However, the shooter does plan to appeal that decision. Meanwhile, final jurors were selected this week for his mother's trial. We spoke with jury consultant Richard Gabriel, who shared with us the process of choosing those jurors.
Well, what's interesting, Laura, is that you have this division of men and women. You've got 11 parents. You've got half the jury that are gun owners or were raised with guns, but that only tells part of the story. It's really the attitude of those gun owners and those people that even aren't gun owners towards the responsibilities of people who own guns. What is the nature of the relationship between the parents? What are the rules regarding guns? And that's where the jury selection becomes really interesting. Several of the people there were asked about whether they've taken gun safety classes. And the truth is that jurors will apply their personal experience to create their own rules and then apply that to the evidence of the case, and then obviously filter that through the interpretation of the law. What's most interesting to me on this case is, as you well know from having tried cases, is that jury selection is really about choosing those 2 or 3 people that are going to be your opinion leaders. There's a doctor on there who's seen gunshot victims and has actually known 2 suicide victims. There's 2 engineers, one of whose husband is a lawyer, and all those people are the strength of the jury. That's who I think either side is looking for to lead the charge for them. So it's a very interesting panel.
And we will be following this throughout the day.
Absolutely, we will. And today we are joined by our legal experts to discuss the previous trial and how evidence and testimony from that trial could impact what we see this morning.
Yes, joining us this morning are attorneys Lillian Diallo and Richard Convertino. Thank you so much, both of you, for joining us. So Lillian, let's begin with you. What can we expect today?
Opening arguments. I think that's going to be so critical because that's a roadmap of a case. It's what we believe the evidence will show. So the prosecutor will say what they believe the evidence will show, as well as the defense. They can't make any summaries. It's just what will it show. And I don't know if they'll get to witnesses. I anticipate they will. And so the first few witnesses are going to be very emotionally based because we're talking about homicide. Well, involuntary manslaughter, which is a lesser, right? But somebody's dead. 4 people are dead, so.
And Richard, yesterday we talked about the fact that things could be moving pretty quickly. The jury selection could be an indicator of that.
Yeah, I think so. I think the opening statements will be fairly straightforward. As Lillian said, they're just an estimation of the facts. It's kind of like an introductory promise that the prosecutor and the defense attorney will make to the jurors, and the prosecutor, both sides will say, I anticipate the evidence to be boom, 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 X, Y, Z, whatever it may be. And then at the end of the case, in the closing arguments, you would anticipate the other side to say, well, you were told in the opening statements that the prosecutor promised this, or the defense attorney promised that, and they didn't produce it. And so it's important to be able to prove exactly what you are promising the jury you're going to prove in the opening statement.
And Lillian, as we mentioned, in December, the shooter was sentenced to life in prison without parole. We were here covering that sentencing. Now, do you think that result of his trial could affect his mother's?
Potentially, but that's why we would hope that the jurors that were picked are as even as they can be and non-biased as they possibly could be. The problem I have is on the shooter's mother's witness list, she listed her son as a witness. Now, I don't know if that was just tactic or an error, but in no world should that person ever testify about what my mom did or didn't do, because understand this, it's like statutory rape. It doesn't matter. Under 16, it doesn't matter. So.
Yeah, and what he says potentially, if he were to take the stand, could be pretty damaging.
She's the mother of the child. We do not sacrifice our children so that we can eat.
Yeah, it's going to be a very interesting case. Now, is there a scenario where there could be the same witnesses from the initial trial of the shooter?
Well, when you say initial trial, there was no trial of the Miller hearing and the sentencing. Yes, there will be.
Yes. Do you think there will be similar or the same?
I do. I think there'll be crossover witnesses. There are 80 potential witnesses that were listed by the prosecution yesterday. And we were talking yesterday. I would anticipate that there'd be nowhere near 80 witnesses that actually are called to testify. It's usually the prosecution overestimates their witness list. There are tactical reasons why a prosecutor will do that. The defense will have to prepare for 80 witnesses that are on the list that are submitted to the prosecution, even though the prosecution may know that they'll call a fraction of that. So there are tactical reasons to do that. One of the things that I anticipate you'll see in this trial is the presentation of witnesses in a primacy and recency manner. So you want to hit off a case after your opening statements with a powerful punch. So you would anticipate the first witness at least, and then the first few witnesses will be the powerful aspect of the emotional part of the case, a part to grip the jurors.
Well, we will be right back. Thank you so much for your insight. We're going to a short break. Good morning, and thank you for joining us for this special coverage of the Jennifer Crumbley trial. I'm Meredith Bruckner.
And I'm Terrence. Friday, all eyes are going to be on that courtroom in Pontiac awaiting those opening statements. Today's trial for Jennifer Crumbley, the mother of the Oxford school shooter who carried out that senseless shooting on November 30th of 2021.
The shooter took the lives of 4 fellow students, injuring others and changing a community forever.
The Oxford school shooter was sentenced to life in prison in December of 2023. We had extensive coverage here.
We did. However, the shooter plans to appeal the decision. He could also refuse to testify in this trial. Now let's have a live look into the courtroom now in Pontiac.
prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of their evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, they are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's disability, race, national origin or ethnicity, gender identity or sexual orientation, or religion, age, or socioeconomic status. There's no fixed set of rules for judging whether you believe a witness, but it may help you think about these questions. Well, was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? When it's time for you to decide the case, you're only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may have not been fully explored. I usually assume that if I don't understand something that a witness is saying, that one of the jurors might be sharing that confusion. So if you can't hear something that is being said or presented, or if you can't see or hear a witness, please raise your hand immediately, all right? During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I'll rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I might have to take care of other matters that have nothing to do with this case. Do not pay attention to those interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it's time for you to decide the case, I'll send you to the jury room for that purpose. You're in 2 different jury rooms right now, but you'll obviously be in one jury room when there's 12 of you deliberating. When it's time for you to decide the case, I'll send you to the jury room for that purpose. Then you should discuss the case amongst yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to the case. You might see one of the lawyers in the hallway and they won't even say good morning to you. There's a reason for that. This means that you may not speak to these individuals, even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you're not allowed to discuss the case. If they continue, leave. Report the incident to court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. Please wear your badges the entire time you're in the courthouse. Okay? During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you must consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it's crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider has to meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom doesn't have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side or another. These restrictions start now and continue until I discharge you from jury service. It's your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries.
We're going to take a quick break here on air, but online coverage continues inside the courtroom. We'll be right back.
Necessary for you to view the scene, the court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you're not discussing the case with someone else, you may not post any information about the case on social media websites or any other matter. If you discover that a juror has violated my instructions, please report it to my staff immediately. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it doesn't distract you from paying attention to all the evidence. Sometimes people are taking notes and they don't hear the next question and answer. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. You must give them to my clerk when you leave each evening. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. At this point, I always like to tell jurors it's possible to replay a witness's testimony upon your request. We have our IT department come up out of our videotape courtroom, so the witness's testimony is being videotaped. I'd like to tell you this caveat. You would be required to hear the entire witness's testimony, not just the portion of interest. You can't all fast forward to a certain part and all yell, aha. Okay? It's the only way it's fair to both sides. If we hear a witness's testimony, we have to hear the entire thing. All right? There's more than one defendant involved in this matter. You should consider only the evidence presented in this defendant's trial. Each is entitled to have his or her case decided on the evidence and the law that applies to him or her. You can see that we've chosen a jury of 17. After you've heard all the evidence in my instructions, we'll draw a line.
Good morning, and thank you for joining us on this special coverage of the Jennifer Crumbley trial.
Yeah, so far the judge laying out the rules of practice and procedure for that courtroom. The trial is happening now. We're going to continue listening in.
You should not influence your decision. If you find the defendant guilty, it is my duty to fix the penalty within the limits provided by law. I'll definitely be giving you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I'll give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you'll go to the jury room to decide on your verdict. A verdict must be unanimous. That means each juror must agree on it, and it must reflect the individual decision of each juror. It's important for you to maintain an open mind and not make a decision about anything in this case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. I think, did everyone fill out a menu for lunch this morning? I guess I didn't ask my staff whether there were any special dietary needs. Those could be accommodated by tomorrow, but maybe not today. So everybody filled that out? All right. Okay, so now we're going to hear openings. And as I said earlier, openings are not evidence. They're how each side sees the case.
Good morning, everybody. I want to introduce you to Hannah St. Juliana, Madison Baldwin, Tate Muir, and Justin Schilling. They died on November the 30th of 2021. They weren't in a car crash. They weren't sick. They were murdered in an act of terror committed by Jennifer Crumbley's 15-year-old son. Jennifer Crumbley didn't pull the trigger that day, but she is responsible for those deaths. These kids were gunned down inside Oxford High School with this gun. It's a 6-hour 9mm handgun purchased 4 days before the shooting by James Crumbley, Jennifer's husband and father of the school shooter. This was a purchase celebrated by Jennifer on Instagram. These are her words. This is her post. Mom and son Dave testing out his new Christmas present. My first time shooting a 9mm. I hit the bullseye. The evidence will prove that by the time this gun was bought, the school shooter was in a downward spiral that had begun months before. The evidence will also show you that Jennifer Crumbley was aware of that. Despite her knowledge of his deteriorating mental crisis, despite her knowledge of his growing social isolation, despite the fact that it is illegal for a 15-year-old to walk into a gun store and walk out with a handgun by himself, this gun was gifted. You will also learn that despite all of that background, this firearm was not secured in a way to prevent her son from gaining access to it. The evidence will also prove to you that even with all of that, on November the 30th, Jennifer Crumbley was still given the opportunity to prevent these murders from ever happening. Instead, she chose to do nothing. This drawing, this math worksheet, was sent to her November the 30th, 2021 at 9:30 in the morning. That's more than 3 hours before the first shot was fired. These writings, that drawing, created by her son. She was sent this by her son's school counselor when he requested an immediate meeting with her at the school that day. He requested that meeting because this drawing, those words, suggest both weapon and injury, even to someone with only limited knowledge of the shooter. Apparently, that raised an alarm with Jennifer Crumbley because she did go to the meeting with her husband, but before she did, she privately communicated her own concern with her husband. This will be admitted in evidence throughout the trial. This is a portion of a Facebook messenger thread from Jennifer to James Crumbley. Jennifer, words in blue. Emergency, November 30th, 2021, 9:35 a.m. Then she sent the picture to James. His response, my God, WTF. And then he wrote back about the vet. He was at their barn, worried about their horse. Jennifer's response, he said he was distraught about last night. And then, I'm very concerned, headed to his school. That's at 10:12 a.m. Yet, despite their private concern, the evidence presented in this trial will show to you that that meeting at the school was nothing like that school counselor or the dean of students who sat in on the meeting had ever experienced before. Those two individuals, even with their limited knowledge of that drawing, had expected the defendant or her husband to take their son home and set an appointment with a mental health professional. But they didn't. You see, you will learn that these kind of meetings, when they occur with parents, can last an hour or longer. This one was abruptly ended by Jennifer Crumbley after just over 11 minutes. And then she left. You see, this drawing alarmed everyone who saw it, including those who only knew the Crumbleys in limited settings, or even to those who had never met their son before. The two people in the world with all of the information, all of the background, to put this drawing into context were James and Jennifer Crumbley. And you will learn that in that meeting, they didn't share any of it. They didn't say anything about the fact that that firearm was identical to the 6-hour 9mm. Identical. They didn't mention how that gun was stored. They didn't mention anything about his increased mental distress. You'll learn that after the meeting when they left, they didn't embrace him. You'll learn that their home is just down the road from the Oxford High School. They didn't stop by the house to look for the gun. You'll learn never once did they ask their son, where's the gun? They did nothing. They didn't do any number of tragically small and easy things that would have prevented all this from happening. One theme will present itself during this trial is just how senseless November 30th was. And that's because of all of the easy, ordinary things for someone to do that nobody did. What I just outlined to you is a snapshot of the evidence that will be presented in this case. You will hear the facts in the evidence from the witnesses. You will hear from between 20 and 25 of those witnesses. You're going to see over 400 exhibits. You're going to hear from witnesses who were in law enforcement. You're going to hear from individuals who work for Oxford High School. You're going to hear from people who knew Jennifer Crumbley in social situations and those who worked with Jennifer Crumbley. You're going to hear from victims in this case as well, those who were inside the school on November the 30th. You're going to learn a little bit about the scope of the investigation. You'll learn that during this trial, the defendant's cell phone, her husband's cell phone, and their son's cell phone were seized. They were all forensically analyzed. Through all of that data received, in addition to data obtained through cell phone towers, social media search warrants, through information received through banking records, GPS pings, from gun ranges, All this information will be presented to you, and you'll be able to obtain a digital footprint of the Crumbley family. And you'll get an idea, you'll get a view into the Crumbley life in the days, the weeks, the months preceding the shooting. You're also going to learn a little bit about the aftermath of the shooting. Specifically, you're going to see a pattern emerge in Jennifer Crumbley after the shooting on November 30th. That pattern will include and show you that she immediately began to downplay and downright lie about her level of knowledge of her son and that weapon and that drawing on November the 30th. This pattern will continue up until the time that she and her husband are found hiding from the police in Detroit. This pattern will show you that her first instinct was to lie, her second was to run. Now, the evidence will show you that she didn't pull the trigger, but she's responsible. But there is no claim that she gifted that firearm to her son knowing he was going to commit the attack. There's no claim that she wanted him to commit the attack. So how can she be held responsible when her son pulled the trigger? And the answer is, she's not charged with murder. She's charged with involuntary manslaughter. You see, murder it's an intentional killing. Involuntary manslaughter, by definition, is unintentional. It's rooted in negligence. You've heard Judge Matthews tell you that every crime is made with something called elements. This is no exception. You're going to learn that involuntary manslaughter is committed when someone's acts or their failures to act or their failures to perform their legal duty were grossly negligent, and that gross negligence was a cause of death. A cause of death, not the cause of death. And that's very important because, as you've heard, and you'll hear it again and again in this trial, that in a case such as this, when somebody else was a cause of death, the person who was grossly negligent can and still will be held responsible. That is, if the person who pulled the trigger, if the shooter in this case, his act was reasonably foreseeable to the defendant. To the defendant, specific to her, not to everybody else in the world, not to a stranger, not to a teacher, but to his mother, one of the two people in the world who raised him, who lived with him for 15 years, one of the two people in the world who had all the information necessary to put that drawing into context. So what's gross negligence? You will learn that it is a willful disregard of danger. Gross negligence is when you could use ordinary care, just ordinary care, to avoid a known danger, and you don't, even though it is apparent that serious injury could occur. And that's what this case is about. It's about Jennifer Crumbley's willful disregard of the danger that she knew of. That's why we're here.
Right, if you're watching with us over the air, we do have to take a quick break. You can watch this uninterrupted on our stream. We'll be right back after this.
Might be culpable. Or who else you think shares some blame. You will learn about the meeting on November the 30th. You may not like the fact that neither the school counselor nor the dean of students searched the school shooter's backpack. That's okay. That's okay. Because that does not mitigate Jennifer Crumbley's culpability. You're going to learn a whole lot about James Crumbley and their son. But James, he's not on trial today. He has another trial in front of another jury. Their son, his case is over. He's already been charged and convicted and sentenced for terrorism causing death and first-degree murder. Today is Jennifer's turn to stand trial. And you will evaluate the evidence as it pertains to her and her own life. We're here because when Jennifer looked at this drawing, she didn't look at it the way a stranger would. When she looked at this drawing, she looked at it knowing the context and the origin. And when someone with that kind of information looks at this, the unimaginable becomes predictable. It becomes reasonably foreseeable. That's why, even though she didn't pull the trigger on November the 30th, She's responsible for those deaths. I ask that during this trial you listen to the testimony, you review the evidence, and you follow the law. If you do that, you will undoubtedly reach a fair and just verdict. If you do that, you will find this defendant guilty as charged. Thank you.
I would, thank you. Your Honor, is it okay if I just move this?
Oh, you can move it anywhere you want. There's a lot of stuff. There's cords and stuff. So
I'm sorry, Sean, can you just help me? I'm going to pull it just forward.
Welcome back, and thank you for joining us for the special coverage of the Jennifer Crumbley trial.
The trial is happening now with opening statements underway. We're going to listen in. We do want you to know that some of the information you hear could be disturbing.
Sorry, Judge, just trying to get this.
okay.
On my way to court today, I blasted Taylor Swift to warm up my voice and calm my nerves. And there was a line in one of her songs that summarized what this case is about. Band-Aids don't stop bullet holes. And that's what this case is about. It's about the prosecution attempting to put a Band-Aid on problems that can't be fixed with a Band-Aid. The prosecution has charged Jennifer Crumbley with involuntary manslaughter in an effort to make the community feel better, in an effort to make people feel like someone is being held responsible, in an effort to send a message to gun owners, and none of those problems will be solved by charging Jennifer Crumbley with involuntary manslaughter. It's the same effect as when your child comes to you with a boo-boo and you give them a Band-Aid that they put on that doesn't take away the pain and can't undo what's happened to them. And in this case, a Band-Aid will never bring back the lives that were lost by Hannah, Justin, Tate, and Madison Baldwin. And the evidence in this case is absolutely horrific. Much of the evidence is going to make you sick and disgusted and scare you, traumatize you, and quite frankly, there's no reason the evidence needs to be shown. Mrs. Crumbley, myself, everyone in this courtroom agrees that on November 30th, 2021, the worst possible thing happened when Ethan Crumbley used a gun and terrorized the Oxford High School. So as you are watching the evidence, I ask you to keep in mind that much of what the prosecution is going to show you is going to alarm you and disgust you and be horrifically sad and tragic, but that evidence is about about the shooter. And in this case, we have agreed to call Jennifer Crumbley's son the shooter because he is the shooter and he is the one, as you will see from the evidence, who was responsible for the tragedy that unfolded on November 30th of 2021. Prior to November 30th, Jennifer Crumbley was the mother to a 15-year-old son, and she did not have it on her radar in any way that there was any mental disturbance, that her son would ever take a gun into a school, that her son would ever shoot people. The evidence at trial is going to show you that Jennifer Crumbley did the best she could as a mother to a child who grew up into a teenager and had no way to know what was going to happen. Jennifer Crumbley raised a son that she took to soccer practice, basketball, bowling. She's the kind of mother who, when a mole on his back changed color, a 1 millimeter mole, she took him to urgent care. She's the kind of mother who's texting her husband, who is at home, working from home, "Where is Ethan? Where is Ethan? Where is Ethan?" at 3:14 in the afternoon, getting texts back saying, "Ethan gets home at 3:16, what's your problem?" And she keeps texting, "Where is he? Where is he?" You will see that if anything, Jennifer Crumbley was a hyper-vigilant mother who cared more about her son than anything in the world. Jennifer Crumbley is not a perfect parent, and we don't claim that she is. But what the evidence is going to show in this case is that the prosecution has very selectively pulled out slivers of evidence from a forest of trees to try to convince you that there was something wrong with Ethan and Jennifer Crumbley, as his mom, should have known. And at the end of the day, these slivers of evidence that are going to be presented to you will have no context and no explanation, and the defense will agree that on their face it looks bad. But like any of you who look back at text messages sent a year ago, they may look bad without context and explanation. And so we would ask that you reserve any judgment on these slivers of evidence until the defense presents evidence itself, and we will be presenting evidence in this case to show the context and what was truly happening on these days that the prosecution is going to try to make you believe something more was happening. By way of example, the prosecution has one day where they claim Ethan needed help and Jennifer Crumbley was out with her horse. James Crumbley was with her at the barn. They had just gotten a new horse. Ethan is 15 years old at home, claiming there's a demon in the house, there's something going on, and the prosecution is going to try to use this one little point in time to convince you that Jennifer Crumbley was somehow neglecting her son. Much of the evidence in this trial is also going to center around James Crumbley, who is not on trial in this case. He has a separate trial, as Mr. Keese told you. You're going to hear evidence that James Crumbley and Ethan Crumbley liked guns. They had 3 guns. 2 guns that were purchased earlier in 2021, and a gun that was purchased at a Black Friday sale the day after Thanksgiving in 2021. You are going to hear evidence that James and Ethan went to the shooting range often, that James was responsible for storing the guns, and to be quite frank, Jennifer Crumbley didn't know anything about guns. Jennifer Crumbley, you will hear evidence, she went to the shooting range one time with James and the shooter, and she went a second time after the gun was bought. She was attempting to find a way to spend time with her son, who had just lost a dog, his friend had moved away from him. She's trying to find a way to connect to him. But on that day, when Jennifer Crumbley went to the shooting range, you will hear evidence that she didn't even know where the gun was or how to put it in the car. She had her husband prepare the gun to take it to the range. He had hid the gun in the bedroom of their home. The gun had a cable lock, a trigger lock in place. James Crumbley had the key to the trigger lock that kept the gun secure. James Crumbley used the trigger lock key, took the cable lock off, put the gun in the back of Miss Crumbley's car. Mrs. Crumbley simply drove to the gun range. You will see video of their experience at the gun range, and you will see that the shooter is the one showing Mrs. Crumbley how to use the gun at the range. And when they're done at the range, the gun was placed back in the back seat of the car, not back seat, but the back of an SUV. And Jennifer Crumbley drove home, and not being responsible for storing the gun and not even knowing where the gun specifically was placed, Jennifer Crumbley left the gun locked in the trunk, the back part of her SUV. And James Crumbley was responsible for getting the gun out, putting the trigger lock back on, storing the gun, and Mrs. Crumbley had nothing to do with that part of what happened. Over the next couple of days, this is right after Thanksgiving, the family is picking out their Christmas tree, talking about Christmas presents. There was certainly some sadness in the shooter's life, but nothing that would have amounted to any reason to believe he's going to shoot people or commit a school shooting. You will hear testimony that on the day of the shooting, Jennifer Crumbley went to work. She is essentially the breadwinner at this time. Mr. Crumbley was in between jobs. He's about to get a job offer. Mrs. Crumbley is trying to keep the household finances up. She's at work, and she finds out through an email and text message that her son has drawn this alarming drawing the prosecution put on the screen. Jennifer freaks out when she sees the drawing. You will see the text messages that show she's urgently texting her husband, emergency, call me now, and she races out of work and goes to the school.
All right, you are watching the first day of the Jennifer Crumbley trial, the mother of the Oxford school shooter.
We're going to take a quick break here on air, but online coverage continues inside the courtroom. We'll be right back.
All in a room together where the shooter explains why he has put together this drawing and what the drawing means. The family and the school talk about how a counselor would be a good idea for the shooter to get into some kind of counseling. The meeting is not nearly as severe as Mrs. Crumbley was initially expecting. Trained professionals at the school who evaluate children represent that the shooter is of no risk to anyone, and they allow him to stay in school. The testimony will show this is not a situation where Jennifer Crumbley refused to take her child from the school. She was provided the option of take him home or leave him here. The shooter struggled when they had online school during COVID. It caused him great anxiety to miss school, and he wanted to stay that day. The school was fine with it. Mrs. Crumbley did leave the school and left the shooter at the school, not knowing he was going to become a shooter within the next few hours. Jennifer Crumbley, the evidence is going to show you, returns to work, and suddenly there is news that there's an open shooter at Oxford. Jennifer Crumbley, it's not even on her radar that her son would be the one with the gun doing anything. Her immediate concern is that her son may be hurt. As she is driving to the school, as fast as she can.
Welcome back, and thank you for joining us for this special coverage of the Jennifer Crumbley trial.
The trial is happening now. We're going to take you back into the courtroom where things are happening as we speak.
Evidence of this, she believes that perhaps her son has done something stupid, like taken the gun and shot it in the air or done something. She knows he's still alive and believes that it's going to be okay. Whatever's happened, they can cross that bridge. A little bit later, there's more conversations, and Mrs. Crumbley becomes concerned that the shooter is actually attempting suicide, and Jennifer Crumbley texts her son, "Ethan, don't do it." It still has not crossed her mind that he would ever shoot another person. Ultimately, Jennifer and James Crumbley are called to the substation where they learn that their son has become a school shooter and has shot people and that there are fatalities. Jennifer Crumbley will tell you she still could not believe that was true and went into a complete state of shock and despair and stress and not knowing realizing her life and everyone's life was going to change. And her initial comments are about how could her son have ruined so many lives that day. Jennifer Crumbley sees her son at the substation, and for the first time when he looks at her, his eyes looked black. And it was a son she did not recognize. Jennifer Crumbley and James Crumbley go back to their house where law enforcement execute a search warrant. Law enforcement takes their cell phones, which the Crumbleys handed over. The Crumbleys have to go and buy burner phones or track phones so they have something to use to be in touch. They begin to realize that there are death threats around their house. People are planning riots around their house, and they cannot be in their home. Jennifer Crumbley and James Crumbley drive to a hotel where they spend the night. They are trying to figure out what is happening, and all Jennifer can think about are the things she believes she can control, like keeping her job, keeping health insurance, figuring out money, figuring out lawyers, and trying to digest what has just absolutely tragically unfolded. In the days following the event, while the prosecution says the evidence will show Jennifer Crumbley is lying, Jennifer Crumbley is truthfully telling the world she had no idea and finding out that she is about to be charged in this Band-Aid effort by the prosecution with involuntary manslaughter. Jennifer and James Crumbley go to the bank. They're advised by friends and family, and you will hear testimony that their money could all be taken out of their accounts, and they know they need money to be able to live and hire lawyers and figure out what to do. They withdraw all of the money from their bank account. The burner phones they're using, they can't get access to any of their accounts because of this two-part authentication you now have to do. So they go to the Metro PCS store where they buy new telephones that they can actually use to access their social media, their accounts, their contacts, and they end up with multiple cell phones. After that, they work to find lawyers. They don't know what to do. They don't understand what they're being charged with. They're under the stress of knowing their son is gone, and life will never be the same, undoubtedly. And on Friday, December 3rd, the Crumbleys find out when a press conference is held that they are being charged with 4 counts of involuntary manslaughter.
All right, this is the first day of the Jennifer Crumbley trial, mother of the Oxford High School shooter.
We're going to take a quick break here on air, but online coverage continues inside the courtroom. We'll be right back.
At his art studio until they know where to go and what to do. They make plans to turn themselves into the court on Saturday morning, because remember, this is late in the day Friday. Saturday morning at 8:30 when the court opens up and does weekend arraignments. And overnight, the prosecutor's office, the sheriff's department, the fugitive apprehension team, the U.S. Marshals have a statewide search claiming that James Crumbley and Jennifer Crumbley are on the lam, they are running, they are fleeing, they are trying to avoid charges, and it couldn't be any further from the truth. They are at their friend's art studio, they are waiting for instructions, and they are waiting to turn themselves in first thing Saturday morning when arraignments take place at the court. James and Jennifer Crumbley are sleeping on a mattress in the middle of the night. When police locate them, you will hear evidence. They're not really hiding. They're standing outside their car, their vehicle, smoking cigarettes. They're standing outside their car, talking on the telephone. They're communicating with various people they know. There's absolutely no evidence to suggest that they're fleeing. You will see body camera footage where when police come into the art studio to find them dead asleep on this mattress, they are cooperative, they are taken into custody, and they are arrested. The prosecution has grossly misconstrued facts in this case, and I ask that you wait to make any judgment until all of the evidence has been presented and you have seen every detail.
CBS Deals, powered by Shopify.
This is the Sun Joe. First of all, I just want to show you, it's a portable propane generator. The battery's right here, okay?
Boom. Okay.
It is the only generator that has a spot for the propane right on board. Has a retractable handle, so I can wheel this outside my house. I don't need to grab my husband. I don't need help. Lightweight. Propane is so much easier than storing gasoline, for example. Yeah. Most people who have a grill have a propane tank in their garage. So a 20-pound propane tank is going to give you about 9 hours of power. So if we're in a blackout situation, wheel this outside and then plug it. It comes with the extension cord, so you plug it in right up here.
Is it really that easy?
Press on. It's so easy. You wheel it around.
Oh, you're right.
You press the on button, plug it into the refrigerator, plug it into the heater, whatever you need to power. The price is incredible. $399.99, 56% off.
To get this deal and more, scan the QR code at the top of your screen or head to cbsdeals.com to start shopping now.
Welcome back, and thank you for joining us for the special coverage of the Jennifer Crumbley trial.
It's happening right now. Let's listen in.
Schools managing missing assignments by her son in his grades. The school never told her about times the shooter was trying to sleep in class, about a test he had failed, about the shooter being called to the office. She was never informed. You will hear testimony. She was never informed that the shooter wrote an autobiographical get-to-know-you poster where he says he feels terrible and his family's a mistake. The school never notified Mrs. Crumbley of this. You will hear testimony that the school never notified Mrs. Crumbley that the shooter was having a, quote, rough time when he spoke to the school counselor. You will hear testimony that the school never notified Ms. Crumbley that previous work found in the shooter's files showed that it leaned a little bit towards the violent side. You will hear testimony that the school never told Mrs. Crumbley about an index card the shooter wrote in class that had odd responses with a drawing of a loaded gun magazine and a person holding it out. You will hear that Mrs. Crumbley was never told much of the information the school had. And so when the prosecution is urging you not to assign fault to anyone else, at the end of the day, we ask that you pay attention to the evidence that Mrs. Crumbley knew. And quite frankly, when you evaluate that evidence and know what she knew and what she didn't know, and learn the context behind the slivers of evidence this prosecution's presenting, you will see that this was absolutely not foreseeable, this was absolutely not expected, and I am going to ask that you find Jennifer Crumbley not guilty of involuntary manslaughter.
Thank you, Ms. Smith. Will you tell me who the first witness is? I'm going to ask them to give me a break. I knew I shouldn't have given them a call. Okay, so you take like a 10-minute break, and then we'll hear the first witness. Okay.
All right, for the jury.
All right.
They go differently.
All right, we have to take a quick break. We are watching the first day of the trial for Jennifer Crumbley, the mother of the Oxford school shooter.
We'll be right back.
You may be seated. Who's the first witness?
They're not.
Okay. She's going to see it.
Your Honor, I need to run to the bathroom. Do you need to go to the bathroom? She's okay unless the deputies need. I think they need to take her downstairs.
I don't think you have to take her downstairs at every break, do you? I don't know.
It just gives her a chance to also use the bathroom, so
Oh, no,
we
I
don't have
want
to interrupt as many times.
Oh, yeah, I want her to be comfortable, so whatever she needs.
She does not need to use the restroom.
Okay, it's up to you.
We'll just take her downstairs and just use it.
You have a taser and gun, so I'm not going to.
It's a lot of paperwork.
Your Honor, what time are we planning to be back?
Just like by 5 o'clock.
Okay, thank you.
Yeah,
I'll be back.
I'd like to go quickly, so whatever you guys want to do.
All right. You may be seated.
We're coming back. Welcome back. Thank you for joining us for this special coverage of the Jennifer Crumbley trial.
Yes, we are here listening in as that trial continues. We are going to go back to the courtroom in just a bit, but right now we're just waiting for things to get back started.
Yes, and with us is Richard Convertino, attorney. Thank you so much for being here
Thank you.
This morning. So just after the opening statements, what's your initial impression of how this is getting underway?
Well, just hearing the defense opening statement, I thought that was, using the common vernacular, bullshit. It was among the worst opening statements I've ever heard.
Wow.
I've heard hundreds, been in courtrooms all over the country. It was discombobulated. I think it was not something that's going to grip a jury, and what it's going to do is, I think, turn off the jury in this case. One of the things that, I mean the defense in this case, anytime you start off in your opening statement, unless you're Travis Kelce, with a discussion about Taylor Swift, I think you have trouble. So that was ridiculous. Her intimation that this was a minor case, a boo-boo or a Band-Aid case, was ridiculous. The empty chair defense, blaming the husband, James, and not only James, and then blaming the school district for ultimate responsibility. So, yeah, very unimpressed. The prosecution was yeoman-like, went through the facts that they'll prove, was strong, it was concise and clear, and I think the dichotomy between the two was overwhelming.
Yeah, it seems to be a very strong start from the prosecution. Of course, things are just getting started, so we still have more to get to. Lillian, any thoughts from you really quickly?
The prosecutor was prepared, as you can see, right? The prosecutor has. This is what we're going to show, gross negligence, you should have known. Mom's attorney did the best she could, I think, right, under the circumstances. You know, this is a little bit different, though, than a Band-Aid analogy. To me, the analogy should have been, well, no. Well, should have been, well, your kid is 16, you're giving your kid the keys to your car, and your kid goes out and has a wreck and kills somebody. Should you be responsible? But unfortunately, in this case, you gave your kid booze and put him behind the wheel. And you absolutely would have some culpability. Let's see what the jury says.
Right, and also we can't neglect the fact that the magnitude of this case is undeniable. Those students lost their lives. I know that they are trying to present this separate from what happened with the shooter, but it did seem to be a bit of a strange approach from the defense.
It did, absolutely. Well, we are going on a short break. You can still tune in online for continuing coverage of the case. Sorry if I cut out early.
Thank you for joining us for this special coverage of the trial of Jennifer Crumbley, the mother of the Oxford school shooter.
Yes, now as the courtroom is currently on break, we're going to bring back attorneys Lillian Diallo and Richard Convertino to continue the conversation over what we're seeing, what we can expect today. Lillian, what's next?
We start with the opening witnesses, right? I don't know if they're going to have the identifiers of the bodies. You know, this is the person, because there are 4 separate bodies in this case, right? Someone has to say, this is this person, this is this person. They may stipulate to that, to not put the parents through it, or whoever's going to identify the person as the person in this case. But let me just say, prosecution is off and running.
Yeah, and based off what we're seeing so far, the prosecution really did have a seemingly stronger start. Would you agree, Richard?
Oh, infinitely stronger. Yeah, exponentially. It was, as I mentioned, straightforward, clear, concise, what the evidence will show. It went seriatim from this to this to this to this. The key points in the prosecution's opening, you know, it started out when that primacy recency theory that you hit hard. It started out with the photographs of the 4 victims, which I'm sure had an impact on a jury. The theme was, despite her knowledge, the prosecutor said that several times, despite her knowledge, she did this, this, and this, to make the jury aware that despite of her ostensible awareness of the underlying facts, she was unconcerned about the ultimate consequences. So she had the knowledge, and she proceeded during the course of her actions to ignore that, and the ultimate consequences occurred, which was rational and reasonable based upon her actions. So he hit that hard. The other thing that the prosecutor hit hard was the statement that this could have been prevented. He mentioned that several times. Could have been prevented with ordinary care, and that's very critical when it comes to proving the elements of the case beyond a reasonable doubt. Someone with limited knowledge of the shooter was concerned. That was his third theme, and that was the school district. The school district didn't know all that the mother knew, and they still were incredibly concerned enough to call this meeting, which was considered an emergency meeting. The father said, or the mother said, this is an emergency to the father, James, and they went to the school. The other thing that the prosecutor is going to show based upon his opening statement was that these meetings that occur with somebody's son or daughter at the high school go a particular way, and this one was ended abruptly. So I'm anticipating they'll have people from the school come in and say, typically when we have these concerns about a student, that meeting lasts at least an hour. We go through all these topics, but this one wasn't the same. This one was abruptly canceled by the mother. That was another theme. And thirdly, or lastly, I should say, the father, the mother, Jennifer, is putting the father on trial, the empty chair defense. She's saying, you know, I'm a horrible mother, maybe, but I'm not a despicable mother. This dude, you know, who's not here right now, he's the, you know, the jagoff who bought the gun. He's the guy who ignored all this evidence, and he's the one who should be ultimately, you know, tried and convicted, not the mother, not, you know, the poor boohoo mother.
And that's something we had foreshadowed even with the Miller hearing, wondering if
Right.
we would see that take place.
Throwing under the bus. Do
Yeah.
you think the order of the trials could come in one or the other's favor, the mother and father?
Well,
does it work to her favor that she's coming first?
yes, absolutely. When you come first, it's a fresh eye, right? So look, this to me is so simple. This is your son. You birthed your son. You have a duty to your son, to your child. Your duties stop when they get a certain age. He's not that age. Mom is taking the young person, shooting, and bragging about it. This is about privilege, entitlement. That child should never have been left at that school by those parents that day. I dare say, had it have been me and my kid in that office, we all would have been put out of that school. And the only person that could have possibly have been killed would have been me, right? Or as they shot us in our back if we didn't want to leave that school. It's really outrageous.
Your thoughts on the fact that the defense is, you know, obviously it's their job to try to paint her in a better light, but We've seen some of this evidence already presented, even though there has been a trial like we talked about, but we've seen so much about what the parents knew, how they neglected the shooter in certain ways. Your thoughts on how they're kind of changing the narrative in a way?
Well, remember, one of the things that the prosecutor said that they were going to prove was, the phrase he used was a digital footprint of the mother. And so that would include the emails, the text messages, the phone records. The prosecutor said you were going to hear from witnesses, including the neighbors, the coworkers, and so all of those people and the records themselves are going to show and paint this person, this defendant, Jennifer Crumbley, in a manner that's going to essentially bury her. Her character, even though character evidence is not admissible, that's exactly what this is going to be, character evidence of her bad character and her propensity to act or not to act in a certain circumstance. And that is going to certainly overwhelm the defense's theory that she's, this is a case that only needed a Band-Aid. As you pointed out during one of the breaks, the defense used the term sliver of evidence, which is
she continues to use this word,
is abhorrent.
Sliver of evidence. Isn't that downplaying
it's horrible.
What they're bringing forward?
You have seven victims who are seriously injured and 4 who are dead. There's no evidence that's a sliver in this case. I mean, the huge mistake I think that was made right off the bat was not to front out this case to the jury and be honest with the jury. These are the facts. This is what she did, but despite that, it doesn't rise to wanton criminal negligence. She could have been, she was a horrible mother. She was a terrible mother, and she had her own issues, and because of that, she may not have been as attentive, but it didn't rise to criminal negligence. That would be the defense.
She didn't use this language. She really pinned the blame on the shooter from the get-go. This was
and the father.
Yes.
Yeah,
and
like
the
no
father.
accountability at all.
Right.
Consistent with what we've seen through this whole case. If one adult, and they're supposed to be adults, had taken some kind of responsibility, we would not sit here right now to talk about this horrible case, right? Accountability, you sent the boy something the day before saying, hey, don't get caught. Yeah.
Well, it seems like we are seeing some activity back in the courtroom. Not sure yet if they are commencing, but we will go back once they do. So just, again, coming back to this, it was interesting when we were tuning into the defense opening arguments. You were saying, I think she's lining this up for Jennifer Crumbley to testify.
Oh, I do.
Will this happen?
I do. You remember part of the opening statement that she was presenting to the jury was that the mother was, she had no clue what was going on. She didn't realize, she didn't believe, she didn't think. When she looked at his eyes, they were black. She was surprised. Now, who can testify to what the mother believed the shooter's eyes looked like? Only the mother. So I do think that she is telling the jury in a roundabout way that the mother will testify. That's about, you have a person testify, the mother, a defendant testifies is a very, very, very dangerous thing for both the defense and the prosecution. Prosecution has to knock them out because the jury is willing, I think, more so to give the benefit of the doubt to a defendant who testifies. And if she testifies in a sympathetic way, it will be certainly harmful to the prosecution's case.
Okay. Well, we will see. We will see as witnesses begin to take the stand. I understand that's sort of the next step here.
Yes.
How many witnesses do we know at this point?
I think I heard him pare it down in the 40s.
I think he said 25.
25
25 plus.
It started with 80,
Yes.
and then they got it down.
And that's good. But let me just say this. When you say the shooter's eyes were black, and what is that all about? What are you saying? It's offensive on so many different levels. It's only about you. You don't have any cognizance about what's around you. You're here. You can't see here. You can't see here. It's all about you. So his eyes are black. What does that mean? I don't care what it means. You're his mother. Whether they're red, blue, or orange, it is your responsibility to take care of a child that you knew had a problem, but you were too wrapped up in who you were to figure it out. But you did get him a gun and take him to an eye doctor.
That was a really interesting statement. That struck me as well.
Me too.
Because she said she saw his eyes were black and it was a son she didn't recognize. It's almost like it wasn't her son.
Yeah,
We're
she was
disconnecting
unaware
her from this case.
Yeah, she was unaware of his mental illness that led up to that, you know.
And not to keep double dipping in the Miller hearing, but we know that in that time, he had said that he had repeatedly gone to them saying, please help me, get me some help. So it's going to be interesting to see how they try to defend that if that comes up.
They're firing back.
Yeah.
He had a
After the
mole
Miller
on his
hearing.
back that she took care of too. Remember
With a
that?
Band-Aid, yes.
That's true.
Oh,
That
yes,
is true.
yes. And just talk about, again, the term of this, the Band-Aid approach. She even used the term boo-boo. I mean, how offensive is this?
Don't force errors if you don't have to. You have to talk to the jury and be credible, right? When you give your opening, you can't act as if you are hiding something or minimizing. There are 4 dead people here. Whether you take a Band-Aid and put it on or off, this is not about a Band-Aid. This is about someone that had some kind of behavioral health issues. You are a parent, so it's child abuse for you not to take care of them, right? This is not a boo-boo. This is a murder, a manslaughter case, and the gift to you is not a murder that you're being tried for. You can't minimize this case like that, right? A sliver of evidence, this is what the evidence is going to show, and I'll come back and talk to you at the end, right? But don't go in there making the jury feel a certain kind of way already about you.
Yeah, and we are seeing some activity again in the courtroom, so we're going to go back now to that live picture for you. Some of the information that you hear is disturbing. We're going to listen in now.
8, and we have no objection to those. 7 we do, and I believe that's already been a ruling by the court. I just have to continue my objection.
Okay, so this was ruled on previously?
Yes.
Correct.
Okay. All right, so 7 was already admitted in the written opinion?
It was, Judge.
Okay.
I just have to maintain my objection.
Sure.
Thank you.
Okay,
For the record, that is a portion of the Oxford High School surveillance footage.
correct. Okay.
And for the record, we just think it's not necessary.
All right. Could you step forward? It's a little cozy in here, I apologize. Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, so help you God?
Yes.
Okay, you can be seated. And then, could you state your name for the record and spell your first and last name?
My name is Molly Darnell, Molly Darnell.
Go ahead, prosecutor.
Good morning.
Good morning.
I'm going to call you Molly. I assume that's okay.
That's okay.
Okay. Molly, can you tell the jury what your profession is?
I'm an educator.
And where is it? Are you a teacher?
I am a teacher.
Okay. And who is your employer?
Oxford Schools.
Okay. How long have you been in? How long have you worked for Oxford Schools?
I started working for Oxford in the fall of '98.
Okay. Would that be your entire career?
That is my entire career.
Okay. And you stayed in that one school district?
Correct.
Okay. Your current position is what?
I work for Oxford Virtual Academy.
All right. And when did you begin that position?
I began that position 18 months ago.
Okay. I'm going to take you back to November 30th of 2021. Can you tell the jury what your position was at that time?
At that time in Oxford, I was under teacher contract, but I was the ELA coach and the International Baccalaureate Coordinator. So I worked specifically with curriculum and teachers, like instructional moves in the classroom.
Okay.
So ELA, what's ELA?
I'm sorry, thank you. It's English Language Arts.
All right. Thanks, Judge. So how much contact did you have with students compared to teachers at that point?
I would say minimal in comparison to teachers.
All right. And you did, though, spend some time in the classroom in your career?
Absolutely, yes. I spent the majority of my career in the classroom.
Okay. So on that day, what was your typical day like around that time in that position?
So in that position, I would work with building kind of professional development opportunities, or I was working with teachers individually. On that day in particular, I was working with the media specialist and my other coaching colleagues, my other instructional coaching colleagues, on building professional development for the next day.
All right. Did you have a classroom?
I had an office that I shared with 2 other individuals, and it was like half a classroom, but it was in the educational hallway.
So it was a classroom made into 2 offices?
Mm-hmm.
Okay. Can you tell the jury when classes began that morning? What was the schedule of the day? Began and end, if you remember.
So you're referring to like the start day of the school
Yes.
day? The school day started around 7:30 and ended around 3 o'clock.
And I know Oxford had a different, they didn't have exactly the same schedule every day.
Yeah, we had a rotating 7, so we met 6 days a week. We met 6 classes a day. But we had 7 classes, so the students only were there in every single class for 4 hours a week.
Can you tell the jury what passing time is?
Passing time was about, Oxford's one of the larger high schools in the state. It's the largest single-floor high school in the state, I think, at the time.
Do you know how many students?
Off the top of my head, I don't.
Okay.
And so there were about 8 minutes between passing times, or between passing.
All right. November 30th, 2021, were there any COVID protocols still in place?
Yes, we were still in masks at that point in time, yes.
And were lockers being used?
Lockers were not being used.
Okay, so how were the kids getting their things from class to classroom?
They were carrying book bags. Yep.
I'm going to show you what's been marked as people's proposed Exhibit 5. I don't believe there's an objection, Your Honor.
That's correct, Your Honor.
When I say I'm going to show you, it's going to be on this screen and this screen. Okay. Molly, what is that?
That's the layout of the high school.
All right, so that's a map of the school.
Correct.
Okay. And can you tell me where your classroom/office was?
So if you're looking at that yellow portion, I am, thank you. I am where you see 222, and then there's 226. I'm that little sliver right in between there, and that was 224.
Okay, Mark's going to show you
Yep.
on the map. He's
Correct.
not letting me have access to the clicker for the
Yeah.
trial, so relying on him. Okay, so is that your classroom?
Yes, that like little sliver where you can see, it looks like a bunch of names are written in there.
Mm-hmm.
That was the room that I was in, yes.
Okay. And I'm going to take you to around the time of about 12:50.
Okay.
What were you doing during that time?
So on that day, the year prior, I was in the classroom, and I had a student who popped by around that time just to check in and wanted to chat. I had a chat with her. There was, I believe it was the beginning of passing that she stopped by. We had a quick little chat.
Was that conversation in your
It was in the office.
or in the hallway?
Yep, it was in the office.
Was the door open or closed?
The door was open.
Okay.
We had a little chat. She left. I was alone in the office. And passing was still happening, so I moved to my my desk space just to check some emails, check on a couple of things.
Okay. So your desk was in the back of the classroom?
Yeah, it was towards the back side, yes.
Facing the door?
Facing the door.
Okay.
Correct.
And did you have a practice of what you did during passing time?
So sometimes I would go out in the hall and check, like just to check and see what was going on, or I might chat with a teacher or two. I didn't on that day because it was towards the end of passing time, and so I knew things would be wrapping up and teachers would be heading back to their classes.
Okay. So at some point, did you see or hear anything unusual?
Yeah, so all of a sudden I could hear a commotion in the hallway, and I looked up from my laptop, and I see a bunch of kids running through the hallway. It was a pack of kids, and they were moving pretty quickly, and there was a commotion around it. I couldn't tell if it was like excited, that it was like higher pitched though. And it was almost like some of the kids' hands were extended, like they were trying to move really quickly.
Okay, for the record, you have your hands, both your hands up,
Yep.
shoulder distance. Okay, and that seemed unusual to you?
It did.
Okay, did it seem unusual because it was at the end of passing time, or just because of the movement and the sound?
It was the movement, it was the sound, it was the large bulk of kids that were moving.
What did you do?
I exited my office. I believe that there was possibly a fight. So I run out of my office. I'm about midway through where 222 is. And I see all those kids exiting out of door 4. So I know there's not a fight.
So if you look at the map, you come out of your classroom and you look down the hallway and they're all running out of the school?
Yeah, on a door 4.
Okay. And that was unusual?
Mm-hmm.
Is that correct?
Yes, I had never seen that before.
All right. And then what happened?
I paused for a second because I'm thinking, like, well, what's going on, right? I don't know what's happening. I head back into my office space. The hallway is completely clear. And I walk into my office and I'm like, all right, what could possibly be happening in this moment?
Was it unusual for the hallway to be completely clear?
I don't believe the bell had rung yet, so that was unusual.
Okay. And so what did you do?
It was in pausing, trying to gather what to do next. I heard 3 things pretty quickly together, like so quickly together that I have a hard time distinguishing what came first and what came last. But there were the sounds of 3 loud pops that I could have mistaken for lockers closing if we were using lockers.
Okay. So when you heard the 3 pops, what did you think that sound was?
Well, again, there was that. There was doors started slamming. I could hear boom, 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 and then the principal at the time, Steve Wolf, came over the PA and said, "We're heading into lockdown. This is not a drill."
And how long had you known Steve?
A couple years at that point in time.
Okay. Did his voice sound panicked?
His voice sounded, it was urgent, but you could tell he was tempering any, panic.
So was that before the loud pops or after, if you can remember?
Honestly, I cannot remember.
Okay. When you heard this, was your door open or closed?
My door, when I came back in, I pulled it, but it didn't shut, so it was open a couple inches.
Okay. So what did you do?
At that point in time, I moved to shut my door.
Okay. Did you, after the pop, did you smell anything?
No.
Did you see anything?
No.
All right. Then you tell the jury what happened when you turned around and headed to the door.
So I walked to the door. I immediately pull it shut. To the left of my door, so my door was here, and there was a glass part, floor to ceiling glass. And then right here was a night lock system.
Can you tell the jury what a night lock system is?
So a night lock is a simple gadget that goes into the door, that goes into the floor, so that if the door were unlocked, it's like a second security measure. If the door was not locked, or even if it was, someone can't get in. So if the glass is shut out, even if they're trying to undo the door, they can't open the door.
And when did you learn about night locks?
Maybe 4 years prior.
Okay. Did you do that? Well, why did you install the night lock?
Well, one, I was directed that we're in lockdown, okay. Right? So as soon as I knew that we're in lockdown, that's what you do.
Were you able to install the night lock?
So I grabbed the night lock, I undid the piece, grabbed it, and looked down at it. So I also, some of the doors have different installs, whether the door goes, in or out from the room. And so I looked at it to see, just to remind myself which one. because the other office that I have at the middle school, or had at the middle school at the time, had a different.
At this point, Molly, the door is shut or closed?
The door is shut.
Are you facing the door or facing away?
I'm facing the door, so I'm close enough to that wall because I had just grabbed it.
Do you know about what the distance was between you and that door?
Not even a foot.
Okay. And then what happened?
I look at it, and out of my peripheral vision, I can see some sort of movement. And so I look up, and I see someone dressed in dark, oversized clothing.
And you're looking through that glass pane
next
to your door. Okay.
They have the mask on, a hat, glasses, and a hood. And I lock eyes with them.
Had you ever seen that person before?
I had not, no.
Did you know if it was a student or is that a no?
I did not know if it was a student.
All right. And you said you locked eyes?
I locked eyes. And then instantly I see some movement. And so I look down and I realize he's raising a gun to me.
Okay. Can you describe?
Yeah. The gun was black, and I remember thinking, as he's raising the gun to me, that there was no orange tip. I'd heard prior that BB guns have an orange tip.
When you say he was raising the gun, can you explain what that looked like? Was it one arm or two arms?
Well, I just saw the one starting to move up. I saw the gun, and I moved.
Which way did you move?
I moved away from the glass partition, away from the door, toward back into the room.
Okay. You just described you saw something in your peripheral vision. You looked up. You locked eyes.
I locked eyes. He didn't hesitate.
Okay. About how long was that from the time you saw the peripheral vision and then the gun was raised?
A second.
Okay.
If that.
When you locked eyes with this individual, what did you see?
I'm sorry, can you repeat that question?
Describe that for me.
I lock eyes with him, and I instantly see that movement. And I jump to the side.
Okay. What happened after you jumped to the side?
As I jump,
and was the night? Did you ever get the night lock installed at that point?
The night lock is not installed at this point.
Okay.
So when I move, I kind of jump and turn my body this way at the same time.
Okay, and for the record, you're motioning, turning your shoulders to the right.
To the right. Mm-hmm. And I feel like my left shoulder moves back a bit, and I feel a burn like hot water had stung me.
Where did you feel that?
In my arm.
Which arm?
In my left arm.
Okay. And you're pointing to your right below your shoulder?
Yep.
Okay. And are you standing up? Are you sitting down?
I'm standing up at this point in time. I feel that hot burn go through my arm, and I turn back. There was a window in the back of my room that leads out to the courtyard, and I see a bullet hole.
Okay, I'm going to show you on the screen. It's been marked as People's Proposed Exhibit 6.
Any objection? 6 is admitted.
What is that, Molly?
That's the office that I shared.
Okay, and that, can you just describe where the desk is, what you just described, and point that out? You said you turned around to the back of the classroom.
Yep, so you can see on that window exiting, there's a white mark.
Right there?
Yep, that would be the bullet hole.
Is that what you noticed when you turned around?
That is what I noticed when I turned around, correct.
Okay. At this point, what were you thinking?
A BB gun can't do that. It seems like really silly.
What seems silly?
That I couldn't wrap my head around what was happening.
I mean, after you felt the warmth and you still were thinking it might be a BB gun?
Yeah.
Okay. So what did you do? Was the night lock installed at this point?
The night lock's not installed at this point, and the only thing I'm thinking is I have to barricade this door. Like there was instinct that kicked in. So what you can't see is right around that corner there was this huge filing cabinet.
And I think if we can point to around that corner to.
Yeah.
Okay.
And so I grab it because I'm afraid to go back towards the door at this point in time. And I try to move it, thinking maybe I can pull it out enough and push it. And it was just too heavy for me. So that rolling cart was sitting next to it. That's when I pulled out the rolling cart and I take that back. I didn't do that yet.
Take your time.
I crawled down on my hands and knees and I put that night lock in. And then I moved for the roll. I was like, I just have to keep barricading. And so I grabbed the rolling cart.
Is the object in the...
Yeah, you can see it's the little red object on the rolling cart. Yep.
Oh, that's the night lock.
Yes.
Okay, but it's sitting on that's the rolling cart, right?
Correct.
Okay. All right, and were you able to put it in front of the door?
I was able to put the rolling cart in front of the door, correct.
Okay, and then what did you do?
Then the only thing I can think of is he's going to come back and finish what he wanted to do.
Could you hear anything else in the hallway?
At this point, I'm not hearing anything.
Okay. And so what did you do?
So I go back to that large cabinet because I know if I'm anywhere in the back of this room, he can see. So I need to hide in this front corner. And so I pull that large filing cabinet back just enough to crawl behind it so that if he comes to that window, he can't see where I'm at.
So the way the classrooms are is you have to be at a certain angle to see certain parts of the room from the hallway, correct?
Correct.
Okay. And you said you moved to that corner behind because what?
Because I didn't want him to see where I was at.
Okay. Once you were behind the cabinet, were you sitting?
I was crouched down. I was trying to make myself as small as possible. Right? I got really low. I was on my bottom, crouched as close together physically as I could make myself.
Okay. What did you do next?
I had texted my husband, "I love you, active shooter." And then I started feeling blood dripping down my arm.
And what did you do? At this point, had you registered that you had been shot?
I don't think I was registering that I was shot. I just knew that I was bleeding.
Okay. What did you do?
I had a cardigan on that day, and so you can see in the photo there's this red little bag on the side, on the right side of the wall. Those are medical response bags that we keep in every room. So if someone's bleeding or if a tourniquet's needed, they're in there, but I was too afraid to go back and grab it. So at that point I knew I needed to put a tourniquet on. I knew I was bleeding. I removed my cardigan and I used one of the sleeves of the arm, wrapped it up on top and pulled with one arm and my teeth with the other to tighten it.
And Molly, how many inches down was that wound?
It sits right here.
Okay. And you brought a cardigan so that you could show the jury what that looks like so they know exactly where you were hit?
Yep.
Go ahead.
I don't know if you can all see okay, but...
You can step down if you
Okay.
feel comfortable with it.
Can everyone see? I can see it, yeah.
So you can see it kind of sits in the back. So when I was turned, that was the entrance and the exit.
And there's two holes there.
Yep, so it entered here and exited here. And the space in between, the heat of the bullet cauterized.
The skin?
The skin.
Okay. You can sit back down. You put the tourniquet where on your shoulder?
I put it above the wound.
Okay. How do you know how to do that?
We go through trainings once a year regarding what to do,
Okay.
in a situation.
What happened next?
I put the tourniquet on, and I'm in my head. I'm thinking, okay, what do I do next? What's like the next move here? And my daughter texts me. She didn't go to Oxford High School, but she went to a neighboring school district. And they had heard through social media that there was a shooting at Oxford High School. And so she sent me a message and just said, Mom, are you okay? And I responded to her that I love you. I'm sheltered in place. And I'm fine.
You didn't tell her you were hit?
I did not tell her I was shot, no.
Molly, I want to go back, and I'm so sorry. When the shooter raised his hand, what were your what did you notice about, if you noticed anything about his stance, or you said you locked eyes?
Yeah, his feet were set about hip distance apart, and that's, he was, and his shoulders were like he was square, right? He was square.
How long were you in that classroom?
I was in there for about 20 minutes.
Were you communicating with anyone else in the school, or law enforcement or administration?
No, there were a couple teachers. My hallway had a text thread, and that was not active. There was nobody texting on that. But another part of the building where the English Language Arts Department is at, they were texting. And one of them said, I heard there was a shooter. And I responded that I saw one.
Did you respond that I've been shot?
I did not.
Why is that?
I think I didn't want to create panic. I wanted to make sure that people knew it was serious, but there's no, I'm okay.
Okay. At this point, did you have any idea where the shooter was, if anyone else had been hurt? What were you hearing? Anything?
Nothing. And it was absolute silence for a long time. And then I started to hear a volume of footsteps. And I thought, they must be evacuating a classroom. And so when that shift occurred, I texted the teacher next door and I said, hey, you're the only one that knows right now, but I've been shot. I hope I'm the only one.
How long was that? How long were you in the room then?
At that point, it was probably 18 minutes.
Okay. At some point, did somebody ask you to leave the classroom?
Yes. So the teacher next door was like, oh my gosh, I'm calling the office. There was another teacher in the room with her who texted administration.
Okay. And at some point, did somebody come to the door?
Yep. So the text from administration, Kurt Noose was at my door within maybe 2 minutes. Time's hard on that. And he was knocking, Molly, are you in there? I've known Kurt Noose since they started in Oxford. I did not trust that was him at my door.
What were you afraid that it was?
I don't know. Everything that I knew to be reality wasn't.
Okay. So did you answer him back, or did you open the door, or did you just remain silent?
I said, I'm in here, and he said, are you okay? I don't remember how I responded. It was within a second or two that But then there were police at the door, and they were like, "Are you in here? Are you injured?" I said, "Yes." And then I think I said, "Do you want me to?" It was clear that they wanted me to, like, they were there for me.
And they couldn't just open the door.
They can't just open that door. That night lock prevents them from getting in the door.
And Molly, if you know, how would you get into that room if someone doesn't remove the night lock from the inside? Is there a way?
So I know there's a special tool to use, but you'd have to take everything off that door, and that's all steel.
So the frame, actually?
Yes.
Okay. And so they were asking you to remove the night lock. Did you do that?
I said, "Do you want me to remove the night lock?" And they said, "Yes, remove the night lock." And then I said, "Do you want me to open the door?" And they said, "Yes, open the door." And I'm down on the ground while I'm doing all of this. Like, I'm removing the night lock, and I'm opening up the door from my knees. And they, like, scoop me up. And I can see the two officers that scoop me up, but I can see Kurt standing there against the lockers. And I can see 4 cops with guns.
Did you see any students?
I did not see any students, no.
Okay, Molly, I'm going to play a surveillance, which is marked People's Exhibit 7, which I know there is an objection to, but the judge has previously ruled. Just to let the jury know, you're not going to see any victims in this, except for Molly, and nor are you going to see any students.
Can everybody see?
While he's getting that on the monitor, when you say you saw 2 officers with guns, how far away were they? And were they in the same direction?
They were. When they scooped me up, the 2 that scooped me
I'll
up.
just have you look here.
Yep.
Is that the hallway?
That's the hallway.
Okay.
So you can see there's multiple around. So it wasn't just the 2.
Where's your classroom in this photo?
It's farther down, right? Okay. So you can see, like they're going inwards towards the classroom.
Okay.
It looks like that's an officer there.
Okay.
So I knew that they were officers based on the vests that they were wearing. Okay. And so they were just around, right, as well, like securing the area, I suppose.
All right. Can you press play? Is that you, Molly?
That is me.
At this point, are you hearing anything in the building?
No. Everything is silent, like almost like it's so, like echoey. It's so silent.
Okay, now you can see through that glass door. Is that you?
That is me.
What's happening?
He's removing the self-made tourniquet from my cardigan, and he's putting on an actual tourniquet.
Okay, and at some point you get into an ambulance, correct?
Yes. So at this point, he says, "I'm going to radio to see if there's an ambulance available for you," making sure that no one else needed it ahead of me.
Okay. You eventually get into an ambulance. They take you where?
They took me to Lapeer.
What happened when you got there?
So I get to Lapeer. And the doctor comes out to the ambulance and introduces himself. And they said, I was sitting in the ambulance the entire time, and then they said, "We're going to put you on the gurney." And I said, I can walk. Like, if I can walk, I want to walk. And so they help me out of the ambulance, and I walk in, and they're like studying, you know, like kind of almost holding me up, studying me. And the hallways are lined with doctors and nurses.
Did you see any other victims?
I did not, no.
Okay. And they treated your wound?
They did.
Okay. Were you able to, I assume they ran some tests. I want to be cognizant of the judge's prior ruling about what you can testify to. But at what point, how long were you at the hospital?
I have no idea what time I walked in those doors.
Okay.
I was there for several hours.
Did you learn at some point there were other victims?
I did ask when I was in the hospital, is anybody else been injured? And I was, you know, I was told that there were other victims and a few fatalities, yes.
Okay. At some point, did you hear a teacher was shot?
I did.
And what did you think?
I instantly thought it was another one of my colleagues. I knew the direction that I saw him turn, so I knew what direction it came.
And who was the teacher, Melanie?
I thought it was Lauren Jasinski that was shot.
But who was the teacher they referred to?
It was me.
At some point, you were shown weeks later a picture of your doorway. Mm-hmm. Do you remember that?
I do.
Okay. Do you remember who showed that to you?
No.
Okay. Was it me?
I did. Well, I did see. I did see it in your office. Yes.
Okay. You were preparing to testify.
Yes.
I'm going to put that picture on the screen. It's People's Exhibit 8. I don't think there's an objection.
No objection. There's no objection. Date submitted.
Molly, is that your classroom door?
That is my. Yes.
Okay. What was your reaction when you saw that?
He was aiming to kill me.
Do you know which one of those shots landed in your shoulder?
I don't. I have no idea which one landed in my shoulder, but I know the top one, that's where my head would have been, and the two down below are my chest area.
Okay.
I unlock that door every day.
And what was your, did you have some, what is your, when you think about the wound and why you weren't hit, why was it? In the chest?
That door, the distance, the door, and me moving was the only reason that I'm alive.
How many inches from your heart was that injury to your shoulder?
The actual wound is 6 inches, but my turn might have made it less.
Thank you.
Thank you.
I have nothing further, Your Honor.
Cross.
I have no questions, Your Honor.
Thank you.
Thank you. Can this witness be excused, Your Honor?
Yes, please. You can step down and
Thank you.
Who's the next witness?
Christy Gibson Marshall.
We had a discussion about the boundaries of her testimony. I don't know if we put that on the record. Do we need to or not?
We've prepared her, Your Honor.
Okay.
We understand it's not a Miller hearing. We know it's a trial.
Okay. The media is asking whether or not they can videotape tape the video. I don't see a reason why they can't, right?
No, there's no minors.
Oh, okay. Yes, I want to make sure.
Judge, actually, this one, in this portion. Yes.
Oh, yes, in this portion. We'll indicate which
Right.
which videos can't be shown.
Yeah, give them a heads up. So you know.
I'm mostly concerned in giving a heads up to the jury so everyone's prepared.
And then, Your Honor, again, the defense objects to, I believe it's just one exhibit you're using with Ms. Gibson.
This witness?
I believe it's only exhibit 9.
Yeah. This was previously extensively briefed.
Yes.
I made it unwilling about it. But your objections are good.
Thank you.
People call Christy Gibson Marshall.
Good morning. Could you raise your right hand? Do you swear or the testimony you're about to give is the truth, so help you God? All right, please be seated. And would you state your name for the record and spell your first and last name?
Christy Gibson Marshall, KRISTYGIBSON-MARSHALL.
Go ahead, prosecutor.
Thank you. Good morning. Hi. May I call you Christy?
Yes.
Christy, could you please tell the jury where you're employed?
Oxford Community Schools.
How long have you been with Oxford?
29 years.
And what do you do right now?
I'm an assistant principal.
Okay. And that's at the high school?
At the high school.
How long have you been the assistant principal at the high school?
6 years.
And what did you do before that?
I was an elementary principal.
Also in Oxford District?
Yes.
Now, if you could tell the jury a little bit about your role as an assistant principal. What are some of your responsibilities?
Teacher supervision, evaluation, curriculum and instruction, supervising. I do parent communications. It's hard to think of all the stuff that my big giant list while I'm sitting here, but we have a student relations team that works together to support our alphabet, part of the alphabet. Big goal is, like, to me, my biggest role is supporting students, and I love the kids, so just bringing energy and having fun with them.
You've been in education, you said, for 29 years?
Yeah, yes.
So up until this role, you were an elementary school principal?
I was, and prior to that, I was a teacher.
Teacher before that, okay. Now, as it happens, the school that you were principal at was Jennifer Crumbley's son, one of those students?
Yes.
Okay. And what grades, if you recall, was he there?
4th and 5th.
Did you have any contact with him in your role as a principal in those 4th and 5th grade years?
No.
Did you have any contact with his mother or father?
Not that I remember. I had an email about a report card once, but that's all I remember.
And that would have been years prior?
Like 5th grade going to 6th.
Now I'd like to direct your attention to November the 30th of 2021, about 12:50 in the afternoon. So we have the screen in front of you. That should be displaying People's Exhibit 5. This is a map of the Oxford High School.
Yes.
If you could tell us, if you recall, where you were about 12:50 in the afternoon that day.
I was in the I started in the cafeteria supervising lunches. So what would be, I guess, they're the commons.
So right
Yes,
here?
correct.
Okay. So was that lunchtime while you were there?
Yeah.
Okay.
Yes.
And is there a time where you moved? So around that time on November the 30th, did you have a specific area of the school you would go to, or did you move around?
We didn't have an assigned area, but I like to go to the senior courtyard after lunches and just kind of help see that courtyard area.
Okay.
The hallway out in front of this courtyard area between where you see 400 and 401.
Okay.
Our seniors hang out there and they congregate in a good way, not terrible. Let me just clarify. It's kind of like the rite of passage, and we just like to kind of go there and keep traffic flowing.
Okay.
Yeah.
Is that something you would do on a routine basis?
Yeah. My bad mom joke on that one is that I make it a senior citizen window, and I stand in that area.
Was there a point that day when you realized something was going wrong?
When I was approaching the senior courtyard, so when I was coming down the hallway from the commons, what says commons, I call it cafeteria, by the media center, by the courtyard, and the 500 room, when I kind of got to that triangle there, that diamond there, one of the students that I know pretty well went running by and said, "Get the hell out of here." And he was laughing and running, and I was like, that was a mixed message.
Sure. At that point, was there an announcement on the loudspeaker?
No, not at that point, no. No.
Was he the only one running?
Shortly after him, there was a group of kids laughing and running behind him. When I stopped to ask them what was going on, they weren't entirely sure. But as kids started to pass, you could see it got more serious.
Okay.
I grabbed my walkie-talkie and I
What do you mean it got more serious? What do you mean by that?
their faces got more, I'm sorry, their faces became more serious.
Did that signify something to you when you saw that?
Yeah, just something, them running signified something to me because it's not a typical behavior.
Okay.
But the running and laughing was confusing, and then when their faces became more serious, I was started to get very worried, and that's when I grabbed my walkie-talkie.
Okay. What did you do with your walkie-talkie?
I said, "I'm not sure what's happening, but kids are running in the hallway," which is very odd, and look like they're trying to leave the building.
So where did you go?
They shortly after I got on the walkie, they went to Alice Alert, and so
What's Alice Alert?
Alice Alert is our intruder. I'm going to call it intruder alert because that's what it was that day. But it's a notice that we need to take cover, lock down, be aware. It's an emergency assistance.
An alarm ringing, or is that somebody who's giving a message over the PA system?
On that day, it was a message over the PA system.
Do you recall who gave that message?
Steve Wolf.
And who was that?
Steve is our principal.
He's the principal. Okay. So, is this shortly after you saw the students leaving that appeared to be more serious to you?
Practically the same. Yeah, it was like they went, when the more serious students came by, the announcement went on.
Okay. Now, when you hear that announcement, what were you supposed to do?
I'm supposed to lock down.
Did you?
No.
What did you do?
I went to check the hallways to make sure people were okay.
When you first started to check the hallways, did you see anybody?
The hallways cleared so fast. When I made the turn down the 400 hallway, I ran into a teacher who was locking his door, and then a student came up who was running late. He asked if it was a drill. I let him know that it didn't matter if it was a drill or not, just you got to take cover, get in there. And then I proceeded down the hallway. I was the only one in the hallway at that point.
Did you hear anything?
First, I smelled something. I smelled what I thought was cap gun.
Okay.
Later, figured out was gunpowder. And then I heard two gunshots.
Where were you when you first smelled what you thought to be cap gun?
Probably by like the somewhere between 409 and 414.
So you were continuing to walk down that hallway, the 400 hallway, towards the 200 hallway? That's in yellow highlight?
Yes, that's where I heard the gunshots. I was going that direction.
You were walking towards the gunshots?
Yep. Yes.
As you walked down the hallway, did you see anybody else?
No.
Tell me where you went.
When I got to the end of the hallway, I realized how dumb this is. I turned left to go towards where I heard the gunshots.
So this hallway.
And I went towards 225.
So you came down the 400 hallway and you turned left towards 225?
Yes.
Tell us what you saw when you made a left.
I saw a student laying on the ground.
Did you know who he was?
I didn't at that time, no. His face was covered. And then as I continued a couple of steps, I could see another student walking my direction. He had just dropped his arm was up, and then he dropped his arm.
Did you recognize him?
Not at that point, no. He was too far away.
What did you do when you saw a student on the ground?
There was a garbage can between he and I, so I moved the garbage can out of the way, and I put my foot near him and nudged him and told him to stay there.
Did he respond?
No. No.
Could you tell if he was injured at that point?
You could tell he was injured.
What happened next?
Ethan then came into closer view, and I could tell it was Ethan.
He had been at the school where you were principal?
Yes.
Did you interact with him at all at Oxford High School?
Just normal, like how I interact with everybody. High fives, hugs, silly stuff that I do.
Okay.
I brought my elementary to the high school, so I just
Did you
enjoyed
say
it.
anything to him?
When he got close enough to me that we were sharing the hallway, so he was kind of walking down the center and I was kind of over to the side, so we're probably, 3 feet apart. I asked him if he's okay. It just didn't seem right that it would be him.
So I need to back up just a little bit. When you didn't know who it was at first, a student down the hallway, you said he had lowered his arm?
I knew it was a shooter when he was down the hallway.
Okay. Could you see if he was holding anything?
I could see a gun.
At that point, was he walking towards you or away from you?
He's walking towards me. It was when I realized it was Ethan that I didn't think he could possibly be the shooter is what happened. I know I said that I knew he was a shooter down there because I could rationalize that is a gun. He is putting that gun down. He just shot something.
Okay. Now, I know this is difficult, but I need you to use your teacher voice and speak
Okay.
loud as you can. You saw him coming towards you. How far from him were you when you recognized who it was?
He was probably by the room 221 when I could tell who he was.
Okay.
And I was standing between 226 and that weight section there. There's exit doors there.
Now, you said you said something to him?
Yeah, it seemed so odd that it was him. So I said, "Buddy, are you okay? What's going on?" And when he didn't respond to me and he looked away, that's when I knew it was him, that he was the shooter.
Did he point the gun at you?
He did not.
What did you do at that point?
I got on the walkie and I told my team that I have eyes on a shooter and I have a victim.
Now this hallway, 200 hallway, there's a curve to it.
Yeah, yes.
And he was walking, if we follow the mouse cursor here, he was walking down the 200 hallway towards 233 and 237?
Yeah, he was walking that direction.
That direction?
Yes.
Did you watch where he went?
No.
What did you do?
There was a student who was injured, so I went to him. I didn't.
Okay.
I knew he needed me.
He has, I know you're aware, but there's been certain rulings by the court, so just in general terms, did you render aid to that student?
I did.
Could you tell if he was injured at that point?
Yes.
Did you recognize him?
Yeah, I knew it was another one of my students from Lakeville. Tate Neer. It just took my breath away.
You were on the walkie-talkie, you said?
Yes. So I let them know I had eyes on the shooter and that I had a victim. Kurt News asked me where I was. It's probably the biggest hallway we have, and I said I was in the 200 hallway. Kurt let me know that's a very big hallway and needed more direction. I don't know why I couldn't process the fact that, like, my exact location, I told him I was near the 400.
Okay. Did you stay with Tate until help arrived?
Yes.
Now, you have seen at least a portion of the Oxford High School surveillance video, is that right?
Yes.
I'm going to show you what's been marked as People's 9. It's been admitted. It cannot be broadcast on the media.
All of it? I've never seen it, so you have to tell me.
The entire, this is a short clip of it. None of it can be broadcast.
Okay. You have, okay, so you guys are not video, okay. Everybody gets it?
I have a tight shot of the.
We're going to stop the live stream? Should we stop the live stream?
Yes.
Yes, Judge.
Yes, please.
Okay. All right.
I do want to give notice to the jury as well. This is the moving image of a victim on this video.
Okay.
Christy, tell us when we see you.
I am approaching right in the yellow jacket there, the gold jacket.
For the record, this is at 12:51 p.m. on November the 30th. So no one's come by at this point?
No. I forgot about, that's when he came by. He said, get the hell out of here. I don't know if you could see him running through there.
The first student?
And you see more students running. These kids are kind of laughing, and then you'll see me stopping. There we go. There's my walkie.
And you're walking down the
And
middle
I'm
hallway there?
walking towards the direction that the kids told me. They cleared the hallways very, very, very fast.
That's you at the top of the screen?
Yes. I didn't realize that we passed there. This is where the teacher came out. I'm checking another classroom to make sure they were okay. And then I'm continuing on. This is where I'm saying, that's when I stepped aside, that's when I said I had eyes on the shooter, because he flinched a little bit, or at least in my perception that he did. This is where I moved the garbage can. That's Tate. When I'm talking on the walkie, I try to step back a little bit because I think it threw Ethan off a little. And so there he is coming up to me. And I start talking to him here. And I'm letting them know that I have a victim and I have a shooter. I'm asking him questions. And I turned my back on him and I came back to Tate because I didn't know it was Tate then. And then that's what right there is when I know it's Tate.
This is after the police arrive on scene and cut portions of this.
Yeah. So police arrived on scene and they were trying to figure out his name.
The shooter's name?
Yes, and so I left Tate to go tell them who it was, and then I went right back to Tate. I did not want to be away from Tate. I was telling Ken, his name's Ethan.
Thank you for your statement.
We're going to hit cross. You can resume. They can resume the live stream, right? So.
Yes, sir.
I'm sorry, is the prosecution doing the post?
Yes.
I'm sorry, I can't think straight.
Oh, yeah, I think he said that he's
yes.
finished. Yeah.
Okay. I have no questions for you, I'm sorry.
Thank you.
Thank you.
Can this witness be excused from
Thank you.
This can be back.
Is there any way we can have like a minute?
Say it again.
I'm like so sorry. Can we just have a minute, like a break or can we have a 10-minute break, please?
Oh, sure. Sure. I'm going to give you a 10-minute break, okay?
All right, for the jury.
All right, welcome back to studio as we watch this trial unfold, the first witness statements there. We're back with attorneys Lillian Diallo and Richard Convertino. Thank you both so much for staying with us throughout the day. What are we seeing here? Let's just talk about this moment that the defense is asking for a break. The attorney is emotional as well as the mother.
So,
what do you make of that?
You've seen that video footage before, right? And okay, you can be emotional, but we are supposed to be professionals in a courtroom. That kind of thing is trained out of us. If it's something that comes upon you suddenly, right? But you will never hear me stand up and go, Judge, can I have a minute because I'm emotional so I can think straight? If you can't think straight, get out of the game.
Yeah, we've been pretty critical so far this morning of the defense.
Well,
your take on this?
Honest, I would say.
Just honest.
Yeah, I concur 100% with Lillian. Yeah, there are, as a defendant and an attorney, either the prosecutor or the defense, there are always eyes on you. Somewhere, someone's looking at you, one of the jurors, the court, the someone is looking at you and evaluating you, and so to ask for a break and say that you can't think straight as a defense attorney, I think that sends a signal to the jury that not only was this witness devastating to you, but certainly was extraordinarily devastating to your client. You can't even keep your composure, and so that tells us something.
And this is following two very impactful witness statements. And these were two women that we saw testify at the Miller hearing as well. Why were these two selected as the very first witnesses for the prosecution, do you think?
Well, because they were so impactful, so devastating, so powerful in both their emotional state and their ability to succinctly and concisely go through the facts as almost as a lay witness, but also as a participant to this. So both witnesses were very composed and also very emotional, and it was, I think, devastating testimony.
Yeah, and with those testimonies that we're hearing so far, your take on how this could impact Jennifer?
See, these are boots on the ground. We don't get to see what they saw, right? They're telling you, and you can feel what they saw. You can see the emotion, right? The second witness that just testified, she said, I brought elementary school to the high school. She saved her life. And who else, however many other lives, right? She's very composed, but she's a human being. This is the human concept of being irresponsible in society. That's what we see right here. So, I know we always talk about laws and things of that nature, but this is it right here.
All right, well, it seems as though there's been a complaint from the prosecution about this request for break, so let's tune back into what they're saying.
It's horrific.
You've had this video for over 2 years.
I don't have this video. I have to go to their office to watch it.
You've seen it?
No, I haven't, because it's not necessary. It's not relevant to my client's case. We've already litigated this, but we're doing our best. We were not sobbing or making a scene in any way. All my eye makeup's still on. I checked my camera.
I'm not having.
I need to run to the bathroom. I need a break.
Okay, we're having a break. That's what we're doing. And you got to keep your voices down because
I'm sorry.
The walls are cardboard in here. So
I'm sorry.
Okay, all right. Everyone here is human, right? Everyone here is human. I understand that. I'm striving really hard to give both sides a fair trial, and if people don't at least try to check themselves, to exit if it's that excruciating, which I know it is. I'm not a robot. I'm trying to keep myself from sobbing. I'll do it at 6 o'clock tonight, okay?
I appreciate that, Your Honor. That's all I'm asking.
Okay.
That's all
Your Honor, we don't have the option to leave the courtroom. We're trying our best. We're trying. I promise you, we are trying our best.
All right.
Thank you.
Everybody needs to take a deep breath. She has to go downstairs, right? And we're going to call you right, have her come right. How long do you think the next witness is? I'm bringing lunch in for the
Next witnesses can be back. I anticipate very brief questioning.
Okay, because I'm having their lunch delivered so they don't have to commingle with people in the cafeteria.
It should be less than 30 minutes, so it'll work out fine.
All right.
Are we going to break then after that witness?
Yes.
Okay, thank you.
Yes.
All right. I apologize.
No, it's natural. It's horrifying. It's
horrifying.
It is horrifying.
We're trying. We're trying.
Okay.
We'll keep trying. All right.
You may be seated.
All right, we see that defense attorney there seemingly unraveling in the courtroom.
It's a good word.
Yeah, talking about how emotional it is to take those things in, but we also have to keep in mind how emotional this is for these witnesses, some of them who also appeared in the Miller hearing, having to relive this all over again, just based on courtroom conduct. Some of this has seemed a little unusual today. Is that correct?
It does, because if you have the judge, and I practice in front of this judge, right? And she keeps it together, and she keeps the courtroom fair to both sides, equal playing field. if she's saying you can't do something like that, right? Whatever's going on, we have to hold it together. If you didn't see that video before it started getting played, then you pull them up and go straight.
Yeah, and I like what the judge said about not being a robot, because I think that's something you and I can attest to.
Absolutely.
Every day we're hearing things that are not good.
Yep.
And we have a job to do. We have to present. Richard, your thoughts on this behavior?
I think it may be a great T-shirt. My eye makeup is intact.
Oh gosh.
You know, Jennifer Crumbley's lawyer underneath it, but it's very unprofessional. And the thing that is even more unprofessional was the attorney's assertion that and complaint that she had the ability to see the video. Seemingly was the first time she saw it. Was in the courtroom today. She had the ability to see it, but she had to go to the prosecutor's office to view it. Now, you know, that's the kind of thing that'll get a motion on appeal for ineffective assistance of counsel. You know, asking the court to look at the presentation of the evidence in a fair manner to the defendant, the appellate court, because he or she, in this case, Jennifer Crumbley, was ineffectively represented at the trial level. And I don't know if that motion will be made. It is a routine motion on appeal, but in this case it seems to have some validation. She didn't look at evidence before it was presented at the trial. She's had years to look at this evidence, so there's really no excuse for that.
But Oakland County Prosecutor Karen McDonald said, with conviction, you've seen this video.
She did.
We heard the back and forth between them. It actually got pretty heated, and the judge had to say, please lower your voice to the defense.
Yeah, it's not uncommon that it gets heated in the courtroom. But yeah, there was no basis for this.
Yeah, and the argument there is that this has nothing to do with her client, but as the prosecution said in the beginning, we're talking about the negligence here, which is what led to this outcome.
And focus on that. And listen, I know it's a lonely job being a criminal defense attorney sometimes, right? It's very lonely. However, there are standards. Now, we have jury trial experience, right? You must see what the other side has. You must, as my comrade over there said, you must. For you to stand there and say something like that, it's just repugnant. I don't want to just knock the poor girl, young lady, right? But let's get to this professional thing. We are female lawyers. We're lawyers. Be a lawyer. I don't want to hear about your eye makeup. I don't want to hear about what you have to get yourself together. Get it together, sit there, and challenge the prosecutor's case. Try to put some reasonable doubt in there. That's her job.
Yeah, I feel the same way. I don't want to, you know, pile too much on this attorney, but just, you know, again, Meredith and I speaking from our perspective, we know our conduct that is expected of us as journalists. Can you speak more to just the protocol in a courtroom when it is something emotional and how this is not really lining up with that?
Well, one of the ways to present evidence or to accept evidence at a trial is to have reviewed it prior to the evidence being admitted at trial. It's not, listen, nobody in this trial, none of those witnesses who are testifying regarding exhibits have not had the opportunity to review those exhibits over and over and over. And that is a common practice in the law, that the prosecution will turn over all evidence, exculpatory or non-exculpatory, any evidence that's being used at trial, certainly, to the defense. So to hear a defense attorney acknowledge and actually complain that she hasn't reviewed this evidence prior to the trial, that the first time she's seen it as it's presented to the jury, is shocking. And you know, maybe it did overcome her because that's the first time she saw it, but it certainly, there's no excuse for not reviewing the evidence, whether she had to go to the prosecutor's office to review it or to review it in some other manner or means of the police department or whatever it may be. I've reviewed evidence in police departments before because of security issues or whatever it may be. But you have to do it. You can't say, hey, it's the first time I saw it, I was overwhelmed and I need a break. You're telling the jury that information. It's just astounding.
It's a bit bizarre. Well, this is just the first two witnesses. Yeah. We haven't gotten through much at this point.
But here is one thing that she did do that I think we both, all four of us, but I know Lillian will agree. She got up and said, no further questions. No questions from the defense. There's absolutely nothing that she can do with those witnesses to progress her case. And so there's no need to even ask. The only thing she could do by asking questions is to hurt her client.
Well, thank you both for your thoughts. We will be going on a short break. We'll be back soon.
Welcome back on this coverage of the trial of Jennifer Crumbley, the mother of the Oxford school shooter.
Yes, we just went on break for a short time. This break shouldn't last long. Should have. The defense asked for a break. The attorney became very emotional and said she just needed some time.
Yeah.
After seeing some pretty strong witness testimony. And I must say, something that drawing differences between this and the Miller hearing, which we also covered extensively, we did not see any surveillance footage. We are now. This is really bringing us into that day. Why didn't we see that surveillance footage in the Miller hearing, Richard?
It's not necessary. Yeah. The only time they're going to present evidence is during a necessary judicial proceeding to advance their case. They're not going to show it in a Miller hearing when it has absolutely no relevance. So here it's important evidence.
And while the defense is arguing that it's not necessary, again, like we said, it's showing the consequences of no one stepping in to prevent this outcome.
Absolutely. So we do know deaths by guns, right? It's a very gory thing, okay? But these are the set of circumstances they're saying you allowed to happen by your not parenting this kid that said, I need help, I'm hearing voices. That's okay, we'll get you a gun, a more powerful gun than you had before. So we might have stood a chance with the little 2-shot, right? But with that is a very lethal gun, that Sig Sauer. And they're telling you that he's doing these things, searching, and you're saying just don't get caught.
Right.
And one thing that struck me regarding the gun itself is the drawing that the parents were shown on the morning of the shooting. He said 3 hours before it happened. It was the same exact gun that they had purchased for him in this Black Friday sale. It really makes you question what was going through the parents' minds when they were in this meeting. Why, as the prosecution showed, Jennifer Crumbley cut that meeting short. As a parent, why would you do that?
I think it was clear that why she did it. She wanted to cut that dialogue off and get out of there. Again, as Lillian said, to obviate her personal responsibility, and which obviously is a key part of the evidence now, to show, like the prosecutor said in his opening, the digital footprint, the overall character of the mother. That she had the ability to, all of this you're hearing, the first 2 witnesses, is being presented because the prosecution is saying this needn't have occurred but for you, but for your negligence, but for your wanting recklessness. This would not have occurred. That's the theme of the case.
You mentioned cutting the dialogue and getting out of there. Could this be a tactic of the defense attorney as well? Because you also said in that case it looks like she really had nothing she could reasonably ask those witnesses. So could this be a tactic to just say, we need a break because there's nothing I can come back with?
No, I mean, really, a good attorney will tell you, you don't have to ask questions of every witness over there, especially if you can't get anything from them. So there's nothing that she could gain from that particular witness. And yeah, you get your break, that's fine. Or they could have moved on and called another witness. But there's nothing to gain from questioning a witness like that, from defense's standpoint anyway.
All right, we understand the trial is resuming after a short break requested by the defense. Let's tune in. All right, we are still waiting for audio from that video to come up. But Lillian, and you said your experience with this judge, you believe she is fair.
I do.
Tell us a bit about who she is.
Well, she's been on the bench for a while. I've been in front of her a few times. She's so even to both sides. She doesn't disrespect the attorneys on either side, but she controls her courtroom. Remember, this is her courtroom to control, and I'm telling you right now, if we can't hear it, she's laying down some ground rules for how this is going to happen and not trying to embarrass anybody in the process. Hats off to her.
Yeah, and if we could keep this video up, we're watching her speak now. You can even see her composure without hearing what she's saying, and that is needed right now because it looks like things were getting a little out of hand. Would you agree?
I absolutely agree, and I'm sure Rick would too. We've been in many, many, many trials, right? And when you don't hear what they're saying, and she's saying, I am not a robot, but there are certain levels we will not fall beneath as professionals. And you might have fallen beneath one when you talk about your eye makeup.
Mm-hmm.
You know, I don't know what she's thinking right now. She is composed, Terrence, but I did see a bit of frustration on her face.
Yeah, I saw it in the opening statement as well, the defense opening statement as well. She looked upset, looked like she was curious as to what she was hearing. Did seem like it was rather bizarre, the way the opening statement went, and she looked like she was agitated with the defense attorney. One of the things about this judge that I haven't been in front of her. I've tried cases in Oakland County, and Oakland County is a little different than many other counties. It's a no-nonsense judicial county, and they move quickly, and the courtrooms are controlled heavily by the judges. This judge went to Fordham Law School and graduated, I think, in 1989, and then in 1991 went right into work for the Oakland County prosecutor. So she worked for the Oakland County prosecutor, I think, until 2014, and then was appointed to the bench. And then, so she's been a prosecutor almost her entire career. And so to have a judge who's even keeled, like Lillian says, that's great. Because she comes from a background of only prosecution.
Now we understand audio is back, so let's tune back.
We're hearing that the court has actually called for the audio to be cut off.
Oh, sorry about
so
that.
we're going to
Okay.
keep watching as everything continues to play out. At some point, hopefully, they'll get that back to us.
I see.
With this break that is happening, could this just be a chance to just set the balance back in place?
Regroup. Let's reset and understand what our responsibilities are as advocates in the courtroom. The prosecutor is going to try to show there is no reasonable doubt. We are trying to sow the seeds, right? If it's there, it's there. If it's not, it's not. But that's what we're supposed to do.
Okay, and we've been told that there are 25 plus witnesses that will be taking the stand today. We're getting more information from our producers. They're actually bringing in some minors now to speak. So we've heard from those first two witnesses, and that could be obviously a very good indicator why the audio is cut and the video is cut. How damaging could that be as we continue to hear more accounts of what happened that day, hearing from some of those students?
It's going to be devastating. It's devastating to us just here. Like, as you said, we're supposed to just be even keeled. This is PTSD kind of material, right? You have to just take it in. These are children that were directly impacted and terrorized. That impact doesn't go away because the person is sentenced. This is lifetime.
This is something that we were talking about as we were watching those first two witness statements, watching the assistant principal at Oxford High School, Christy Gibson Marshall, her facial expression and reaction to the surveillance video when she approached the shooter and spoke to him without knowing it was him that was shooting. And you have to understand the chaos in a situation like this. Discovering Tate Meir on the floor. I mean, these witnesses just speak to the strength that it takes to testify twice on national television.
Well, to testify twice, but to live it every day.
Yes.
And to maintain your composure, because one of the things that I really want to stress about the first two witnesses is that they were fact witnesses. They were necessary witnesses. One was shot, and one personally witnessed the shooter with gun in hand.
Yes, I do.
Critical witnesses, but they were able to clearly and concisely dictate the facts in an orderly fashion, and still share with the jury the empathy and the ethos, the emotion that was so devastating to the defendant. Now, you'll hear these witnesses can't and won't talk about the mother right now. This is just about the shooting and the scenario that occurred in the high school.
Just their experience.
Just their experience. They're not going to say, anything about the mother.
Yeah. We'll continue this
defendant.
conversation in
Okay.
just a few, but let's get back to the courtroom now, because another one of those witnesses, an adult witness, has taken the stand.
Is done, myself or whoever will run a NICS check on the computer.
Okay, can you tell us what that is?
That is where you send it over to, I just lost my train of thought, to the FBI, and then they take it from there.
Okay. Do you know what happens with that? When you
I
send
do
it to the
not.
FBI?
Nope.
So you take this information in, and the customer fills out certain forms, and you send that off?
Yes.
Okay. And how long does that process usually take?
Sometimes it could take seconds, sometimes it could take up to 30 minutes
Okay.
or longer.
is someone able to walk in and buy a firearm, or to buy a firearm and walk out with that gun purchase that day?
As long as they pass the background check.
As long as everything checks out?
Yes.
Now, what happens if things don't check out, or if there's some kind of delay? Does that ever happen?
Yes.
Okay, and tell me about that.
So if a customer is delayed, we are giving them a Brady date, which is 5 days. Within those 5 days, the NICS check could come back as a proceed, or it could come back as a denied. After 5 days, if there is no response, then we are allowed to hand the firearm over to the customer.
Okay. Do you know the circumstances in the background why somebody might be approved or denied?
I do not.
Okay. Now, when the store you work at sells a firearm, do you also provide a ATF pamphlet on handgun safety?
Yes.
Is that with every handgun purchase?
With every handgun, yes.
Okay. And tell me about that pamphlet, please. What kind of information is contained in there?
It just states the do's and the don'ts as far as, you know, when you buy a firearm, child safety, how to lock it, just to pretty much keep your firearm safe and out of the hands of, you know, anyone that doesn't need to have it.
Okay. And that is provided by the ATF?
Yes.
Okay. That's the Bureau of Alcohol, Tobacco, and Firearms?
Yes.
All right. Does your store also provide a trigger lock statement?
Yes.
Okay. And is that one of the standard forms that has to come with the firearms purchase?
Yes.
Okay. And tell me what that is, please.
So it's just the trigger lock form, we take and we make sure we check the box, that it has the lock in the box, and that it has a box that can be locked.
Okay. Now we say the lock in the box. What do you mean by that?
The trigger lock.
Okay, so when your store sells a firearm, you also provide a lock with it?
Yes.
Okay. And that's not an actual gun safe, correct? That's a smaller locking device?
Yes.
All right. And that happens with every handgun sale from your store?
Yes.
I'd like to direct your attention to November the 26th of 2021. Do you remember that day?
I do.
Okay. And were you working?
Yes, I was.
Did you, well, first of all, I should ask you, as office manager and someone who's been employed at the store for 4 years, every time a firearm is sold, is there a receipt kept?
Yes.
Okay. On November the 26th, 2021, did you sell a handgun to James Crumbley?
I did.
Okay. And was he there with somebody else during that purchase?
Yes, he was.
Okay. Was it an adult or was it a teenager?
Teenager.
Okay. Did you come to learn who that person was?
Later, yes.
Okay. And you came to learn that it was the defendant's 15-year-old son?
Yes, sir.
Okay. But you didn't know that at the time?
No, I did not.
Okay. Now, during the purchase between yourself and James Crumbley, did his son do anything?
Never.
Okay, so he was there present, but he didn't interact with you?
No.
I'd like to direct your attention also to June the 15th, 2021. Did James Crumbley make another purchase of a firearm that day?
That I cannot say.
Okay. If I showed you receipts, would that refresh your memory, you think?
Yes.
Okay. So what I'm going to do is go through some exhibits with you. They'll be on the screen in front of you. These are all stipulated too. Can you see that?
Yes.
Okay. This is Exhibit 24. This is, do you recognize this as a receipt from the store you work at?
Yes.
Okay. This is June the 15th, 2021. Do you see the date?
Yes.
All right. And the purchaser is James Robert Crumbley.
Yes.
And it has his address. And it has the item purchase, and that's a Cobra Classic for $180 total.
Yes.
And that's actually a 22 Derringer pistol, is that correct?
Yes.
24 has been admitted, I believe, with stipulation.
I believe that Ms. Smith was willing to stipulate to 24 to 30. Is that correct?
That's correct.
24, 25, 26, 27, 28, 29, and 30 are admitted. So.
Thank you, Jeff. This is Exhibit 25 right here. It says pistol sales record. Can you tell us about that, please?
So each time that a pistol is sold, we have to provide the customer with a pistol record. They are given those, and they are instructed to have those dropped within 10 days of the purchase.
Okay. Now, this has a description of the pistol, is that right?
Yes.
So it says, this is the Cobra Classic we just saw the receipt for. Do you see that on there?
Yes.
Okay, and it says pistol shot in the number 2. What does that mean?
It's a 2-shot.
Okay, so it's a small handgun?
Yes.
And barrel length 2.25. Is that in inches?
Yes.
Okay. It says purchase transfer date is June the 16th of 2021, whereas the receipt was June the 15th, 2021. Can you tell us what happened there?
So I believe that Mr. Crumbley may have gotten a delay on June 15th, and he had a proceed either later in the day on June 15th, or he may have gotten a proceed early morning on June 16th.
Okay. And that's because there's some kind of delay in the background information?
Yes.
Ms. Mack, is it true that some handguns sold by the store actually come with their own cable locks, not just from the retailer themselves?
Yes.
Okay. So, whereas on November the 26th, you provided a lock, not every handgun has to be provided a lock by your store.
Yes, it does.
Because the manufacturer gives the lock themselves.
Yes.
Okay. So I don't think that was clear, so I just want to back up for a second.
So some guns that come in from the manufacturer do not provide locks. We
Okay.
have to provide those.
Got it.
Sorry.
Okay, no, that's okay. No,
Okay.
that's my fault, not yours. The 6 Hour, for example, they do not provide their own locks, is that right?
Some they do, some they do not.
Okay. And if they don't, then you would fill in that gap.
Yes.
All right. Now, this is Exhibit 26. This is a receipt, James Robert Crumbley, June the 16th. And this is the Caltech P17 22LR. Total price $349. Do you see that?
Yes.
Okay, this is Exhibit 26. And again, this is June the 16th. That's the day that he would have received the Derringer.
Yes.
You're right? Okay. And here's Exhibit 27, which is the actual pistol sales record. And again, purchase transfer date June 17th of 21. So there was a delay in this purchase as well?
Yes.
Okay. And this description is, it's a 16-shot, barrel length is 3.8 inches.
Yes.
So it's bigger than the Derringer.
Yes.
Now moving on to Exhibit 28. This is from November the 26th of 21, the day we've already spoke of. So this is a receipt, total of $519.35. And again, James Robert Crumbley. Is that right?
Yes.
Okay. And this is the day you recall seeing somebody with him?
Yes.
His son. Okay. Do you recall if his son was with him in June, or did you not complete that purchase?
I did not complete that purchase.
Okay, that's fair. But as office manager, you can tell us that those records are from your store.
Yes.
Okay. Here's Exhibit 29. This is the pistol sales record. And this is from the 6 Hour on November 26th, is that right?
Yes.
Okay, so this is a 15-shot, and it's 3.75-inch barrel.
Yes.
Is that right? Okay. And he walked out with that gun on November the 26th, 2021? Because that's the date that we have right there?
Yes.
Okay. Now, hypothetically speaking, if there was a 15-year-old who walked in your store and tried to buy a handgun, would you let him?
Absolutely not.
Okay, that would be illegal, right?
Yes.
Okay. Here's Exhibit 30. This is a portion of the firearms transaction record. I think you referred to it as a 4473. Do you recognize this?
Yes.
Okay. And was this provided, this was filled out by James Crumbley?
Yes.
Okay. And what's the purpose of this form here?
That is to keep a record for ATF for all firearms that are sold.
So there's certain boxes are checked here, and the condition of the gun is notified. In this case, it was used.
Yes.
Okay. And the purchaser has to assert certain things before he can walk out with that gun. Is that right?
Yes.
in one of those boxes, are you the actual transferee, or you are the actual buyer of the gun, and it's not for somebody else?
Right.
Because it is not legal for someone to buy a gun for somebody else through your store, correct?
No, it is.
Well, that person has to come in and fill out this paperwork, that
Yes.
right? Right. So it would not be legal for a adult, for example, to check this box that the gun is for himself and then transfer it to a child.
Yes.
Can you tell us the difference between a cable lock and a trigger lock?
So a cable lock, you have to take the slide off of the pistol and run the cable through the barrel and bring it out and to lock. Trigger lock goes directly on the trigger.
Okay. And do you recall it was provided to James Crumbley on November the 26th?
I believe it was a cable lock.
A cable lock, okay. So it looks like a rope.
Yes.
And then at the end of the rope, there is a locking mechanism?
Yes.
And then that's fastened by a key. Would that be right?
Correct, yes.
There's some firearms that can't be secured with a cable lock versus trigger lock, or is it unique to certain guns that you need one versus the other?
I don't believe so.
Okay. Does your store always provide either a cable lock or trigger lock, or does it depend?
We provide both.
Both?
Yes.
Okay. But on this particular occasion, on November of 2021, it was a cable lock.
It was a cable lock, yes.
I have nothing further. Oh, hang on one second. Sorry. Thank you, Judge. Nothing further.
Thank you, Your Honor. I just want to go back through the exhibits. Would it be easiest if I had the prosecution go back through them if I ask, or is it easier if I just transfer it to my laptop? Okay. I can use these. Okay. Can you put up exhibit number 24, please? Just so that the jury can see it. And if you want, I can put it on my computer. I have them.
Oh, we have another flash drive, don't we, that we provided to the defense?
I have them on my computer. Do you want me to take the reins and use my laptop?
Yes.
Yes.
Okay. Your Honor, we just need to switch this over then.
Oh, gosh.
Hit that button, and then I've got to plug in my... And I'm just going to pull up the exhibits on the laptop while Mr. Godwin plugs them in. Okay. Good afternoon. My name is Shannon Smith, and I represent Mrs. Crumbley. I'm going to ask a couple of questions, and if I ask anything confusing, can you please just slow me down and let me know?
Sure.
Okay, thank you. It's not my job to confuse you. I want to make sure you understand each question I ask.
Okay.
The first exhibit the prosecution showed, Exhibit 24, which was admitted, is a receipt for a Derringer gun. And I just want to be clear that Derringer gun was purchased by James Crumbley, correct?
I cannot say.
If you look at the receipt.
By the receipt, yes.
Okay, so by the receipt, it indicates James Crumbley purchased the weapon.
Mm-hmm.
And
yes, I'm sorry.
And it's fair to say that Jennifer Crumbley's name does not appear anywhere on that receipt.
No.
Okay. We talked about Exhibit 25, the pistol sales record. And this was the pistol that was bought back in June of 2021. On this receipt, on this pistol sales record, James Crumbley is the person who purchased this pistol. Is that correct?
Yes.
Jennifer Crumbley's name does not appear anywhere on this pistol sales receipt, correct? No. I'm sorry?
No.
Thank you. All right, Exhibit 26 was admitted. This is a receipt from a Kel-Tec gun that was purchased, correct?
Yes.
And again, on this receipt, it indicates that James Robert Crumbley purchased the gun.
Yes.
And Jennifer Crumbley's name does not appear anywhere on that receipt.
No.
All right, I'm turning to Exhibit 27, which was admitted. This is the pistol sales receipt from the Kel-Tec that we just talked about in the prior receipt. I'm sorry, this is the sales record. The sales record indicates James Crumbley bought this gun.
Yes.
Okay, and Jennifer Crumbley's name is not listed as the purchaser, or she's not anywhere on this record, correct?
Yes.
All right, I'm going to number 28, which has been
On air and streaming live, CBS News Detroit at noon starts now. Thank you for joining us for CBS News Detroit. I'm Terrence Friday.
And I'm Meredith Bruckner. Today we're providing gavel-to-gavel coverage of Jennifer Crumbley's trial. We are going to tune into that right now. Let's take a listen.
On this receipt, this gun was purchased by James Crumbley, correct?
Yes.
The receipt does not have Jennifer Crumbley's name.
No.
And when this gun was purchased, James Crumbley was accompanied by a teenage boy and no one else, correct?
Correct.
And you were testifying that you didn't have any interactions with the teenage boy who was with Mr. Crumbley.
Correct.
And when you saw this teenage boy with Mr. Crumbley, there was nothing about him that stood out to you as unusual or weird or something that would have raised concern about selling the gun to James Crumbley with his son, correct? No. I'm sorry. The court's making a record, so it's really important we talk one at a time. I'm not trying to cut you off in any way. I just need to make sure the record's really clear.
Sure.
So I'm just going to re-ask, and I'm doing it just to have a clear record. When you saw Ethan Crumbley with Mr. Crumbley buying the gun, there was nothing about him that concerned you about selling the weapon to Mr. Crumbley, correct?
Correct.
And on that date, you vividly remember it was only the two of them at the gun store purchasing that weapon, correct?
Correct.
And again, on Exhibit 29, this is the pistol sales receipt. Jennifer Crumbley's name does not appear anywhere on the pistol sales receipt, correct?
Correct.
And I'm going to open Exhibit 30, which has been admitted. This is the firearms transaction receipt. This is specific to the November gun that was purchased, the Sig Sauer, correct?
Yes.
And on this form, James Crumbley is the only adult that filled out this form, correct?
Yes.
Jennifer Crumbley's name does not appear anywhere on this form.
No.
And the information provided was all provided by James Crumbley, correct?
Correct.
And you cannot sell a weapon to a 15-year-old who walks into your store if they came in and wanted to buy a gun, correct?
Correct.
And if you don't know the answers to these questions, I can ask someone else, but I'm going to ask you, when a parent buys a gun, you have a parent has a right to take their child to a shooting range, correct?
Yes.
A parent has a right to take their child hunting, correct?
Yes.
A parent has a right, when they own a gun, to allow their child to use the gun at things like a gun range or hunting or along those lines, correct?
Yes.
You testified that with the Sig Sauer gun, it did not come from the manufacturer with a lock, correct? A cable lock.
That was a used gun.
Okay, so the used gun did not come with a cable lock in the case, correct?
It may have.
If it didn't, you provided a cable lock
Yes.
to that gun.
Yes.
And in order to take a cable lock off a gun, you have to use a key, correct?
Yes.
And the key is, it's not just any key, it's a key specific to that cable lock, correct?
Yes.
And in Michigan, there is no, as far as you know, and if you don't know, you can tell me and I can ask another witness, there is no requirement that a person has to store a gun in a safe, correct?
Judge, I'm going to object. That's calling for legal conclusion.
Well, it is. It is calling for legal conclusion, isn't it? I'm assuming you guys could stipulate to that at some point, but.
Either way, it's not appropriate for this witness.
Yeah.
Okay, we'll
Yes,
take care of that
police
later.
officer, yeah.
Okay. When you sell guns to people at your store, you also, you're not required to also sell them a safe for that gun, correct?
Correct.
As a precaution, if it does not come with a cable lock, you make sure that every gun that leaves your store is sent out with a cable lock if one can be put on that gun, correct?
Cable lock or trigger lock?
Or trigger lock?
Yes.
Okay, thank you. There is not any time that you recall seeing Mrs. Crumbley at the store looking at guns, considering buying a gun, anything along those lines, correct?
Correct.
And of course, I don't expect your memory's perfect. I'm just asking by recollection, you don't recall that Mrs. Crumbley was in there.
She was not, no.
It's also not illegal for a father to bring children in or a teenager in with them to purchase a weapon, correct?
Correct.
Mr. Crumbley is not the only person who has ever been in the store purchasing a weapon with minors present, correct?
Correct.
And there is nothing that when you come to the door of the store that says minors cannot enter the store or look at what you have in terms of your stock, correct?
Correct.
May I have just a minute? Sure. I have no further questions. Thank you.
Just very briefly. Ms. Beck, I'm just going to clear a few things up. I'm afraid I wasn't terribly clear with these things. First of all, after the shooting in Oxford High School, agents from the ATF, they came and spoke with you. Would that be right?
Yes.
Okay. And ATF, that's the government agency that sort of regulates the firearms transactions.
Yes.
Okay, at least to your understanding.
Yes.
Okay. And when you, well, first of all, let me ask you this. Do you recall on November the 26th when that Sig Sauer was sold to James Crumbley, if he shopped around at all or if he went right to that gun?
He went right to that gun.
And did he make any statements about that?
That he had had his eye on
Your Honor,
for some time.
I would object to the hearsay of the co-defendant who's not present in this trial.
It's not offered to the truth of the matter, sir, to judge. It's offered to show that he went right for that gun.
Well, I guess he asked whether or not he looked around.
All right, we do have to take a short break on air from this trial of the Oxford High School shooter's mother, Jennifer Crumbley. You can continue to watch Gavel to Gavel coverage on the stream. We'll be back shortly.
621. was for cash or for credit?
It was cash.
Cash, okay. And you did that by comparing the receipts on November the 26th, and there were no credit or check transactions that have been made in the amount of $519.35.
Correct.
Okay. Thank you, nothing further.
Can I ask you, there's also an Exhibit 31.
Oh, that's going to come through Agent Brandon.
Okay, I just wanted to make sure you didn't have to bring this witness back. I'm an excuse, right?
Thank you.
Thank you, Judge.
Step down and excuse.
Thank you.
Your lunch is here. Okay. The fact that we're providing lunch doesn't mean that you can't leave the building or go out to your car or do things like that. I want to avoid any interactions in the cafeteria that could impact you. I don't want people talking to you, and I just want you to feel comfortable. All right. So your lunch is in the cafeteria. There's an hour. We'll come back at about. You can return to the jury room at 10 after 1. Your lunches are in the jury room. Don't discuss the case with anybody. Don't do any research. Don't go on Facebook. Don't.
Welcome back. Our coverage continues of the trial for Jennifer Crumbley, the mother of the Oxford school shooter. Some of what you may hear and see could be disturbing.
All right, for the jury.
All right, well, we just came back from break, but now they're going on one.
Right.
So
These things, we can't predict
Yeah.
exactly how the court is going to make sessions. So as we understand, they are going on a break. Do we understand this is a lunch break, or is this, do we know?
I think it's probably
This is probably the lunch break we're saying here. So we are going to have a break. We'll be discussing this in studio with our legal experts. But first, we wanted to point out a moment that happened this morning earlier. An outburst in the court. The prosecution was upset, saying that the defense attorney was sobbing during the testimony of a witness. Let's take a listen to that moment.
Judge, first of all, I was not sobbing, and this is horrific. I've
never seen this before.
It's horrific. That's why we asked the court not to play it. This is horrific. I don't know how the prosecutor. She's watched it 100 times with these witnesses. It's horrific.
You've had this video for over 2 years.
I don't know. I don't have this video. I have to go to their office to watch it.
You've seen it?
No, I haven't, because it's not necessary. It's not relevant to my client's case. We've already litigated this, but we're doing our best. We were not sobbing or making the scene in any way. All my eye makeup's still on. I checked my camera.
I'm not having.
I need to run to the bathroom. I need a break.
Okay, we're having a break. That's what we're doing.
All right, we're seeing those moments there from that attorney. We'll start with your reactions to that. Lillian, what is your reaction to what we saw play out earlier?
It's very disappointing, and maybe she's trying to find her sea legs right now, okay, but sobbing, I don't know what was going on, but it was enough for the prosecutor to take note, and then you say, it's horrific. I don't know if the jury is still there, right? So now we know
they were not there.
They were gone,
yeah.
But it's horrific. So just think about the poor jurors, right, that have to see that. And yes, it's horrific, but we are defense attorneys, right? We see this, and we don't comment. That's the prosecutor's job, to point out how horrific it is. And, you know, hopefully she's getting better with the last witness. She seemed to be finding some kind of footing, so when she asked a relevant question, she could get back on track. So I just hope she's back on track.
It's not clear if that was a genuine emotional reaction or if it was theatrics, but Is this harming her client?
Yeah, either way, it's ridiculous. But what's more appalling is the admission that the defense attorney made that she hadn't seen the evidence prior to trial. So it's the first time she was exposed to it, which is why she's claiming that she was overcome, because it's her first. It's the first time that she had actually seen the evidence. But her excuse was for not viewing it is not relevant to my client. There is an abundance of evidence in this case, and there will be, that is not exactly directly relevant to her client, including the first two witnesses that had nothing to do with her client. So later there'll be a bridge from the first witnesses regarding the actual incident to her client. But right now, there's an abundance of evidence that's being offered, including the last witness regarding the gun, that don't directly affect her client. And so if that's her excuse, that she hadn't viewed the evidence that doesn't directly impact her client, there's going to be a lot more evidence that she didn't review in this case, which is absolutely both unprofessional and misconduct.
Also seems to be a few contradictions thrown out. There have been a couple times where she will stop the prosecution and say, this has nothing to do with my client, when they're referencing James, but then she'll say, well, James bought the gun, or James did this. So your thoughts on that?
So what she's trying to do is create a clear bridge and a clear box here. So what's the box? My client did not have anything to do with the purchase of this weapon. She wasn't at the store. She had no, this is James Crumbley, all his doing. She's just a poor innocent ingenue in this whole situation, right? But the problem is, she's at the shooting range with him, and he's showing her how to use the gun, and you're posting, we're testing out his new Christmas gift. So I understand a little bit about how she's doing it, but she got to kind of stay away from grievable issues.
Not to mention there's 400 pieces of evidence. We've barely gotten started.
Right. One of the things that's important to recognize in the course of a trial in general is the prosecution has the burden of proof, so they go first. They do direct examination. The direct examination is getting the where, what, who, where, when, and how. The very general questions. What happened next can be, can take a witness all the way through a direct examination. The star in the testimony is the witness. In cross-examination, the star, if you will, is the prosecutor who's getting the evidence out through his or her own, essentially, testimony. You didn't do this, you didn't do that, isn't it true that, that kind of thing. Then there's something that's very important called redirect, where the prosecution can go back, and they did in this case. And in this case, one of the things that the prosecution didn't do, that the defense opened up the door to, the defense said, well, it's the parent's legal right to take him hunting. It's the parent's legal right to, well, the door is open there to say, well, is it the parent's legal right to allow their child access to a weapon if he's mentally ill? Is it the parent's legal right to allow emotionally disturbed child who has all of these defects and has said that they wanted to kill themselves in the past or seen demons in the past to have access to a gun? Are you aware, ma'am, whether or not Jennifer Crumbley, the defendant in this case, was in the car at the time the gun was purchased, or in another part of the store at the time the gun was purchased? Because she didn't come to the counter doesn't mean she wasn't there and wasn't knowledgeable about the gun. None of those questions were asked on redirect, and the door would be open. That's why it was better in this situation, in my opinion, that this defense attorney not ask any questions. All of the questions she asked and the information that she extolled from this witness could be used on closing, in closing argument. She can hold it up. You don't see her name on here. She could do that repeatedly without asking any questions.
Okay, well, thank you both so much for your insights. We will continue to cover this trial as they go to lunch break, and we are also going a short break. We'll be back soon.
Welcome back to CBS News Detroit at noon. Time for a look at that extended forecast. Karen Carter is here with us with a look at the foggy conditions that we are seeing right now.
Yeah, if you can see it, right?
Barely see it.
Barely see it out there. Take a look at this next weather tower cam. Just a few minutes ago, you could actually see the roads below and some of the buildings. You could see out a fair little bit, but just within the past few minutes, it's gotten more foggy, and that's going to kind of be the case throughout the course of today. Here's a look at our dense fog advisory. It was supposed to expire at 11 this morning. It is now pushed back until 10 o'clock this evening, still for all of southeast Michigan, and still, in fact, for all of the lower half of the lower peninsula. So if you're traveling today, be careful out on those roads. We'll see that fog continuing. This is a quarter mile or less at times. Here's a look at our radar. We are seeing, oops, let me go back one. There we go. A little too far. Here we go. So radar right now is showing nice and dry conditions, a little bit up north just along the bridge, but we are going to see dry conditions through a little bit of today. Through most of today, not until tonight, about 7 o'clock, are we going to start to see that rain beginning to move in. We're going to see that rain throughout the course of the overnight hours. Heavy at times. We could see around a half to 3/4 of an inch of rain overnight. And with the warmer temperatures, with the rain, and with the snow that we still have on the ground that's going to be melting, we can see some minor flooding into Friday and even into the weekend just because of all of that melting. Taking a look further into tomorrow, we'll see that rain continuing through the overnight into tomorrow morning. Most of it moving out by around 8 o'clock. We should stay predominantly dry through the day tomorrow, but we could still see a brief shower move through the area. Most of us staying dry through the day on Friday, and we'll stay dry throughout Saturday too. Still cloudy conditions. Saturday night, though, we're going to see a mix of snow and rain move through, and that's going to last into Sunday morning. So taking a look at the precip chances over the next few days, we just have that small 20% chance of rain for today. Mainly it's going to be drizzle. It's going to be tonight that we're really going to see that rain into Friday, then dry conditions Saturday, and then Saturday night into Sunday. That's when we're going to see that rain-snow mix. Small chance of a little bit of rain then on Tuesday. Here's a look now at our 7-day forecast. We are going to expect those warmer temperatures for not only today, but also for tomorrow as well, and even into Saturday with drier conditions. Temperatures still above normal for the beginning of next week. We'll still see those temperatures in the mid to upper 30s. Typically for this time of year, we should be at 32 degrees. Temperatures warming up on Wednesday back to 40 degrees. Maybe we'll see a little bit of sunshine for the middle of next week. We'll be right back.
Welcome back to CBS News Detroit at noon. Comedian Jon Stewart returns to his old stomping grounds, and a Destiny's Child star shines in a new Netflix crime thriller.
Danya Backus has your Eye on Entertainment report.
Mr. Malloy, this is Mia Harper. I'd like to meet with you to discuss your case.
The first full trailer is out for Tyler Perry's upcoming Netflix thriller, Mea Culpa.
If he's not lying, he is a psychopath.
The steamy flick starring Kelly Rowland and Trayvon Rhodes is about a criminal defense attorney who gets romantically involved with a client. That client stands accused of murdering his girlfriend. Tyler Perry's Mea Culpa premieres on Netflix February 23rd. Prince Harry and Meghan Markle hit the red carpet in Kingston, Jamaica for the premiere of the new Bob Marley biopic, Bob Marley One Love. British actor Kingsley Ben-Adir portrays the reggae icon in the film, who inspired the world through his groundbreaking music.
And his whole life was about music and creating music, and the energy he put into creating them songs that we all now get to enjoy. We get to receive the benefits of his genius and his creation.
Bob Marley One Love hits theaters this Valentine's Day. And Jon Stewart is returning to The Daily Show on Paramount's Comedy Central, but only temporarily. The comedian who hosted the late-night show for 16 years will serve as executive producer and host only on Mondays, beginning February 12th through the 2024 election cycle. A rotating team of correspondents will anchor the program the other days of the week. That's your Eye on Entertainment. Danya Backus, CBS News, Los Angeles.
All right, let's have another quick look at the weather with Karen.
Yeah, we still have that dense fog advisory out until 10 o'clock tonight. So we'll see dry conditions really for most of the day until about 7 o'clock tonight. Then we'll expect that rain overnight into Friday. Drier conditions on Saturday, a little cooler for the beginning of next week.
All right, thanks, Karen. Our coverage continues. Good afternoon, and thank you for joining us here on CBS News Detroit on the noon stream. I'm Terrence Friday.
And I'm Meredith Bruckner. We'll check in with next weather meteorologist Karen Carter in just a few moments. But before we do, we're continuing our special coverage today of the trial of Jennifer Crumbley, the mother of the Oxford school shooter. It's underway this afternoon, and this morning we saw opening statements and the first witness testimony.
Our Andres Gutierrez is live outside of the Oakland County courthouse. Andres, we've been watching this trial play out all morning. Lots happening. What is it like from your perspective?
Well, Terrence, just like the Miller hearing for the Oxford High School shooter, this one is filled with emotions for his mother. In fact, just before we took a lunch break there, his mom broke down in tears, sobbing uncontrollably, pretty loud in the courtroom as she was watching surveillance video of her son walking through the hallways that fateful day, walking past one of his victims, Tate Meir. Now, during opening statements, as you've been hearing all morning long, the prosecution told jurors that Jennifer Crumbley is a mom who had several chances to intervene in her son's downward spiral, but failed to do so. And because of that, she is responsible for the 4 deaths that day, even though she herself did not pull the trigger. The defense attorney, Shannon Smith, began her opening statements in a unique way, quoting that Taylor Swift song Bad Blood, saying that, quote, Band-Aids don't fix bullet holes. And in the context that the prosecutor here, Karen McDonald, is attempting to put a Band-Aid on problems that cannot be fixed by a Band-Aid, that essentially she wants to see some justice for the community as a whole, but the parents cannot do that just by putting them on trial. She argued that Jennifer Crumbley doesn't know much about the guns that were in the household at the time and placed the responsibility on her husband, James.
That's why we're here. We're not here to talk about good parenting or bad parenting. It's not illegal to be a bad parent. We're not here to put restrictions on gun owners. That's not our job. That's not your job. That's for lawmakers. We're not here to talk about who else might be culpable or who else you think shares some blame. You will learn about the meeting on November the 30th. You may not like the fact that neither the school counselor nor the dean of students searched the school shooter's backpack. That's okay. That's okay. Because that does not mitigate Jennifer Crumbley's culpability.
When she saw the materials in this case, she learned that her son had not been her son for months, that he had been manipulating her, that he had been hiding things from her, that he had been sending text messages, alarming text messages, to other people. You will hear that the school never advised Mrs. Crumbley of problematic issues that if she had heard about, she would have jumped right on top of it. Despite the fact the evidence will show that Mrs. Crumbley is on power schools, managing missing assignments by her son in his grades, the school never told her about times the shooter was trying to sleep in class, about a test he had failed, about the shooter being called to the office. She was never informed.
And so far, we have heard from 3 witnesses, starting with Molly Darnell, the teacher who was wounded by the shooter that day, Christy Gibson, the assistant principal who encountered Tate Meir that morning and then that afternoon rather, and then also the employee of the store where James Crumbley bought the gun on Black Friday that the shooter eventually used that day. These 3 witnesses are part of the more than 100 on the witness list that we may hear over the next course of the 2 weeks. Reporting live in Pontiac, Andres Gutierrez, CBS News, Detroit.
All right, thank you, Andres. We will be checking in with you throughout the day from there for updates. Now, as Andres mentioned, that Taylor Swift moment in the courtroom. Let's take a listen.
On my way to court today, I blasted Taylor Swift to warm up my voice and calm my nerves. And there was a line in one of her songs that summarized what this case is about. Band-Aids don't stop bullet holes. And that's what this case is about. It's about the prosecution attempting to put a Band-Aid on problems that can't be fixed with a Band-Aid.
The prosecution has charged Jennifer Crumbley with involuntary manslaughter in an effort to make the community feel better, in an effort to make people feel like someone is being held responsible, in an effort to send a message to gun owners, and none of those problems will be solved by charging Jennifer Crumbley with involuntary manslaughter.
Smith continued on to say, quote, a Band-Aid will never bring back the lives that were lost by Hannah, Justin, Tate, and Madison Baldwin. So just to recap, Jennifer Crumbley is charged with 4 counts of involuntary manslaughter.
She and her husband, James, are both accused of ignoring warning signs and failing to prevent their son from going on a rampage. He killed 4 students and injured 7 others at a Michigan high school in 2021. Elaine Keano has more.
The defendant shall serve the rest of his life without the possibility of parole.
1 month after their son was sentenced to life in prison, the parents of school shooter Ethan Crumbley are standing trial themselves.
There are a number of warning signs that the prosecution is going to point to and say that the parents' actions amount to involuntary manslaughter.
The prosecution alleges Jennifer Crumbley and her husband James ignored their 15-year-old son's mental health struggles, including troubling drawings, and even bought him a handgun as a gift.
This is the gun I'm going to use. This is 2 weeks before the shooting.
On the day of the shooting at Oxford High School, prosecutors alleged the Crumbleys refused to take their son home after a teacher reported seeing him search for ammunition on his phone, prompting Jennifer Crumbley to allegedly text her son, "You have to learn not to get caught." Several days after the shooting, James and Jennifer Crumbley were arrested in a Detroit warehouse where police said they were hiding. They've been held in jail since, unable to post bail, with James Crumbley being tried separately in March.
The fact that the parents are not standing trial together is not rare, but I absolutely think it indicates that they expect to point the finger at each other.
It's also possible for Ethan Crumbley to take the stand in both his parents' trials.
His attorneys have advised him not to testify, not to provide evidence. His parents' attorneys obviously want him to testify and say, I am the one who is responsible for my actions. It was not my parents.
The jury for Jennifer Crumbley was seated yesterday. It's made up of 10 women and 7 men. Both parents have pleaded not guilty to involuntary manslaughter charges. And here in Michigan, that charge carries a maximum penalty of 15 years in prison. Elaine Quijano, CBS News, Pontiac, Michigan.
All right, switching gears here, we're going to get a look at our local forecast with next weather meteorologist Karen Carter.
Yeah, it's quite foggy out there today. We've seen the extension of the dense fog advisory continuing into tonight, but take a look out at our next weather tower cam. It's really been changing over the course of even the last hour. We've been seeing a little bit more visibility to practically no visibility out there at all. Take a look at the visibility in the area. We have less than a mile in Detroit, a mile in Pontiac, Howell, also in Monroe, less than a mile in Ann Arbor and Adrian, a little bit more as you head up to Mount Clemens, even Port Huron and Lapeer, but still less or around 4 miles in Mount Clemens and Port Huron as well. So still not much. We're going to be continuing to see that throughout the course of today. So that dense fog advisory is going to be in effect still for all of southeast Michigan until 10 o'clock tonight. Now, we could see a little bit of mist or some drizzle along with that throughout the course of today, but predominantly dry conditions. Here's a look at our next weather satellite. You can see the clouds here all the way from our area down south, but really what I want to show you is that you can see the boxes a little bit better. Those gray lines that you're seeing all over, that's all dense fog advisories. And they're really throughout a good portion, not only of the Midwest, but also towards the east and even as you head down south, even still into Texas. So really spanning a good portion of our nation. Right now, we are staying nice and dry throughout southeast Michigan. That's really going to stay throughout the course of today until tonight. So we are going to stay predominantly dry. Like I said, you could see a little bit of mist or some drizzle because of that fog, but otherwise we'll see temperatures in the upper 30s today. Not until about 7 to 8 o'clock tonight are we going to start to see rain moving into the forecast. I'll talk more about that rain coming up in your next weather forecast.
All right, thank you, Karen. Staying with weather this afternoon, parts of the south are under flood warning as powerful rain from the west sweeps across the country.
CBS's Jared Hill has a closer look at those conditions.
This morning, the south is sopping wet as a storm system dumps inches of rain. Floodwaters in Houston left this man stuck on top of his car, the rescue coming just in time.
There you go. There you go. Good.
Northwest of the city, a whopping 10 inches of rain over the past 3 days washed away roads like this one leading to a neighborhood. Drivers in Covington, Louisiana, north of New Orleans, pushed through flooded roads. And further south in Mandeville, flash flooding left cars like these abandoned alongside the street. The National Weather Service asking drivers to avoid traveling across the North Shore if possible due to unsafe conditions. In Columbia, Missouri, a blanket of fog cut visibility to a quarter mile or less. The wet weather washing across the south, leaving thousands with flood warnings, is the same system that slammed into San Diego. In Northern California, dramatic new video shows a helicopter rescuing a woman stranded for 15 hours when her car flipped in rising water.
It could have had a whole different outcome. She could have been swept downstream, but strong enough to get up on top of the vehicle.
According to NASA, a warming climate will make situations like this a more constant presence. For every degree Celsius of warming, they say the air can hold 4% more moisture, which can mean more rain and more flooding. Jared Hill, CBS News.
Terrifying footage there. Now, where the rain may have stopped, there's still a concern that rivers will continue to rise. That means the threat of flooding continues.
I-75 is back open after an accident last night that left one Michigan State trooper dead. It happened on northbound I-75 at Birch Run Road in Saginaw County. Michigan State Police say troopers were conducting a traffic stop on a suspected drunk driver in a curved lane. That's when an elderly driver hit two patrol cars. Tri-City Post Trooper Joel Popp was standing outside of the car. The 39-year-old was taken to the hospital where he later died. The 81-year-old driver who hit him has serious injuries but is expected to survive. Popp is the 56th Michigan State trooper killed in the line of duty.
Now to an update on a story we've been following since the beginning. The suspected vehicle involved in a fatal hit and run in Superior Township has been found. The Washtenaw County Sheriff's Office says no one is in custody yet, but they have identified the person involved. Sunday morning, the Sheriff's Office was called to the area of Prospect Road and Park Lane, where a 53-year-old woman was found dead. Pieces of the suspected vehicle were found near her body. Now, the Sheriff's Office say this is still an ongoing investigation.
Detroit police now looking for this woman caught on video smashing a window with what appears to be a crowbar. That video was captured at Martin Luther King Apartments near downtown. This happened around 2 early Saturday morning. If you recognize the woman in this footage, DPD wants to hear from you. You can reach them at the number listed there on your screen, 313-596-5700.
And now to your health watch, the racial gaps in dementia treatment and a new way to detect if a baby will arrive prematurely. Michael George has the day's top health stories.
Researchers in Chicago have developed a way to use ultrasounds to predict the risk of a baby arriving prematurely. The new method measures microscopic changes in a woman's cervix. Doctors say the ultrasound technique works as early as 23 weeks into pregnancy. There are significant racial and ethnic disparities in dementia care. That's the finding of a study from UC Davis Health, which shows minorities are less likely than white patients to get an accurate dementia diagnosis or be prescribed anti-dementia medication. The authors say more research is needed to understand the reason for the disparities and how to fix them. A new facial recognition app is being used on dogs to improve rabies vaccination rates. Researchers from Washington State University used the app at a rabies clinic in Africa. When they later visited surrounding villages, they were able to tell which dogs were vaccinated and which ones still needed protection from rabies. Those are some of the day's top health stories. Michael George, CBS News.
Watch CBS News Detroit.
It's all right here,
right now, with breaking Southeast Michigan news
and next weather updates.
Just open the free CBS News app, select live, and then look for CBS News Detroit. On your block, around the clock.
Welcome back to CBS News Detroit at noon. Those foggy conditions seem to be sticking around.
Yeah, they're going to continue to stick around throughout the rest of today and even into tonight, too. At least we're going to see a little bit better conditions, hopefully, as we head into the weekend. Here's a look at the next big thing, though. We are going to see rain tonight, and that's going to last into early tomorrow morning. But we are going to see it drying out throughout the course of Friday. So Friday, we'll have a high of 41 degrees. We'll see it drying out a little bit. Then Saturday night into Sunday, we're going to have a mix of some rain and some snow. And then we'll see some scattered showers. Then on Sunday, temperatures a little bit cooler, and we'll have a little bit of wet weather, especially in the morning. Here's a look, though, right now at our next weather radar. Right now, nice and dry, but we are seeing that fog still in the area. We'll continue to see that throughout the course of this afternoon, so you could still see some mist or some drizzle because of that fog, but overall dry conditions. And I mean that we're not going to see the system move in until a little bit later on this evening. Not until about 7 o'clock are we going to start to see that rain really pushing through. A little bit heavier rain throughout the overnight hours. We could see about a ½ inch to 3/4 of an inch of rain. That's going to help with the snow melting overnight as well, and even into tomorrow. It looks like it's going to pick up, though, and move out of our area by around 8 o'clock. We'll start to see more dry conditions. Still a chance that you could see a brief shower throughout the course of the day, but overall drier conditions on Friday. Definitely on Saturday, we'll see cloudy conditions throughout the day on Saturday. Not until overnight, Saturday night into Sunday, you can see that snow and that chance of rain moving in. We'll see that throughout then, especially Sunday morning, but still a chance of some scattered showers throughout the day on Sunday as well. Here's a look at the temperature trend, though. Well above normal still for this time of year. 32 degrees is where we should be. We'll still be in the 40s throughout the course of today, even into tomorrow and Saturday. Then we'll start to see those temperatures dropping off a little bit, but still above normal, even if we're in the mid to upper 30s. We'll see those temperatures picking back up into the 40s, though, for the middle of next week. Now, if you are traveling out to California for the big game on Sunday, well, here's a look at what you can expect there in Santa Clara. 65 degrees. That's actually where the game is going to be. 65 degrees on Friday with partly cloudy skies. 66 on Saturday with mostly cloudy skies. And the time of the game, that's California time. 72 degrees with mostly sunny skies. A little bit different here. Here's a look at my Motor City meter for today, though. I'm going to give it a 2. Foggy conditions, overall dry conditions throughout much of the day. We won't see that rain until a little bit later on this evening. So 40 degrees are high today. Foggy conditions then tonight. 36 our overnight low with that rain. Your 7-day forecast showing us still in the 40s. Rain tonight into tomorrow, and then we'll see dry conditions into Saturday. Temperatures into the 30s. We'll see another round of rain and snow Saturday night into Sunday. A little bit warmer by the middle of next week.
All right, all that fog and rain, but I can't complain because at least my face doesn't hurt.
Right.
From all the
We
cold.
had those negatives.
It feels balmy now in the 30s. It's pretty nice.
I know.
I'm gonna put on some shorts.
Just need a jacket.
Thanks, Karen. All right, joining us now is Carol Kane, the producer and anchor of Michigan Matters.
It's a program that tackles politics, business, education, sports, and community issues every week. Thanks so much, Carol, for being here.
It is great to be here, and all these things are playing out this week, and we'll be on Sunday's show.
It really, it's a jam-packed show on Sunday, so tell us a bit about it.
So we have the Chinese Consul General coming in to talk about growing connections between Michigan and with China, between the auto industry and other things. It's a huge part of our economy here. Then we also have the political roundtable of Jill Alpert, Chris Holman, and Mayor Brian Barnett of Rochester Hills, talking about Governor Whitmer's the state speech and also the presidential contests, which, oh my, with all the things going on with the primaries and the caucuses and Donald Trump in and Haley's still in there, Nikki Haley's still in, it's like, oh my gosh, what a moment.
Yeah,
so much
quite a
ground
bit
to
watch.
Yeah,
We'll be tuning in.
Well, and also too in Michigan, there's a lot of conversation after the governor's State of the State speech, where this was her 6th State of the State speech. She talked about the roads, which is where if you remember, this is how she came to power, and then she ended up talking about education, which she's also been pushing. Early education, having free community college, but a big thing, a point of contention that's going to cause lots of conversations in business, political circles, having monies to be able to entice businesses to come to Michigan as other states like Indiana, Ohio do, because Michigan is not spending the kind of money that other states do, and frankly puts them at a disadvantage when a company is coming in, whether it's an American company looking to move or someone from China or another country looking. They look at those things like incentives. They do play out and they do have an impact.
Yeah, and these are good things to listen into because this really affects all of us. Based on the conversations that you've had so far, anything that sticks out that viewers need to make sure they're listening for?
Here's what I want everybody to know. The Detroit Lions, this Sunday, we'll be talking about the Detroit Lions. Oh my gosh, who would have thought? I admit, they're a great team. I was not among the believers that thought they'd make it this far, but they're going for the NFC Championship Sunday, and if they do, we'll all be doing a big sigh of relief that they're in the Super Bowl. So that's a big thing everybody's looking at right now.
It's true.
We'll be hearing a lot of Lions roaring all over the place.
Yes, we will. So remind us when we can catch your show.
You can watch it at 5:30 a.m. on CBS Detroit, and then it also runs at 12 noon on CW 50, Channel 50, WKBD. So many different name changes, but 12 noon on Channel 50.
Well, Carol, you do such a great job, and you're always having such important conversations that impact the community, so thank you for the work that you do.
I appreciate being with you guys here. This is great having you together here.
This is great. We're enjoying it, but certainly a difficult day ahead in terms of the trial that we're
it's heartbreaking, heart-wrenching, and this is going to set the national tone for a lot of things, I think, in this gun control conversation as well. But conversation for another time.
Very good points.
And they will be picking up in the courtroom around 1:10 today, and we'll have that coverage for you here over the air on our website, cbsdetroit.com. We have to take a quick break. Carol, again, thank you. We'll be right back.
Watch CBS News Detroit with breaking Southeast Michigan news.
And next weather updates.
Better informed.
Better prepared.
Open the free Pluto TV app, scroll to local news, and choose CBS News Detroit. Then just add us to your favorites.
You're watching CBS News Detroit.
Welcome back. We're going to have some conversation about beverages now. Get this, Great Britain and the United States, as you take a sip, are at a boiling point over tea.
Yeah, how dare you?
Oh, I like the accent.
U.S. scientist claims that the perfect cup is made with a pinch of added salt. Michelle Frankel says the tiny addition isn't enough to taste, but just enough to cut that bitterness.
Interesting. You'd think that sugar would do the job, right?
Well, she's in hot water about this.
Yeah, she is. Brits are furious their national drink is being messed with by Americans who prefer the iced variety or even coffee. The U.S. Embassy in the U.K. has distanced themselves from the idea and ensured adding salt to tea is not official U.S. policy.
You know, it's you people loving all that salted caramel, just spilling over to the tea now.
Yeah.
Spilling over. See
Oh,
what
I
did
like
there?
it. I like it. Okay.
All right, we have to take a quick break. We're going to refresh our tea. We're at 5. Stay with us.
When it comes to Michigan, most people know the state's rich music history.
And according to the Anderson Economic Group, music actually brings in more than $1 billion a year into the state's economy. Amir Jacobson is on your block in Allen Park, where one man is actually taking his talents to the world of guitars.
It happened a long time ago. Wanted a guitar and couldn't afford to buy one, so I made it. A friend had a book of how to build a guitar. It was like 4 pages. It took me like a year to do the first one, but then somebody saw that, said, could you build me one? And gradually became like a full-time job.
Gary Zimnicki spends a lot of time in his workshop.
It is absolutely a passion. It's always on my mind, even when I'm not out here. I really love what I do. It doesn't feel like work when I'm out here most days, except when things go wrong. Yes.
Which doesn't happen often. Gary has handcrafted around 450 instruments.
I like the craft of it, just, you know, the challenge of making clean joints and making pieces butt up against each other perfectly without any gaps and that kind of thing.
Creating a custom sound that he says you just can't find in the big box stores.
If you buy an internet guitar, they're not set up right. They're hard to play. They don't sound good. And the difficulty playing it especially, I think, turns people off. And so they'll, you know, play a few chords and then they put it down and never pick it up again because it's too much work. Whereas if they have something that was handmade and set up properly, it just plays so much easier.
To Gary, supporting small business is crucial.
Small businesses are the backbone of the country these days. I think it's very important to support small businesses, especially when they can provide something that a large retailer can't.
Leaving a financial impact and a long-lasting legacy for years to come.
It's a humbling thing, you know, that, like I said, that my instruments are gonna outlive me, hopefully by quite a long time, and that at least some couple of people are gonna know my name a long time from now.
In Allen Park, Amir Jacobson, CBS News Detroit.
A former Children's Hospital patient from Shelley Township is now helping other patients cope with their illnesses after enduring his own. He's paying that kindness forward through Jacob's Bravery Box. CBS News Detroit's AJ Walker is on your block at Children's Hospital of Michigan in Detroit with the inspiring story.
We have a toy, we have a picture, we have a box of Band-Aids.
7-year-old Jacob Ethemu knows what it means to have to be brave. In 2020, he was diagnosed with the medical condition HSP, inflammation of the blood vessels in your skin, joints, intestines, and kidneys. Now, he's proud to talk about his finest accomplishment. These bags that are giving hope to children who, like him, need to have medical procedures that involve needles.
And I didn't want to get an IV, so then they said, after you do it, you might get a little prize, and after I got a Spider-Man toy, so I said, what if other people feel scared? So that's when I made Jacob's Bravery Box.
Jacob's mom says ever since the very first bag they put together, they knew they were doing something special.
That it would maybe take them out of that element for a minute and let them celebrate something, I think was really exciting.
So this is one of the rooms at the hospital where a child could find themselves facing a needle, which can be scary and painful. But when they know at the end of it they can be getting a bag from Jacob, it gives them something to look forward to. Dr. Rosanna Baracco of Children's Hospital of Michigan has seen the simple but powerful effect this gesture has on young patients.
Their face just lights up. Immediately their focus is now on what they just received and not on the pain that they might have to go through.
Jacob's mom says his second grade class helped to stuff these because they were inspired by Jacob and now want to help other kids as well. Reporting in Detroit, I'm AJ Walker, CBS News Detroit.
Homes all across Detroit are seeing an increase in prices, but there's plenty of affordable properties around the city. They just need a little TLC. Here to tell us all about what to look for when buying a fixer-upper is Jay Halliburton. Thanks for being here with us this morning.
Thank you for having me.
And Jay, you have deep roots in Detroit.
I do.
Yeah, where'd you grow up?
I grew up on the east side of Detroit.
Okay, so tell me all about what you're doing with buying these cheaper homes, flipping them, and then allowing people to live in them.
Okay, so we got started back in 2017. A group of me and my college friends, we got together, we put some money in a pot, and we purchased our first property through the Detroit foreclosure auction. And from that, we just grew a little bit more. We started renovating these properties, started trying to make a difference in our communities.
And so now it's Jay Buys Detroit.
Yes,
I mean, this
is
is a labor of love for you, I would imagine.
It is.
Yeah. So tell us about the process. What should people look for if they're trying to buy a cheaper home as well?
So it's 5 things that I like to pay attention to. I call them the big 5. It's the roof, it's your plumbing, it's your electrical, it's your HVAC, and it's your foundation. So out of those 5, I think the 2 most important are your roof and your foundation. So if you're looking at your roof, you want to go to the attic and you want to see if you see any daylight. Any daylight in the roof shows you that you have a roof leak somewhere. You can get moisture in there, so it'll be a problem later. Also, if you see any curling shingles on the roof, that can be an issue. Now with your foundation, you want to go in the basement and you want to see if you see any cracks. Any cracks in the walls or the basement tells you that the ground around your house has been moving, so you might have some issues later.
Okay, those are great tips for people to look out for. You went to Cass. My
I
mom
did.
would love that.
Go green.
You went to Michigan State.
Go green
Don't
again.
love that.
Oh.
But what made you want to get into real estate?
It's a lot of different things. Part of it is my entrepreneurial spirit. Another one is me wanting to make a difference in my community. I know it was a point in time where people wouldn't even touch these Detroit houses, like it was so blighted. So a group of me and my friends, we said, hey, we're from here, we want to make a difference.
And there's another component to your company, a really big part. You help people become homeowners.
I do.
Tell me about that and why that's so important to you.
It's very important because you got to get back to your community. You want to be able to keep the roots in Detroit, like you said. So we help people. We help people with their first investment properties. I'm a licensed realtor, so I help people get into retail properties. It's just very important for us.
How cheap can people find homes on the land bank in Detroit?
You can find homes for as little as $1,000 on the land bank in Detroit, but these houses are going to have a lot of issues. So if you're not really too experienced in the rehab, you may have some issues yourself.
And so for young people who are looking at you and they're like, he's an inspiration, I want to do what he does, how can they get started?
They can visit the website at jbossdetroit.com. They can, of course, save your money. I would say find a good contractor. That's going to take you far. Or if you don't know any good contractors, you might want to look and get into the trades yourself. That's one of the things that I tell my younger brother, like, hey, I want you to get in some of these trades so you can be able to fix these properties.
And so where can people find you? Tell us all about your social media as well.
Again, you can find me on my website at jbossdetroit.com, or you can go on Instagram where I give a lot of tips and tricks to the trade at j_Halliburton.
All right, Jay, thank you so much for being here with us.
thanks for joining us for our stream of the Jennifer Crumbley trial continuing. The break is over. Court is resuming.
Yes, they went into a lunch break. As we see the court's coming back, they're getting into their places. Some interesting moments this morning to mention, particularly the defense attorney getting emotional and pretty much demanding a break. That was an interesting.
Yeah, she seemed overwhelmed by some of the evidence that has been presented. A couple of those witnesses have been brought up. We've been told that there are at least 25 plus that could be taking the stand. So we're going to listen in as things continue. We're checking to see, do we have audio at this point?
See if we can hear that.
All right, we're going to listen in. Do want to warn you that some of this information could be graphic and disturbing to hear.
Your Honor, calling People v. Jennifer Crumbley, case number 22279-990-FH.
Karen McDonald, voting in progress. Karen McDonald, appearing on behalf of the people.
Thank you, Mark Keith, on behalf of the people.
Thank you. I'm Shannon Smith on behalf of Jennifer Crumbley. Please let us know.
Sean Gottman, on behalf of Jennifer Crumbley.
All right, you can be seated. I wanted to let you know that my colleague, Judge Brennan, has been conducting a jury trial this week that she started on Monday. No one else in the courthouse was permitted to conduct a jury trial while we were doing this one, but she did pick a jury on Monday. I just learned that 3 jurors on her trial were approached by media and asked if they were jurors on the Crumbley matter. The Sheriff's Department is conducting an investigation. As we know, jury tampering is a crime. If I find out that anyone approaches a juror in this matter, they will immediately be taken into custody and ordered to appear before Judge Warren. This is not a threat. I'm going to bring the jury in, okay?
Thank you, Judge.
Judge, just so the record's clear, our next witness is Agent Brett Brandon. Counsel's indicated that she has no objections to any of the exhibits. I'll make that record for you.
Okay. And that's correct.
discussions with you. So if someone approaches you, you should tell me right away. I heard some things that I heard that a juror in the case that was selected Monday was approached, and the sheriff's department is doing an investigation with regard to that. So if anything like that happens, please let me know immediately. All right?
Judge, not by allegation isn't by a lawyer. Just
no,
related.
No, it wasn't. It wasn't by a lawyer. It was alleged to have been by someone from the media who thought that jurors for another judge were jurors for this case, and it was someone from the media. So I just want to let you know that, some people do not follow my orders. All right. Who's next witness?
Special Agent Brett Brandon. And Judge, for the record, we did speak with counsel.
That's correct. I just was checking the number. Thank you. I'm sorry. Third one was listed as, but you're going to do it through.
Yeah.
Okay. Thank you.
Yeah.
Thank you. Okay.
Could you raise your right hand? Do you swear or affirm the testimony you're about to give the truth, so help you God?
I do.
Could you pull the door toward you, have a step up, have a seat? Could you state your name for the record and spell your first and last name?
Yes, Brett Brandon, B-R-E-T-T, Brandon, B-R-A-N-D-O-N.
Thank you, Judge. Good afternoon.
Afternoon.
All right, just to let everyone know, there's a lot of exhibits here, so Mark and I are going to try to do this, at least get the exhibits together to be as efficient and quick as possible. Special Agent, what's your formal title?
It's a Special Agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, commonly referred to as the ATF.
All right, and as part of as being a Special Agent in the ATF, what are you assigned to right now?
Right now I'm assigned to the Pontiac Gun Violence Task Force. It's a partnership with the Oakland County Sheriff's Office focused on investigating the criminal possession and use of firearms, specifically shooting investigations.
Okay, and for those of us who don't, or people who might not know exactly, it should be common sense with the name, but what does the ATF do?
The ATF enforces the nation's arson, explosives, and firearms laws, but as you might expect, our primary focus is on enforcing the federal firearms laws.
Okay, and does it involve state laws or regulations in any way?
Yes, so as I stated before, I'm on the Pontiac Gun Violence Task Force, and through that and other partnerships, we commonly embed with and work with state and local law enforcement on a daily basis.
Okay, so you do still enforce state laws in that capacity?
Yes, investigate state crimes, yes, with the state and locals.
Investigate, thank you. Can you tell the jury what your background and experience is?
Yes. I have a Bachelor of Arts in Political Science from Oakland University. I also went to law school for 1 year at the Catholic University of America. I then went to the ATF National Academy and completed the requisite training to become a special agent.
So you would rather be a special agent than a lawyer?
Yes.
Okay. And how many years have you been in the ATF?
I've been an agent for a little over 10 years, and I've been with the agency for nearly 15 this summer. I was a student intern working primarily in intelligence for 4 years, both in undergrad and that 1 year of law school.
Okay. Approximately how many shooting investigations have you been involved in?
Hundreds.
Hundreds?
Yes.
And you testified earlier your job is to enforce and investigate federal firearm laws, but do you have a general understanding of the state firearm laws?
Yes, I investigate crimes committed within the state of Michigan involving firearms as a part of my assignment on the task force and other previous assignments with that task force setting. Yes.
Okay. Special Agent, do you know who Jennifer Crumbley is?
Yes.
Do you see her anywhere in the courtroom today?
I do.
Would you describe what she's wearing?
She's got a gray and white sweater on, seated at the defense table in the middle.
Thank you. May the record reflect he's properly identified.
The record reflect the incredible identification of the defendant, Jennifer Crumbley.
How did you get involved in the investigation on this prosecution and one with the shooter? Can you explain to the jury how that happened?
Yes, I'm the federal agent assigned to the Oxford shooting investigation.
Okay, and let's go back to November 30th. Do you remember where you were that day?
Yes.
Where were you in the morning?
I was in the Detroit Field Division office in downtown Detroit.
Okay, and when did you first hear of the shooting?
Within several minutes of the shooting, an assistant special agent in charge at the time came into my partner and I's office and informed me that there had been a shooting at Oxford High School. He knew that I grew up in a surrounding town, was aware of the area, and wanted to inform me. I immediately grabbed my things and ran out the door out to my car and drove north.
Okay. You've responded, and part of your job, do you respond to active shooters?
Yes.
Okay. When you heard about the Oxford shooting, did anyone assign you or tell you you had to drive there and go to the scene?
No.
And did anyone else in your office at that moment go with you?
At that time, I think information was still coming in. At that time, I don't think anyone had responded yet. No.
And what made you go immediately?
I had familiarity with the area. I knew exactly how to get to Oxford High School. I'd also been involved in another investigation recently with the Oakland County Sheriff's Office at that time. I had a close relationship with them and thought that I'd be able to get on the ground quickly and help out in any way I could.
And this was the community that you're familiar with?
Yes.
Okay. About how long was it after you heard that you left the building?
Immediately. My chair was still spinning, according to my partner.
So was your partner there when you left?
No, he had stepped out for a minute.
And when he came back, your chair was spinning?
Yes.
Okay. So how long does it take you to drive from downtown Detroit to Oxford High School in a normal day?
With traffic, could be quite a time, definitely around an hour.
All right. Talk to me about once you got on the road, on the way up there.
As I started driving on the freeway, I believe it was when I got to the Troy area, the Big Beaver exit, that I began to notice other law enforcement with their lights and sirens activated, also driving north on 75 and joining somewhat of, I'd call it, a caravan on I-75, joining other people.
What was the rate of speed in the caravan?
It was fast, but it was safe.
So there was no traffic. Was everyone moving to the side of the road?
Yes, people were getting over at that time, yes.
Okay. As you drove, were you aware whether or not it was a false alarm or if it was a real active shooting situation?
As I drove, I began to receive information from our intelligence employees that it was indeed a real shooting and that we're reporting there were victims and fatalities.
Okay. Do you remember who else you talked to on the way to the shooting?
I spoke to ATF Intelligence Research Specialist Michael Malone. At one point, I also spoke to my wife.
About how long did it take you to get there?
Approximately 35 minutes.
And you arrived with a caravan of other first responders?
Yes, as I got off the Pier Road or M24 to drive north towards the high school, it was like the Red Sea had parted and everyone was parked on the right side of the road. And there was a caravan now of people coming from Auburn Hills and Pontiac, unmarked cars, marked cars, and joining that caravan to get to the high school.
Lights and sirens?
Yes.
What did you observe when you approached the Oxford High School complex?
When I arrived at the school, I saw some Oakland County deputies that I had known from prior cases, as well as other people from other departments starting to run towards the school. At that point, I don't exactly recall when I learned that the shooter was in custody, but I knew there was no gunfire going on and no one was moving as if the threat was still active. It became clear to me that not the scene was secure, but that the threat had been either eliminated or detained.
Did you see any students in the parking lot or around?
No.
Were you able to determine where the students were?
Yes, as I drove past, I believe it's the Meyer there, it seemed like there was way more cars than normal in that parking lot, so I assumed that's where they were meeting.
Okay. So you approached the building and did you enter the building?
Yes.
Which entrance? Can you pull
It would have been.
Never mind, it's going to be too much. We had a map of the school that we admitted earlier, but where in relation to that hallway did you approach the building?
I arrived at the main entrance, which would be off Ray Road, and where the parents would drop off their students in the morning or pick them up in the afternoon and the buses go. I arrived at that entrance.
Okay, when you approached the entrance, were you allowed in?
Yes, my law enforcement status was verified and I was allowed to enter the building, yes.
Okay, tell the jury what you did.
As I entered, I realized that they were on their, I believe at that time, their second clear of the building to make sure that it was safe. Again, I had worked with other individuals from the Oakland County Sheriff's Office, and they informed me that Lieutenant Willis was in charge. At that time, I thought the best use of my federal abilities and assistance would be to locate the firearm and start the urgent trace.
So I just want to stop you there, backing up. You go into the building, and when you say it was a second clear, so just to make sure everybody knows, that means the students were no longer there.
Yes, the students have been evacuated at that time, yes.
The shooter was in custody? Were you able to learn that?
Yes, during that time is when I learned that the shooter was in custody.
Okay, and what was the scene like when you approached? And how many people did you see?
There were dozens, if not 100, law enforcement officers in the main front office area of the school.
Okay, and you were told that Lieutenant Willis was the ranking officer in charge?
Yes.
Okay, this guy right here?
That's right.
Okay, and did you track him down?
Yes.
Where was he?
He was standing in front of the administrative offices in the front of the school.
Okay, and what did you do?
I told him that I was from ATF. I believe some other people let him know who I was as well. And then I asked if I could get the identifying information and physically observe the firearm used in the shooting.
Why did you do that?
So to start a trace to determine who first bought the firearm, I needed to know the make, model, and serial number of the firearm. And I wanted to physically inspect it to make sure that the information I was getting was accurate.
Okay, but it might seem like an obvious question, but that's also what the ATF does, correct?
Yes, that's our primary role in a situation like this. In addition to being, responding to the active shooter situation, that is the number one thing that we offer that other people can't start themselves. Yeah.
Okay, and so what was Lieutenant Willis's response to that request?
Lieutenant Willis brought me to where the firearm was located. It was in a trash receptacle with some other items, I believe a couple magazines and maybe the shooter's cell phone, and I was allowed to take pictures of those items and markings. And I transmitted that information to ATF Intelligence Research Specialist Michael Malone to start the urgent trace.
Okay, when you say a trash bin, this wasn't a stationary thing. This was someplace the weapon and the magazines were placed there by some law enforcement, correct?
Correct.
Okay, to basically contain them.
Yes.
All right, and had they been touched? Do you know?
To my knowledge, that they hadn't been touched. I know the firearm was made safe, and a round was ejected to make sure there was no other additional rounds in the firearm. But other than that, I don't think it had been handled at that point.
Okay, and you immediately started tracing the gun, you said?
Yes.
Okay, and then what did you do?
It was learned through that process that an individual in Rochester, Michigan had purchased that firearm.
I'm sorry, Special Agent Liz. Describe the weapon. Were you able to tell what kind of weapon it was?
Yes, it was a 6 Sauer SP 2022 9mm pistol with a specified serial number.
Okay. And I'm sorry I interrupted you, but you were able to find out who owned the gun?
Yes. So based on the tracing process, which ATF can contact the manufacturer to find out who they sold the firearm to, and that would be a federal firearms licensee. Most people call them gun stores, but they're federally licensed gun stores. Through that process, that gun store gets contacted, and then they provide the information that identifies the first purchaser of the firearm in interstate commerce. And that information identified an individual in Rochester. Two special agents went and spoke to that individual who stated they sold it back to the gun store in Oxford, and then those agents then responded to Oxford.
How quickly was that happening?
Within an hour.
They found out in an hour to go to this individual in Rochester who said he already sold it back to the federally licensed store.
Yes, I don't know how long it was between the actual start of the tracing process to when they eventually made it back to the gun store, but it was very quick.
And again, the the way you trace a weapon is what? Can you tell the jury?
Yes. So the tracing process, federal firearms licensees, gun stores have to maintain records. It's called the 4473 that shows who they sold the firearm to. They're paper copies held at the business. And so ATF would contact the manufacturer to find out who the manufacturer sold this firearm to.
But how do they identify which gun it is?
It's based on the make, model, and serial number of the firearm.
So every firearm has its own individual serial number?
Yes.
Okay, thank you. What you said agents were doing that, and they ended up at the store where the gun was sold back to, correct?
Yes,
all right.
correct.
What were you doing during this time?
At that time, I looked for Lieutenant Sam Marsban of the Oakland County Sheriff's Office. I had, again, worked with him on prior cases and wanted to see what I could assist with. It became clear that the Oakland County Sheriff's Office was beginning to type a search warrant for a residence in Oxford, the Crumbley residence on East Street. And I began gathering facts and creating timelines for Lieutenant Marsban to use in the search warrant affidavit.
Okay, and at some point did you find out what the other special agents found out from the gun store and who that gun was sold to?
Yes.
And what did you discover?
It was sold to James Crumbley on November 26, 2021. Okay.
At that point, you said you started assisting Lieutenant Marsban?
Yes.
Okay. And then what did you do?
As a part of those responsibilities, Detective Wogrowski was pulling the surveillance video of the school for the shooting, and I started to create a timeline of events and pass that information along to Lieutenant Marsban, as well as, I believe, looking for Ethan's class schedule to determine his whereabouts throughout the day.
Okay. When you learned that the gun was sold on November 26th to James Crumbley, before we get to that, how old do you have to be to purchase a gun in Michigan? Well, under federal law, how old do you have to be?
Under federal law, to purchase a handgun from a federal firearms licensee, you have to be 21 years old.
Okay, and do you know under state law?
Yes, based on my participation in this investigation and others, to buy a handgun from a federal firearms licensee, under federal law is 21. If you're buying a firearm from an individual in the state, that requirement's not there. It's not a federal law to do that. It's 18 years old.
Okay. And to be clear, we're talking about handguns?
Yes.
Okay. Were you able to determine whether or not James Crumbley or anyone else in the household had owned any other firearms?
Yes.
Can you tell the jury how you determined that?
Yes, as a part of taking part in the search warrant at the Crumbley residence, I learned that James Crumbley had previously purchased 2 firearms from that same gun store in Oxford.
Okay, and what were the names of those firearms? What kind of handguns?
There was a Cobra Classic ENT Derringer 22 caliber, as well as a Kel-Tec P17 22 caliber pistol.
Okay, I'm going to hand you what's already been previously admitted, the actual physical evidence, and we are going to, per the protocol, put our gloves on and we're handling it. Let me know when you're ready.
Yep.
Your Honor, may I approach? Okay. I'm handing you what's marked and admitted as People's 32, Exhibit 32. Can you tell the jury what that is?
Yes, this is the Sig Sauer SP 2022 9mm pistol that was used in the school shooting.
Okay, and just so the jury knows, you've made that safety handle, correct?
Correct.
Okay. And I just hand it to you for a second, just so everyone can see it. Do you know about how much that weighs? It's heavy. For me, it's heavy.
It's not a light firearm, no.
Okay. That's previously admitted.
It's Exhibit 32.
It's Exhibit 32. Special Agent, that is the murder weapon, correct?
Correct.
Okay. And what's the significance of a 9mm versus another handgun, particularly the Derringer and the Caltech?
So it would refer to the caliber. So the caliber is measured in the diameter of the bore of the firearm. The bore would be where the projectile or bullet expels from the firearm. If it's the 22, is just the measurement versus the 9mm, meaning that the 9mm is a bigger round than the 22.
Okay. I don't think they saw that. So the bore, I'll take it first. The bore you're referring to is right here?
Nope, it would be where the projectile actually would come out of.
Here.
Nope, it would be through, if you actually, this would be considered the bore, and that is the side. The diameter of that is the caliber of the specific round and firearm.
Can you just hold it up just a little bit so that the jury can see? Okay. You were able to determine that there were 2 other weapons that James Crumbley purchased, correct?
Yes, correct.
And were you able to determine when those weapons were purchased?
Yes, one was purchased on this June 15th and picked up on June 16th. That would be the Cobra Classic ENT Derringer. And then on June 16th, James Crumbley purchased the Caltech P17 22 caliber pistol, but did not pick it up till the 17th of June.
Okay, I'm going to take this for a second. And then I'm going to hand you what's People's 33. You can just grab that out of the box.
Yep.
And can you tell the jury what that is?
Yep, this is the Cobra Classic Derringer purchased on June 6th, picked up on June 16th.
Okay, can I have it for a second so I can see? Does everyone see that? Okay. So this is significantly smaller than the 9mm. What is, you said earlier, it's the caliber, but some might look at this and say it doesn't even look like a handgun. It's very small.
It is very small, and it only has a 2-round capacity for the firearm, but it is still a firearm, yes. Okay.
And then I'm going to hand you People's 34. What is that?
This is the Caltech P17 22 caliber pistol purchased by James Crumbley on picked up on June 17th.
Okay. So I've just handed you and admitted 3 separate weapons that were in the Crumbley household. This was the murder weapon referred to. You've examined all the evidence in this case. In fact, you're one of the officers in charge, correct?
Correct.
Okay. And is this the same gun that was posted by Jennifer Crumbley as a Christmas gift to her son?
Yes.
Okay. And how do you know that's the gun? Is there anything unique about it? Just looking at it.
Yes, that's the specific make and model, and obviously the serial number would be distinct as well for the purchase by James Crumbley.
Okay. And then this is the Caltech, significantly lighter. Do you know how much each weighs?
I don't know off the top of my head how much each weighs, but it is lighter than the SIG and the Derringer. Or the Derringer and the SIG or the Caltech are less than the SIG.
Okay. Can you tell me what the difference is in terms of caliber between the Derringer, the Caltech, and a 9mm? Actually, can you tell the jury?
Yes. So the Derringer on the top is a 22 caliber. The Caltech in the middle is a 22 caliber, and the Sig Sauer is a 9mm.
Okay. So what would you typically use a Derringer and a Caltech for?
Generally speaking, target practice. I guess some may use it for self-defense. I would say more than 9mm for self-defense and target shooting.
Okay, and you said you investigated hundreds of shootings.
Yes.
Okay, any multiple victim shootings?
Yes.
All right. Have you ever responded to an investigation or a scene on multiple victim shootings where a Derringer was used?
I can't say for certain if a Derringer was used, but a .22 caliber, regardless of the type of firearm, I don't believe in my career I've ever worked a multiple victim case with a .22 caliber scene.
Okay. Why is that?
This is like, again, like I said.
I would object to that. That would be speculation on why he hasn't.
Yeah, there's probably a better question. But he doesn't know why.
Can I just get some leeway and I cleared up. I'm just going to get to that question very, very quickly.
Well, because that does call for speculation. So go ahead.
Okay, thank you. What is the weapon you normally see if on a multiple victim shooting?
Your Honor, I would object to the relevance of this. This case is about the Sig Sauer being the weapon. We don't dispute that. We all know that.
Response?
My response is that weapon is more dangerous.
Your
it causes
Honor,
more damage.
I object to this record. I object to making this record in front of the jury. Ms. McDonald is using this opportunity to tell the jury information that I'm objecting to, and I'm asking if we can approach.
Okay.
Do you want us on the hall?
Actually, the hall.
I'm going to show in our case the reason why that weapon, the 9mm, was purchased and why it's significantly different. That is, and it's absolutely relevant. It has to do with
present other evidence that will show why that.
Yes, including statements of the shooter.
Your Honor, I think that's extremely.
Well, there are some statements that are coming into the trial, right?
There are, Your Honor, but there is no way the prosecutor can prove this weapon was bought to kill people, specifically by James Crumbley or Jennifer Crumbley. And this case is about Jennifer Crumbley. It's not about Ethan. It's not about James.
Okay, so part of it is about what they knew, though, right? Part of it is about what the parents knew.
Part of it is about what the parents knew, but there is no evidence to lay a foundation that my client knows anything about the deadly capability of these guns. Nothing. She has no. There is no foundation.
It sounds like an argument she's going to make in defense and in her defense, and she has a right to. I just want to be able to have my witness testify about what kind of weapon this is and what the reason you have a 9mm versus a .22.
Well, I guess a better question is that you can shoot more bullets out of that quicker. Is that what you want to know?
That and the type of damage those bullets can do.
I know a lot about guns you can make. Right?
I thank you, Your Honor.
Okay.
I'm not sure every member of the jury does, so I'm trying to explain it to people who are not familiar with firearms.
Okay, well, yeah, no, I understand that. Part of what you're saying might be argument, but it's a fact question that the SIG can eject more rounds quicker. You can shoot rounds quicker from the SIG powder.
I don't know. I don't know that that's necessarily true.
So if you just give me a couple questions.
Okay.
All right, thank you. What is the difference between the SIG and a .22?
It's the size of the round is the main difference. And
Okay, the size of the actual bullet, for lack of another.
Yeah,
I know
correct.
you say round. Okay.
Yes.
And why does the size matter?
The size matters because the larger the bullet, the bigger the hole.
Okay, more damage, whatever it is you're shooting.
Correct.
Okay, thank you. All right. You said that when the other special agents were finding out where these weapons were purchased, you were still at the school.
Yes.
And then can you talk about what you did with Lieutenant Marsman?
Yes, I was watching the surveillance video from the school documenting the shooter's path through the day as well as his actions during the shooting.
Okay. And what were you able to view?
The actual surveillance video of the shooting taking place.
And who showed that to you?
I was with Lieutenant Marsban and Detective Wogrowski.
Okay.
when you say the actual surveillance, what does that mean?
So there was an administrative office inside the high school that had the computer system with this, the surveillance video playing on a large monitor. I was in that room reviewing the footage as it played.
Okay, and we're going to get back to that, but at some point, did you actually go to the home?
Yes.
Why did you do that?
Lieutenant Marsban had obtained the search warrant at that time, and I responded to assist with the search warrant.
And when you arrived, who else was there, if anyone?
Multiple detectives from the Oakland County Sheriff's Office and also Lieutenant Marsban.
Did you actively search the home, or were you just present?
I actively assisted in the search.
Okay. Did you recover anything in the house related to these weapons or relating a case, anything? What did you find? I don't want to put words in your mouth.
Yeah, I was present for the recovery of evidence, and I also observed 2 targets on the wall in what would be the, I guess you'd call it the shooter's childhood bedroom, which shares a wall with his parents' bedroom.
Before we get to that, did you recover these 2 handguns in the house?
I was not the one who recovered them, but I was present when everything was there.
Okay.
Recovered, yes.
Were any other cases or boxes or anything related to the firearms recovered?
Yes.
Okay, I'm going to hand you what's been marked as People's 35. Can you tell the jury what? Yeah, it's admitted. Well, what that is.
Yes, this is the pistol case that came with the Kel-Tec pistol. That'd be the middle firearm on the table over there.
So this.
Yes.
And you previously testified, and through the other witness, this was purchased June 21st.
It'd be June 17th.
Oh, I'm sorry, June 17th.
Yes.
Okay. All right. And does that case have a locking mechanism?
It's not locked now. There are 2 holes in it, like most standard pistol cases, where if you needed to lock it, you could slide standard locks through each one of these holes.
Let's see this. So these holes right here.
Yes.
Okay.
Is that a cable? Is that what you do with a cable?
No, we're going to get to that, Your Honor. I promise. Okay. Can you open that case? Okay. Do you know where that case was found?
Yes, it was in the kitchen, I believe, underneath the island or in a cabinet.
Okay. And if I can see this for a second, you open it up, and what's inside this Kel-Tec case?
That is a cable lock.
Okay. Is this how it was discovered? Was this cable lock in the Kel-Tec case when this was found?
Yes.
Okay. I'm going to hand you the cable lock. And can you tell the jury exactly what that is?
Yes, so a cable lock is used as a mechanism to make a firearm inoperable, and it's something you have to defeat to operate the firearm.
What do you mean, defeat?
So you have to find the key, unlock it, or take it off in some other way to load and discharge the firearm.
Okay. When you examined that for this first time, what, if anything, did you notice about it?
I noticed there wasn't much wear and tear. The packaging didn't have many markings on it, as if the cable lock had been taken in and out. It's very wide, so taken out many times, there'd be more markings on the sides of this cable lock. It looks almost new.
Does it look like it's ever been disturbed?
No.
How many keys go with the cable lock?
Generally, you receive 2 keys on the same key ring for 1 cable lock.
Okay. Are there 2 keys in there?
Yes.
Okay. Anything else about this?
No.
All right. Have you ever opened this up?
No.
And as far as you know, no one's actually disturbed this?
Not to my knowledge.
Okay.
No.
So this is in the same condition as it was when it was found in the Kel-Tec case, correct?
Yes, that's my understanding.
Okay. Can this be used on all of these handguns?
It can be used on the Kel-Tec pistol and the Sig Sauer pistol. I'm not sure how small that cable is for the Derringer. It may fit, I'm not quite sure.
Okay. Thank you.
This is Exhibit 39,
Yeah,
the cable lock.
Oh, the lock is separate.
Yes.
Okay. Okay.
And that's admitted. All right, I'm handing you what's been admitted as People's 36. And what is that, Special Agent?
This is a black safe with a combination on the front. It was found in the Crumbley parents' bedroom on the shelf in the TV stand or dresser where they kept their TV.
Okay, how many numbers is the combination?
It's 3.
All right, and what is it set at?
0, 0, 0.
All right, what's significant about 000?
That is generally the factory default for a lot of safes.
Okay, so even though to some people who aren't familiar with firearms this might look like a box, this is actually what you refer to as a gun safe, correct?
Yes.
You'd call this a safe?
I would call that a safe, yes.
Okay. What, if anything, was found inside this safe?
Both the Derringer and the Kel-Tec pistol were located inside that safe.
Okay, I'm going to hand this back to you. And then I'm going to hand you the Kel-Tec that was found in it. And if you could place that in there as it was found, you can.
Imagine the slide was forward on this when it was found.
And then I'm handing you the Derringer. Okay. Can I see that back? Is this how these 2 handguns were found in the bedroom of Jennifer and James Crumbley?
Yeah, I don't recall the exact positioning, but both were placed in that safe, yes.
Okay. And it was closed and locked to 000.
I'm not sure the combination at the time when it was recovered. I know that the combination is 000.
Okay. Have you had an opportunity to examine this and determine whether or not the SIG fit in this safe?
Yes, the SIG is too large of a firearm. The safe will not close with that firearm inside the safe being the SIG.
Okay. Will it not close if there's one of the other handguns, or it won't fit no matter, regardless of whether another handgun was in there?
It will not fit by itself or with another firearm. It will not close.
Okay. All right. I'm handing you what's been admitted as People's 31. What is that?
This is the pistol case for the Sig Sauer 9mm pistol used in the school shooting.
Okay. So, in other words, that is the case that this SIG was sold in?
Yes.
Okay. And do you know where that was found in, where was it recovered, if you know?
It was located on the bed in the Jennifer and James Crumbley's bedroom next to an empty box of Patriot Defense ammunition.
Okay. And does that have a locking mechanism?
It doesn't have one inserted, but as the other pistol case, there are 2 holes in the pistol box that you could place a locking mechanism through to secure the case.
Okay. And
Your Honor, I would just object as to foundation for where the gun case was found, because this special agent came in after other law enforcement had pulled that case out, opened it, and put it on the bed. And so it's very misleading for this jury to hear that this gun case is just laying on a bed. And so I would just ask that there be foundation laid about how he...
Okay, I understand. So...
Could we respond?
Yeah.
Okay.
Well, Judge, he was on scene at the search warrant scene.
He was on the search warrant scene, but what she's saying is he initially the one that found that case, and was it found on the bed? Can you clarify?
It was found on the bed, but I think at least 2 times Ms. Smith said she didn't object to foundation on our exhibits, in which case it sounds like she does, because that's a foundational question. And
that's not true. I object to the question. I don't object to the exhibit. I object to the foundation about the testimony of that being found on the bed, making it sound like these parents left it out on the bed.
We're happy to have we have Officer Stoic to...
When you saw the gun case, it was on the bed?
No.
No.
Not when I was in the search warrant house, no. When I was in the house for the search warrant, I did not observe it on the bed. No, at that point, it had been moved off the bed.
Okay.
We're happy to bring that in through another officer.
Okay.
No problem. Okay.
Can we get clarification then on where he saw this gun case? I can ask on cross. I'm sorry. Never mind.
When's the first time that you had a chance to examine that, Special Agent?
I believe it was on the, with the other evidence, either on the kitchen counter or on the dining room table inside the Crumbley house once I arrived on scene.
So you saw it that day?
Yes.
Okay. And if you can place it on the ledge there so the jury can see it, can you turn it around? Is it clasped right now?
You're moving for submission, right?
It's already admitted.
I don't think it was admitted.
Oh, she stipulated to the admission. And
You know what happened? It was listed under a different witness, but we do stipulate.
Okay, thank you. Could you? Is it clasped completely right now?
Yes.
Okay. Could you? Can you? Would you mind if you stand right there?
Yep.
They're all like trying to stand up to see. So, is that okay, Judge?
Sure.
Okay. I'd like you to demonstrate how to open that for the jury. If you could just maybe place it on the ledge so that they.
They will see it.
Your Honor, we can't see it. Can we?
You can move if you want.
Okay.
You can move.
Or can we just see it maybe twice, like
Sure.
show them, then?
Sure.
Thanks. And I'm sorry, can we just see it? Thank you. Thank you.
Okay, and then if you could clasp it back. Okay, so Special Agent, I know it sounds like a silly question, but it makes a noise when you open it and clasp it back, correct?
Yes.
Okay. Well, I'm going to get to that in a second. I'm sorry, Your Honor, it's just a lot of exhibits, and I want to make sure I get to everything.
No, that's why I asked about that. So, yeah, okay.
All right. You don't have, well, do you want me to hold that for now, or do you?
I can put it on the ground.
When you heard Ms. Back testify about what is provided with somebody when they purchase a handgun, correct?
Yes.
Okay. And she mentioned materials from the ATF.
Yes.
Okay. There's a pamphlet actually provided, correct?
Yes.
Okay. I'm approaching. Is this a copy of the pamphlet?
Yes, it is.
Okay. Can you tell the jury what the title of it is?
It's the ATF Youth Handgun Safety Act Notice.
All right. And if you open up the pamphlet, what are the first two items there?
For the record, that's 37, right?
Yes.
It's a demonstrative aid 237, which is
Right. I'm going to get to it in a second. Okay.
So at the top it says Youth Handgun Safety Act Notice. The first bullet point says the misuse of handguns is a leading contributor to juvenile violence and fatalities. Number 2, safely storing and securing firearms away from children will help prevent the unlawful possession of handguns by juveniles, stop accidents, and save lives.
How familiar are you with that pamphlet?
From this investigation, pretty familiar.
Okay. And what is the purpose in the law around, if you know, why is that included in every sale?
I think the title of the pamphlet speaks for itself. It's a Youth Handgun Safety Act Notice. It's putting you on notice that not safely storing your firearms will contribute to juvenile violence.
Okay. You've had an opportunity to examine all of the evidence in this case, probably the digital evidence, the evidence from the phones, the physical evidence, the narratives, correct?
Yes.
Okay. And what did you notice when the SIG was photographed by the shooter and then a couple of the other images taken? Was the pamphlet with it?
In some photos it was, in others it was not.
Okay. And Up until recently, what did you think happened to the pamphlet that was sold with the SIG?
Your Honor, I would object to speculation.
Isn't it speculation?
I'm getting it. I would just ask for a little leeway.
Okay,
It's
why
part
is
of his investigation.
Wait, why isn't it speculation? What do you think's happened to the
Did you know what happened to it?
No.
Okay. And then recently, did you discover what happened to it?
Yes.
Can you tell the jury how?
Preparing for trial, I opened up the Sig Sauer pistol case.
This right here?
No, that would be
Oh, I'm sorry, yes.
this one
Okay.
here.
This was in the last week?
Yes.
Okay.
And I noticed that there was a piece of paper underneath the foam, so I lifted up the foam and found a receipt from what we're referring to as the gun store in Oxford for the firearm, as well as the ATF Youth Handgun Safety Act notice.
So it was under the foam in the case that the SIG was stored in?
Yes.
When they left the gun store?
Yes.
Okay. All right. Thank you. 1 moment, Your Honor. That's 37.
Okay. The one in the case is
Yes. Special Agent, what are the requirements once you've been cleared to purchase, and you do purchase a gun in Michigan, once it's cleared and checked and you're allowed to purchase it?
So
you
as a
just
part,
take it home and it's yours and that's it?
no. So as a part of this investigation and others, I am aware that when you purchase a firearm in Michigan and are given a pistol sales record by the federal firearms licensee, you do have 10 days to take that to basically local or county law enforcement.
Okay, were you able, or are you able to ever determine whether or not that was done for any weapon? How do you do that?
So there's a law enforcement
Your
database.
Honor, I would just object. May we please approach?
okay.
Okay, the audio there has been muted in the stream due to the prosecution and defense approaching the stand. They do this so that it is not understood what's being said between the judge and the attorneys there. So Richard, take us through what we were just seeing, this very long witness testimony and cross-examination about the firearms. Explain what the issues were in terms of how the defense felt.
Well, what I think the ATF agent is doing now is authenticating the actual evidence itself, where it was found, what the significance of each piece of evidence is. He's been going through painstakingly in detail in things like how to open up the gun safe, how to close the gun safe, and the combinations and the possibilities. And what it all boils down to is that There were 3 firearms in the house of James and Jennifer Crumbley. They were openly displayed. They were not locked up. They were accessible to all 3 people in the house at any given time. There were some indications that there's an ATF memo in there or pamphlet in there about juvenile gun violence that was seemingly discarded and placed in the bottom of the foam inside the case. It was not, I mean, the intimation is that it wasn't looked at or wasn't followed by the parents, and another evidence to show negligence. And so I think that the whole purpose of this witness is to show that there were these firearms available to all parties, including the shooter in this case.
Okay, well, we understand ATF agent Brett Brandon is continuing his testimony. Let's tune in.
A law enforcement database that state, local, and federal have access to, that you query the serial number of the firearm, and it determines, it'll pop up who the firearm is registered to if it's registered.
Okay, and did you do that?
Yes.
Okay, and so the Derringer, was this registered?
No.
Okay. And the Caltech, was this registered?
No.
Okay. And then the SIG, was that registered?
No, it was not, but I will say that there is a...
He had some time to
He had some time to still drop it off after, but there were events that occurred. Obviously, the shooting happened within that 10 days.
Right. Thank you. One moment, Your Honor. So we previously admitted the trigger lock statement, and Mark's going to try to pull that up and keep track of. There it is, and it's People's 38. Whose signature is that, if you know? What's the name on the?
So this form was provided by the gun store in Oxford during the purchase. It was filled out by both James Crumbley and Cammie Beck during the purchase. And the first part says, this sale included, the first box that checked is, it says, a trigger lock or other device designed to disable a firearm and prevent the discharge of a firearm, or a gun case or storage container that can be secured to prevent unauthorized access to the firearm. It basically means that those 2 things have been provided because those boxes are checked. In this case, being the cable lock and the gun case itself, if you put locks in it, could be locked.
Okay. Thank you. And that's been previously admitted. I want to take you back to watching the surveillance of the shooting. And when I asked you what does that mean, from what time to what time were you able to watch surveillance in the school?
Are you referring to the actual time of the day?
No. How much surveillance did you watch, and what did it include?
I watched a majority of the footage, including Ethan's whereabouts through the day, or the shooter's whereabouts through the day, and then also the actual shooting itself and the aftermath of that.
Okay. And if you know, were you able to determine how many rounds were fired?
32.
Okay. And watching the surveillance from an investigative standpoint, was anything interesting or cause you to take other steps?
Yes, there were 3 main things that caught my attention during the video, specifically during the shooting.
There were 3 things?
There were 3 things, yes.
Okay. Can you list them for the jury?
Yes. So first, as the shooting began, the shooter was using only one arm for a majority of the first part of the shooting. And then as he moved down the hallway and Tate comes into view of the screen, he takes a 2-handed shooting grip, takes I would call a shooter stance, feet wide, his shoulders roll forward, and he takes aim with using the sights and fires 1 round.
When you say using the sights, what do you mean?
Meaning that there's a mechanism on the firearm that allows you to take aim. If I can...
Yep. Okay, I'm handing you the SIG, which is the murder weapon. Can you show the jury? You might have to stand up.
Yes. So here you see how there's 2 white dots back here, and I'm sorry for... This is a safe firearm. The 2 dots back here are considered the rear sight. See that over there? And if you line up the front sight with the rear sight, that is how you aim a firearm. In the video, I noted that Ethan did that On the shooter did that on the first shot, as well as the second shot he took at Tate.
Okay, Special Agent, we have not shown that surveillance video at this point. So I'm going to try to provide some context. And what did you, when you were watching this, and you mentioned the stance and lining up the sights, was the shooter rushing? Was the shooter going at a fast pace? Can you describe what you saw?
Yes, during that specific portion, he came to a dead stop and took aim, and then as he moved forward, he walked 2 or 3 steps forward and then took aim again and discharged the firearm.
And what seemed remarkable about that to you, if anything?
Your Honor, I just object to the relevance. This is not the trial for the shooter.
Your Honor, the knowledge of firearm proficiency is absolutely relevant, and it is a contested fact, and it is relevant to these proceedings.
Yeah, I'm going to allow it. I hope you guys do understand that, right? Some of these things overlap, but you were carefully chosen to distinguish between what the shooter did and what we're here about. And we all trust you to do that. So I know it's difficult and an emotional day, but some of these things are not to horrify or upset you, but to let you know some of the circumstances. So I hope that you separate those things.
And it is offered precisely what he's testifying to about the proficiency with the firearm that the shooter had.
Yeah, I'm going to allow it.
Thank you. What, if anything, was remarkable about that?
When I first saw it, I immediately said to others in the room that I thought that the shooter had been to a shooting range or had had training in firearms.
And that's based on what you just testified to?
Yes.
Okay. Particularly with the shot fired that killed Tate Muir, was there anything about that other than the stance?
It was the stance, the way he rolled the shoulders forward, and then
The entire shooting lasted how long, if you know?
the entire shooting, I don't recall the exact length of time, but it was less than 10 minutes.
Okay. Were you able to observe any loading of magazines in the SIG? And I should back up. What is a magazine?
So a magazine is the part of the firearm that contains ammunition that's loaded in the magazine while the firearm.
And I'm sorry to keep doing this. But
Sure.
Can you show the jury where a magazine, how you would load a magazine if you had one?
Yes. So I think there's actually one in the SIG evidence box here. So this is a.
Could you stand up so
yes.
I can see?
So this is a SIG Sauer pistol magazine. It's a 15-round magazine. This would be inserted into the magazine when it's loaded with ammunition. You would then send the slide forward, chambering around, and at that point the firearm's ready to be discharged.
Okay. And you said 32 rounds were fired?
Yes, there were 32 fired cartridge casings or shell casings that were recovered from the school, yes.
And there were how many in a magazine?
The SIG Sauer magazine is a 15-round magazine, and you can also fit an additional round in the chamber for a total of 16 rounds.
Okay. Did you ever observe on the video the shooter reloading?
Yes.
Can you tell me about that?
Yes, so I believe it was the first time the shooter reloaded. The magazine was empty, and he loaded a new magazine into the firearm. At another point, this was the second thing that I thought was notable in the surveillance video. He conducted what at ATF we're trained as a tactical magazine exchange. I know other agencies call it a combat reload, but basically he was not out of ammunition in the firearm yet, but he knew that, I can't testify to what he knew, but...
Why are you trained to do a combat reload?
To make sure that you always have more rounds in your magazine, so that that you have sufficient ammunition. So if you have half of a magazine, you would eject it, not throw it on the ground, you would put it in your pocket in case you need it, and then you load a full magazine, so now you're back to full capacity.
And what were you trained would be the purpose for that? When would you have cause to do that?
So for us, we're trained if we're involved in a shooting. If you do that way you have a fully loaded magazine in case you need to re-engage a threat, Obviously, the circumstances here were obviously different.
Okay. Thank you. One moment. Okay. That was the first thing. There were two other things.
So the first was his shooting stance. The second was the tactical magazine exchange. The third thing was after the shooter exited the bathroom where he gave himself up. Eventually, he ejected the magazine out of the firearm and placed it on top of a trash receptacle, which I found odd at the time because if you were just doing a school shooting, it seemed odd to take the magazine and make a firearm safe.
So he walked out of the bathroom, and the evidence showed that is where Justin Schilling was killed. He walked out of the bathroom, and you say he took the magazine out, and you're saying that is making the firearm safe.
Yes, I don't believe he ejected around from the chamber. I don't recall right now. I don't believe he did. But yes, he separated the magazine from the firearm as if you were at a shooting range and taking the magazine out and setting it on like your shooting platform.
Trash can.
Yes.
Okay. And what did he do after that?
At that point, he got on the ground and was shortly thereafter taken into custody by sheriff's deputies.
Okay. And when he was was he standing? Was he laying down? Was he sitting?
No,
kneeling?
he got into he was kneeling and then got into the prone position with his hands up.
Okay. Were you able to determine whether or not he used anything to protect his ears?
During the shooting?
Yes.
I don't recall, no.
Okay. And then the third thing was, I just want to make sure we got all three things.
Yep, that is all three.
Okay. So after you determined that what you considered it proficiency or somewhat?
Yes, there was some level of firearms training exhibited in the surveillance video.
Okay. And so what did you do next?
So the following day, after knowing that ranges would be open in the morning, also additional information came in during the investigation that there was possibility that the family had been to a firearms range recently. I began looking for evidence of James, Jennifer, or Ethan Crumbley at shooting ranges in the area.
Okay. And is this part of a normal investigation you would do in a shooting?
Yes.
Okay. And so you started going to local shooting ranges?
No, I began calling. The first one I called was the most popular range probably in this area. And upon calling, they confirmed that they did have information and asked that I come in and verify my identity.
Okay, and how far away was that from the Crumbley home?
Not too far. It was in Clarkston, Michigan, so a couple towns over.
Okay. Did you go to the range?
Yes.
All right. And what did you? What kind of information were you seeking?
So the range provided multiple receipts from showing that James and Ethan and Jennifer Crumbley had been at the range in the past, as well as surveillance video documenting range visits on September 25th and on November 27th. I believe that's 3 days prior to the shooting.
Okay. Let's start with exhibits 40 and 41. Is that what? These. Well, I'm going to ask you there. Okay. Special Agent, what is on the screen?
These are Facebook messages between James and Jennifer Crumbley.
And how were these retrieved?
Through a search warrant served on Facebook.
Okay. You also, in the investigation, reviewed downloading from the actual phones, correct?
Yes.
All right. Were these messages still on Jennifer Crumbley's phone?
I know they were on James's phone. I don't recall if they were on Jennifer's phone.
Okay.
Your Honor, I'm sorry. I stipulated, but my copy does not have these stars on it, and they have eliminated some of the messages on this exhibit.
I think that's why the stars are there.
Yeah.
Right. So I object.
We're happy to provide all of the messages. We were just to be concise regarding these messages are offered to show Jennifer Crumbley's knowledge that they were at the store and the range. But I was just trying to be concise. But we're happy to give it all to the jury.
For the interest of completion, Ms. Smith, I'll admit any portions of those that you would like.
Yeah, Your Honor, I would ask for the whole, they gave me the entire exhibit.
You have it all.
Okay, I have it all, but what you're putting up here is not it all.
We're happy to provide all of it. We're just going to talk about these two, and she can, and we'll provide every single thing possible to the jury. I'm just trying to not go through all of the messages that weren't pertinent to the shooting.
We're just taking slivers out. This is the problem. This is
the whole exhibit. The whole exhibit's going to come in, but that's the reason that the stars are there, to show that it's not a complete chain. That there's something in the middle. But I will admit the entire text chain, and you are also happy to present to the jury the entire text chain.
Okay, thank you, Judge.
And Your Honor, there's no evidentiary requirement that we have to publish every text message in a 2,000 page string if we want to pull out. I'm not trying to misrepresent.
There isn't.
Okay.
But I'm just saying that if Ms. Smith would like those in, I would be happy to admit them for the purposes of completion.
We want it all in, so we're happy. We'll stipulate to it. This was only taken out not to deceive as much as to try to make these are the ones about the gun range. But there's a lot of content about things like, purchases and all sorts of stuff. Okay, so can you read those to the jury, especially Jim?
Yes, so this is dated June 15th, 2021. So JC Crumbley is Jennifer Crumbley's Facebook account, that's in blue, and it says talk at 12 o'clock ? And then James Crumbley, who's in green, responds, taking Ethan to store at 12. Jennifer responds, you get gun.
So that the last one was 11:34. That's minus UTC -4. Is that 11:34 a.m.?
This has been adjusted to Eastern Standard Time.
So it's really 11:34.
Yes.
Okay. And there's time passes, and now we're at 1:17. And what does Jennifer reply?
Jennifer asks, you get gun.
Okay, and the next slide.
James responds, yes, and it says Mo, but I believe it's supposed to be no. Jennifer questions that, says, huh? And then James says, we paid for the gun and bought it, but can't pick it up till everything clears Washington, in parentheses, FBI. Could be today, tomorrow, or next day. They don't know. Jennifer responds, gotcha. Bring me those fruit punch things when you come to bring hay.
Okay. And then that same, can you read the text on the slide?
Yes, so Jennifer sends a message that asks, how much is your gun? James replies, 300.
Okay. I want to direct your attention to Exhibit 24 that's already been admitted. What are we looking at?
This is a receipt from the gun store in Oxford for the Derringer that we've been talking about.
So this is the Derringer?
Correct.
Okay. And how much was the price?
Total price was $180.15. Okay.
And then the next, who purchased the Derringer?
James Crumbley.
Okay. What is Exhibit 26?
This is also a receipt from the gun store in Oxford for the Keltec P17 pistol.
So it's this one?
Yes.
All right, and the same day? These on the same day purchased?
They were purchased on different days.
Okay. And how much was this?
The gun itself was $299.95.
Okay. Thank you. All right. I want to draw your attention next to I'm sorry, Your Honor, there's just a lot of exhibits and I want to make sure we get it right.
I understand.
Okay. 27? No, we did that. I'm sorry. Facebook messages between James and Jennifer on June 20th, 2021. Can you read those? That's Exhibit 42.
Yes, again, so Jennifer is in blue. It says, can you guys answer your phone? And James responds, no, at gun range, loud.
Okay. And then Exhibit 27. Can you tell the jury what these two videos are?
Yes, so there's, on James Crumbley's cell phone, there was a video on the 20th of June at 12:58 p.m. that shows the shooter shooting the Keltec pistol, and then after that, a couple minutes later, there's a video of the defendant's son shooting the Derringer pistol.
And these are it's the same day of the Facebook message before you just read?
Yes.
Okay. And this is Exhibit 43 and 44. So the first video, the shooter's, can you tell which firearm he's using?
Yeah, so the first video, the shooter's shooting the Keltec pistol.
This right here?
Yes.
Okay. This was the one for $300?
Yes.
Okay. And then the second one was the Derringer?
Yes, that's correct.
Okay. All right, I want to draw your attention to what's been marked as People's 45. Can you tell the jury what this is?
Yes, this is a Facebook message from James Crumbley to Jennifer Crumbley sending the video of, it appears to be the second video of the shooter shooting the Derringer.
So the second clip, which was shorter, where the shooter's shooting the Derringer, was sent to Jennifer from James.
Yes.
Okay. And is this a Facebook post?
No, this is a Facebook message from James Crumbley to Jennifer Crumbley.
Okay. That's the I already said that. That's the second clip, right?
Yes.
And then People's 46. What are we watching, Special Agent?
This is the video that James had sent to Jennifer via Facebook that she then posted, I believe, as an Instagram story that said, Ethan and James Crumbley both got handguns this week, testing them out at the range.
Okay, Ethan and James both got handguns this week, testing them out at the range. Correct?
Yes.
Okay. That's People's 46, Your Honor. I don't believe there's an objection. I'm going to direct your attention to the Exhibit 47, which was June 26th of 2021. What is that, Special Agent?
This is a receipt from the firearms range in Clarkston for range time and targets.
Okay, and Exhibit 48.
This is a Facebook message of, I believe, Ethan, the shooter shooting at the range in Clarkston, sent from James Crumbley to Jennifer Crumbley via Facebook Messenger.
Okay. And then 49. Was that the same video that was sent from James to Jennifer on June 26th?
Yes.
And what am I looking at right there?
This is the shooter at the gun range in Clarkston shooting the Keltec pistol with the Derringer visible on the shooting platform.
Okay. And do you know what Jennifer did with that? Where was that posted?
It was posted to an Instagram story on June 26th.
Whose Instagram story?
Jennifer's Instagram story.
And is this the actual Instagram story?
Yes, it is.
Okay, thank you. Directing your attention to July 24th of 2021.
Your Honor, what number was that?
Yeah. 75.
75.
75.
I'm sorry, it's July 25th.
Okay.
Can you tell?
Wait, hang on, I'm so sorry. What number?
It's exhibit number 75. It's July 25th, 2021.
Okay, thank you.
Yeah, I was trying to ask him so that we can. So it's 75. What were we just watching?
This is a video taken on James Crumbley's cell phone of Jennifer Crumbley shooting at the Clarkston range, the Kel-Tec pistol.
Okay, this one?
Yes.
Okay. All right, directing your attention to August 19th, 2021, exhibits 50 and 51. Can you tell me what this is?
Yes, this is a video sent by the shooter to another individual.
All right, and this was already admitted. What are we watching?
This is the shooter holding the Kel-Tec pistol.
This?
Yes.
Okay.
And then he sends the slide forward. There's no magazine or chamber or no round in the firearm.
Okay, was there any text messages about it or just the image?
There were also texts.
Okay.
I'm sorry, that was 50 or 51? We're going so fast right now, I can't.
I think it's 50. That was 51.
It's 50.
The text is 50. The text is 50. The video is 51.
Okay, the text is 50 that has the video in it, and then the video is 51.
Correct.
Is that correct?
That is correct.
Okay, text is 50, video 51. And I'm sorry, I am so sorry, we're just going so fast.
The text contains the video.
And that's at the gun range, the shooter holding the Kel-Tec, or shooting the Kel-Tec, is that correct?
I'm happy to clear it up.
Okay.
Special Agent, what in that image are you able to observe?
It appears to be a couch.
Oh, okay.
Do you know what time that was sent?
I don't recall the exact time. I'd have to look at the text message. I believe it was later in the evening.
Okay, we'll go back to that. What time was it sent, Special Agent?
I believe this is the next video. It was 9:31 p.m.
Okay. Were you able to find another image that showed that the shooter had access to the Kel-Tec?
Yes. So on that same date, he sent another video to the same friend at 12:30 a.m. With the Kel-Tec.
And this is 52 and 53. All right, Special Agent, you said this was sent at what time?
I believe it was 12:30 a.m.
And on that same day, which was August 19th.
Yeah, I believe it would be now the 20th.
Okay, I'm sorry, the
August,
20th,
yeah.
because it was after 12. And what do you see in the background that, can you tell the jury what you observed in the background of this photo?
Yes, so
This video, I'm sorry.
this video is taken on the dining room table in the Crumbley residence. Familiar with, after being inside and also reviewing photographs taken at the house during this investigation, that the wood grain matches on that table to the kitchen table in their dining room. In the video, the shooter loads a loaded firearm magazine into the firearm and then chambers around into the firearm.
So, is this a concern to you?
Yes.
Can you tell the jury why?
Well, as that ATF safety pamphlet states, the access to firearm by juveniles.
Your Honor, I would object because access to firearms by juveniles may be against the ATF pamphlet, but there's no evidence that there's not an adult there or anything happening.
Okay, yeah, well, he's not commenting on that. You don't know if anybody else was present.
No, Your Honor, I don't.
And Your Honor, I understand but that's argument, and it can be, she can point that out. Was there any message accompanying this video to his friend?
Yes.
What was the message?
My dad left it out, so I thought, why not? LOL.
And that is,
Your Honor, also, we've already had extensive arguments about, I am objecting to all hearsay texts between the shooter and his friend that my client and Mr. Crumbley have never seen, and this is one of them.
Your Honor, you've ruled on this several times, and
I ruled on this one.
No.
These are the text messages between the shooter and the other individual. You previously ruled that it's admitted.
I ruled on, I don't recall this one specifically. Was this amongst the ones that were ruled on?
Okay. I'm happy to make it I believe that you have, but if not, I am happy to make the argument. This is, even if you haven't ruled on it, it's under the exception of a present sense impression. He's picking up a firearm, and in that moment, videoing himself holding it and then saying, my dad left it out, so I thought, why not?
Well, it's in keeping with 803 1, and yeah, it's consistent with 803 1, isn't it?
Your Honor, I just want to reserve all prior objections that have already been in motions, and I can rely on that.
Thank you. All right, Special Agent, this is People's Exhibit 54. Can you tell the jury what this is?
This is the Google location information for James Crumbley, and it's dated August 19th, 9/29. It's around the time of the first video of the last two that we've seen, and it shows that he's at the Crumbley residence on East Street.
Okay, and the time on that?
It was 9:29 p.m.
Okay, and that's the video of where the couch was in the background.
Correct.
Okay, and then the next exhibit. This is 55. What is this?
This is the Google location information for Jennifer. It also shows that that East Street address, the Crumbley family residence.
Okay, so in other words, both Jennifer and James were home during the photo with when he was holding the Caltech and there was the couch in the background.
Yes.
Okay. And then 56. This is August 20th. So it's the 12:32 where the video was taken and the text, my dad left it out?
Yes.
Okay, and this shows what?
This shows that James Crumbley, the Gmail account associated with James Crumbley was at the East Street family residence, Crumbley family residence.
Okay, at 1:30 in the morning.
At 12:30 in the morning.
12:30 in the morning, sorry. All right, and the next slide, 57.
This is the same thing. It's Google location information for Jennifer's account, and it shows that she was at the Crumbley family residence at 12:21 a.m. that day as well, during the time, around the time of the video.
Okay, thank you. All right, I want to draw your attention to Exhibit 58. September 1st, 2021. This is a message between who?
This is a message between James Crumbley and Jennifer Crumbley on Facebook.
Okay, and the time is 4:56 p.m.?
Yes.
And what does the message say?
Ethan and I are headed to gun range.
Okay. And what are the Special Agent? This is Exhibits 59 and 60, but can you tell the jury what they are?
Yes, so these are receipts for that day. for James Crumbley. It's range time, targets, as well as renting a Ruger LCR 22 caliber revolver and paying for 22 caliber ammunition.
And this is a video exhibit 61 of that same day?
Yes.
Okay. Okay, and I want to, that's People's 61, and then I want to draw your attention to September 25th. Did either defendant go to a shooting, did this defendant go to a shooting range in Clarkston?
On September 25th, I believe, I don't recall for sure, I believe it was just James and Ethan that went.
So it wasn't this defendant?
No.
Okay. Were you able to determine whether or not she was aware they were at the range?
Yes.
And how do you know that?
I believe it was the same thing through Facebook messages.
Okay, and this is 62, and this is a receipt. What was the receipt for?
This was range fee, ammunition for 9mm, a rental of a 9mm pistol, as well as 22 caliber ammunition and targets.
In all of the videos you were able to obtain and observe, is this the first range video using a 9mm?
This is the first that I could find. Yes.
That we know of.
Yes.
Okay. All right. And this is 63. What are we looking at, Special Agent?
So that's James Crumbley in the white sweatshirt and gray baseball hat, and then the shooter is behind him wearing a light gray sweatshirt, dark pants, Nike shoes, and a black hat.
Special Agent, we see two firearms there, correct?
Correct.
Okay. What, if you can tell, what kind of handgun it's for?
So I believe the handgun that the shooter is picking up now is the Keltec, and then the other one was one that they appeared to rent, or to, if they were looking to purchase a firearm, sometimes that the range will let you test it out before you purchase it.
So the one to the right of the shooter, what is that, if you know?
I can't say for certain. The footage is a little grainy.
Okay. Can you tell the jury what he's doing right now, if you know?
I believe he's having trouble with the firearm discharging. He appears to be having some type of malfunction that he's not able to clear on his own.
Okay, and I want to draw your attention then to Exhibit October 3rd of 2021, Exhibit 64. What is this?
This is a Facebook message from James Crumbley to Jennifer Crumbley at 12:01 p.m. that says, "Cool, just got cleaning our guns, leaving for range in a few."
Okay, that's 64, and then...
Wait, I'm sorry, Your Honor. Can we just slow down for 1 second? Because the exhibits I was given have more content. I just need to...
we'll go as slow as you'd like.
Okay, this is...
We separated them to make it easier to read one message at a time.
I understand, but this is different than what you provided me, and I just need to make sure I'm keeping up. So thank you.
I'm happy to go at any pace you'd like.
Thank you.
Judge.
Okay, so this is Exhibit 64.
Thank you, and I'm caught up.
Okay.
Okay, sorry.
It's okay.
It's all right.
All right.
It's a lot of information.
It's a lot of information.
65. What is that, Special Agent?
That's a receipt for the gun range in Clarkston, dated October 3rd, 2021, for range time, targets, and .22 caliber ammunition.
Okay. All right. Was this the last documented visit before November 26th that we have?
Yes.
Okay. Let's go to November 26th. What day was November 26th? What's significant about that day?
That was the date that James Crumbley purchased the 6-hour SP 2022 pistol for the shooter.
Okay, and that was the day after Thanksgiving?
Yes.
Okay. This has been previously admitted. This is the receipt for the SIG, correct?
Yes.
People's 28. And that was paid in cash, and the amount is $519.35. I don't mean to lead. I'm just trying to do this to make it easier to understand.
Yeah,
I have no objection to that.
Okay.
Yeah, that's already in.
Okay. And on the 26th, when this occurred, do you know what the next is? This has also been previously admitted. This is the purchaser's information. We've already talked about that. This was, I'm not sure if it was admitted, but it was shown in the opening. I believe there's no objection to it.
Yeah,
But
it's admitted.
Okay.
66, yeah.
Again, for the jury, this is the SIG, correct?
Yes, what's depicted in that picture is the 6-hour pistol, yes.
Okay. And when did Jennifer post about... I'm sorry. Excuse me. This is not Jennifer's post. This is the shooter's post. This is a different post. This wasn't the one at the opening. I apologize if I'm confusing anybody. It's just a lot. And what does this say?
So this is an Instagram post by the shooter that says, "Just got my new beauty today, 6-hour 9mm. Ask any questions, I will answer."
Special Agent, were you able to determine, based on the forensic evidence of the phones, whether or not Jennifer Crumbley followed the shooter's Instagram account?
Yes, she did.
Okay, so this account where he posted, she followed it. We can't say she saw it, but we know she followed it.
Correct, yes.
Okay, and that is a picture of the SIG?
Yeah, so the first picture was the 6-hour in the pistol box. And then the second picture is the shooter holding the firearm. It appears to be inside the Crumbley family residence based on the floor. And then there's the shooter again holding the firearm with the sights aimed in. As you can see that the 3 dots are aligned.
I'm so sorry. What number is that?
It's all part of 66.
66?
This is Instagram post from November 26, 2021.
Okay, thank you. So 66 then has multiple pictures.
Three
Yeah, it's,
Okay, thank you.
It's the one Instagram account that we know is in common.
Okay, thank you. Yeah, yeah.
All right, I just want to make sure it's from.
But when it's in piecemeal, I can't tell what's, the number is not on the screen, so.
Right.
Right.
I was wondering.
That's why I'm having a hard time, so, sorry.
Are we able to take a break, Your Honor?
Never.
Sorry.
I was looking for the natural break, so.
Yeah, I don't think this is the fine time. There's about probably 30 minutes left of this.
Oh, okay. So, yeah, I'm almost,
well, sorry about that.
No.
I was waiting until cross-examination.
I'm so sorry.
No, I'm with you. All right. So, a few things. You can't discuss your testimony with anyone right now because you're still on the stand.
Understood, Your Honor.
But you can step out and we will come back at 3:15. How's that? All right?
All rise for the jury.
All right, coming back now to studio, it looks as though the court is going on a short break until about 3:15, so a little over 15 minutes now. We're joined by legal experts to discuss what we have seen today and how evidence and testimony presented would be impactful. We're joined by Lillian Diallo and Richard Convertino, defense attorneys. Thank you so much for being here. So this was a very, very long cross-examination. What did it accomplish?
It wasn't the cross-examination yet.
I'm sorry.
Just the direct
Testimony, yes.
direct examination, which is just the prosecutor asking questions. She's trying to establish authenticate the exhibits. Exhibits 31 through 75 have been admitted seriatim, and so those are already a part of the record. Yet the defense attorney seems to have objected to some exhibits that she had already stipulated to the admission of. So I'm not sure why she did that, other than that she didn't review them again before they were admitted into evidence. And there's a standard is that when you have exhibits that are marked as exhibits that you intend to introduce at trial as the prosecutor, you turn those over, show those to the defense attorney at some point, and they have an opportunity then to either agree or disagree or stipulate or not prior to them being admitted into trial. Saves a lot of judicial court time. So it appears that she had agreed to the admission of those documents but still hadn't reviewed them before they were actually admitted. So seems to be some controversy there. Yeah. She wants the whole exhibit. She said, now the prosecutor said, fine, we'll give you the whole exhibit. We want the whole exhibits, and there could be evidence in there of things that the prosecution wanted to get admitted that the defense had objected to and that the judge had kept out by saying, now, we're not getting the whole exhibit, we want them all in. She may be, cutting her nose to spite her face.
Yeah, it's just adding to so many things that we've seen already that are just so unusual with this case. And during jury selection, the defense questioned prospective jurors on parental responsibility, asking questions about if children should be left home alone and if parents should search their children's belongings. Do you think that making parental responsibility part of the defense is something that could work?
She has to do something. She is a defense attorney. She has to defend her client some kind of way. So, I mean, yes, right? What is the responsibility of a parent? And I think this case cuts on both sides, right? You have people that are very strongly opposed to the state prosecuting, and then people that are saying, yes, yes, you should, right? If that person is a child in your home, there are no such things as doors in my house, right? If I have to pay the bills and you are my child, I'm going in. So parental responsibility, you can have privacy, but you bought him the gun. You knew he had the gun. We keep getting away from that. And I'm gonna say this about what's going on right now. See, Judge McDonald, she is doing a lot of talking objections right now, right? And I don't necessarily know what Shannon Smith's end game is, right? I don't know. I mean, it may be things in there she wants. I don't know. But it could be overwhelming. But I do see she has Sean Godwin sitting there. He's WCCDBA, Wayne County practitioner. He knows how to get this stuff in, right? So she did partner with somebody who I know knows how to present evidence and go through it. So I don't know, it may be part of her ultimate strategy. I don't know, but the girl has to do something.
There are a lot of speaking of, objections in this case, which can be devastating to the opposing side, because the party that has the evidence objected to then currently is telling the judge and the jury the particular reason why they want the evidence in, or why they believe the evidence is important. And then at that point in time, if the judge rules against them, you can't unring the bell. The jury has heard that, and they can then view the evidence. Of course, even though they're instructed not to, it's hard to get a juror to unlisten to something they've already heard.
And it was a long time ago. It was about around 1:10 that this resumed, and the ATF officer was called to the stand. But the judge quietly said something about jurors being approached during break. Do we understand what happened there?
Not necessarily, but we think that, well, what we heard, now we don't know because we weren't there personally, that allegedly some members of the media may have approached jurors, either this case, but I don't think so, but in a different case. But it's inappropriate to approach any juror anywhere, period. If they have a juror badge on, you stay away. So they may need to sequester jurors now and walk with a deputy with them and away from them. You don't want to get a charge of obstructing, right, or tampering in any way, shape, or form. So I think they have to be careful. They cannot just be so excited by this whole thing. It's still a court of law, and there are rules to this.
Seems like we've been talking a lot about protocol today and making sure that's being followed. Something else that was brought up by the defense, they were saying that they shouldn't question the type of weapon that was used, because there's no way those parents would have known that it was something used with the intent to kill. But at the point of the matter, we're looking at a deadly weapon. Lillian, you look like you have a response already.
It is a deadly weapon. Yeah. It's inherent. It's not a car that may or may not be. It is a gun meant for killing.
On top of a child who has admitted to having issues with mental illness.
So you don't know what? You don't know anything? Now you stop that. Now, I'm all for trying to have a defense or something, right? You just stop it right now and just say you missed some cues. Yeah. But you knew something was wrong with that young man.
Basically what you're saying is be for real.
Yeah, be for real. Now, we got a gun, and you're sitting up there, you're posting it so everybody can see. It's like, look at me, look at me. It's this whole Facebook era where everybody wants the likes and wants to send a message, leave him alone if he's being bullied. That's what Mom was trying to do, I think. I could be wrong.
And something also, as we've kind of been discussing behind the scenes, this is an unprecedented case in this country because parents of a mass shooter are being charged. However, Richard, you said this is not an unprecedented move just generally when it comes to guns.
It's not, yeah. In fact, in Michigan, there was a case in 2018 which the appeal was set on in 2021. The appeal was affirmed the conviction, where a father was convicted of involuntary manslaughter. And the facts of the case, it was People v. Head. And the facts of the case where the two children, 10 and 9-year-old boy and a girl, were watching violent videos, or playing a violent video game, I should say, and they decided to test out the gun in the father's closet, which was unlocked, illegal firearm. It was a sawed-off shotgun. And the little girl took the gun and pointed, aimed, and discharged it directly at her brother, who was killed. The father was convicted of the same charges that are here. He was also charged with several counts of child abuse, was convicted of those as well. So it's not the first time that a fact pattern similar to this in Michigan and other states, involuntary manslaughter was used to convict a parent for reckless and wanton criminal negligence. But it is the first time in the country where a mass shooting occurred where parents were charged.
And let's talk about the conversation of child abuse, because that's something that's been brought up with this a lot too, especially with some of the things that we heard specifically in the Miller hearing, with the shooter saying that he was left home with no food and sometimes basic resources that he would need. A lot of that stuff still hasn't been unpacked as far as this trial goes. Any thoughts on the direction that could go?
You know, that may be just so prejudicial, because we do know the child said he was left home by himself at 6. Something's wrong, right, with the parenting. They didn't charge them with child abuse, right? That was the gift. And so because they did not charge them with child abuse, they're saying involuntary manslaughter on a gross negligence, which means not carelessness, right? It's more than carelessness. You disregarded the natural probability of what could or could not happen. And so let me just say this, People versus Taranisha Davis, my case, 2012, it was a Considine recreation shooting, and Madam Prosecutor Worthy charged everybody the same, the mother and the son, with first-degree murder. We had to go through a trial and get second-degree murder. The mother made the gun available by popping the hood. So the son reaches in, pulls it out, and it could have been a mass shooting, but only one person got shot, but there were multiple people around that had been bullying the child, right? So Madam Prosecutor, in 2012, we had to rock and roll with that case. And that was very difficult. That was the first time I'd ever, heard of something like that. But everybody got convicted of second instead of one, so.
And you've said previously in our coverage of the Miller hearing and sentencing for the shooter that the parents almost got off lucky for not being charged with child abuse.
Absolutely, because had they have been charged with child abuse 1, child abuse 2, there are different ones, then that becomes felony murder. If a homicide happens, a death happens, they're not charged with homicide. And I heard Prosecutor McDonald get in real slick saying homicide. No, this is manslaughter, right? It's a different level of death. Right, so it doesn't rise to the level of homicide, intentional, like that, boom, boom. But this is a gift for them. This is a gift. I know people don't understand it. I've had my fellow colleague Terry say, oh, well, that's what they should have been charged with. Listen here, that was a gift for them. Now, as a defense attorney, we don't ever want to put our clients in more peril. We have to limit exposure and liability.
Yeah. I've even talked with colleagues, and everyone seems to agree with this case. There's so many things that are just different. With a lot of the other mass shootings, we've seen parents just say that they were completely shocked, or maybe they knew that there were issues, but not that it could go to this level. With this young man and some of the things we saw in the Miller hearing, talking about an insatiable need to kill and seeing demons in his room, all of those sorts of things, how irresponsible is it of them to get a weapon for him, and how could the defense even try to argue this?
Well, it's so profoundly irresponsible that they're being tried with involuntary manslaughter. That's how irresponsible.
Simply put, yeah.
And the prosecution is saying we want to put forward in evidence this digital footprint that the Crumbleys left, purchasing the guns, the conversations they had both on text and on Facebook. We saw these videos, these Instagram posts. Right. Are they doing a good job painting a picture of this digital footprint for the jury?
Excellent job. And they may get a gift of allowing the jury to see a broader digital footprint if the defense attorney now is saying, I didn't get all the information. They're saying, yes, you did. And she says, I want it to be, I want the part that you excluded in evidence. Now, that could be extremely prejudicial. So prejudicial that it's excluded or was excluded by the judge. So who knows what's in those parts that are excluded, but now it seems the defense attorney wants that information to be included as evidence.
And there was talk that the shooter himself may be called to the stand. Is there a scenario that would happen?
Not in my world. I don't think Madam Prosecutor would want that to happen, right? She's dealt with that part. He's under appeal. This goes to the larger issue of the parents and where they feel their responsibility lies. They are treading on this boy's head. They're walking on his head. They don't care. They took his money and went on the run, right? His college money. You can't do that. That's the whole thing about this trial. It's about them and not him. As a mother, you do not put your child through that again to save yourself, right? He's there for life, right? Because of what you did or didn't do. It's about you right now. Leave him out of it for right now. You've been leaving him out of it.
I also would like to get your thoughts on something the defense said earlier about those parents cleaning out their accounts and running away out of fear, or people telling them that their money would be taken. Obviously, it is her job to defend Jennifer in this case, but do you feel like the argument is strong?
No, I think it's evidence of guilt. That's what the fleeing is. That's why it's admitted into evidence to show that there's consciousness of guilt, that the parents knew that they were in jeopardy, legal jeopardy, and they fled. And they not only did they flee, but they emptied the bank account as well in order to continue their escape.
Now, I know that Jennifer Crumbley made some requests going into this trial in terms of who could testify, what would be shown, and those weren't always adhered to by the judge.
Correct. So, I mean, the judge has to control the flow of the trial as well, right? You want to do justice, but you don't want to have cumulative or things that cannot be admitted come in, right? So everybody you want, you have to show a rational reason. What's the purpose of this person coming in? We're not going to get, I hope they don't get into character. They may get into character evidence. I pray no.
It's possible.
I pray not. Because you open it up to all those things where they were selfish, you know, drinking, having horses and putting everything over their kid. You don't want that in, right? You just want to say, okay, is she guilty of? And hit the elements as the defense attorney. Whatever's in there, you are supposed to know every piece of paper, watch every video in a case that's rationally related. Period.
Yeah, about 10 times.
Period.
Yeah.
Do you think the prosecution is probably sitting on some more gold mine evidence in terms of social media, some of those messages between the parents? Because we still haven't heard a lot of it.
Well, they listed 400 potential pieces of evidence or exhibits. They're probably up at close to 100 now, including, you know, the 33 through 75 that were admitted in blanket fashion. And so there may be evidence that's admitted at a later date in, again, you know, several tens of evidence of pieces of exhibits that I should say that may be admitted through stipulation that the defense hasn't gone through or hasn't gone through carefully, that can be used to, you know, what we used to say is sandbag the opposing party who's not familiar with the evidence.
And we saw, you know, so far, those who've come to the stand are eyewitnesses to the shooting, an employee at the gun store where these guns were purchased, as well as an ATF officer. Lillian, who else could we expect come to the stand throughout these next couple weeks?
First responding police officers that walked the scene, some of the children that were present inside of the school during that time. I really can't think of too many more people you need, right? You just need your fact witnesses on this. The prosecutor, they know where their case is, right? You don't need all of this in order to try to prove elements. But the salaciousness and the horrendousness of what happened, this is a first-time prosecution, so they want to get it right.
And I wonder who else the defense could call.
Well, one of the things I just wanted to comment briefly that the importance of the BATF agent in his testimony, he went through the three main things that struck him when he viewed the video, and the third thing was the tactical maneuvering of the magazine, or the combat reloading that he said was used by the shooter in this case, and how unusual that was, and how that showed proficiency, expertise. And so there was evidently a practicing prior to the shooting, including going to the gun range with his mother and father, where he may have been practicing, but certainly became proficient at shooting. But the ability to master the changing of the magazine, which held 15 rounds. Remember, he discharged 32, so he changed it twice. And the ATF agent said that shocked him to see. He was cold and calm. He stopped. He went into a shooter's stance. He didn't recoil. He used two hands. He aimed. He used the iron sights on the front of the gun to focus in on his target. So it was devastating testimony. It was kind of hidden in all of the kind of the boring authentication stuff, but it was very damaging, and you'll hear about that a lot in closing arguments, I presume.
And let's remember, this is a 15-year-old boy who committed this.
15. And he's able to do all that. I think that speaks to our culture in general right now, how it's all about the bullying culture, and you have to have this toxic whatever relationship instead of talking things through, right? Or listening. Listen to who's next to you. Listen to your child. Help your child instead of saying it's all about me, me, me. And our guns, we must have these guns around to prove that we are men or women of America. Well, no, that's not what proves you're a man or a woman. Restraint is what proves who we are in times like these, right? That kid didn't have a chance.
It's all very upsetting, and brings back difficult memories from that day, from that time. We're certainly going to see more evidence, more testimony, perhaps more surveillance video. That to me really struck me today, since this is the first time they're airing any surveillance video in these, formerly the Miller hearing, but now this trial. It's extremely upsetting.
Yes,
it's extremely upsetting. And we understand some students may come forward as well. Some minors. We don't see them on the camera correctly
Right.
when they
You won't hear them
testify.
either. Yeah.
It's just to keep their identity.
Yes. Yeah, that was what earlier today the judge and the attorneys were discussing the juvenile witnesses coming, when they're going to come, and so she could be prepared to mute the courtroom. That was earlier.
Oh, wow.
Yeah.
I didn't know she was going to mute so we couldn't hear.
So we couldn't hear, yeah.
Because we heard him in
I
the Miller
think so.
hearing.
I think so.
Remember?
I think that's what,
And that tore, I mean, that really tore me up, listening to the young man that was in the bathroom and the text chain that was going on, right?
Yeah, getting their perspective, yeah, for sure. We're going to continue this conversation. Right now, we're going to take a quick break, but we'll be right back. Today's trial for Jennifer Crumbley, the mother of the Oxford school shooter who carried out that senseless shooting on November 30th, 2021, is continuing right now.
The shooter took the lives of 4 fellow students, injuring others and changing a community forever.
The Oxford school shooter was sentenced to life in prison in December of 2023.
However, the shooter plans to appeal the decision. Meanwhile, final jurors were selected this week for his mother's trial. We spoke with jury consultant Richard Gabriel, who shared with us the process of choosing those jurors.
And we do know that court is continuing right now, so we're going to listen in as that is happening. We do want to warn you that some of the information that you hear is disturbing. We're seeing those live pictures. Jennifer actually just walked back in. Are we going to go back to the courtroom, or are we going to hold on that? Okay, before we go in, we'll talk with our panel briefly as they're getting everything situated and ready to go. As this picks back up and it proceeds, any thoughts on where this could go?
I want to see the cross-examination. I want to see what she intends to get from this ATF witness. I don't know how much she can get based on what's been presented and the text messages, other than she didn't have, Jennifer Crumbley, didn't have any direct connection to putting a gun in a hand. Knowledge, yes, but no directness right there. So I want to see it.
And you had a prediction, Lily, on the break just now that, so we just heard a lot of hard facts for about an hour and a half. It kind of dragged on. You expect to see some emotion now.
Yeah. So after this, after we get done with these kind of witnesses, then you have your students that were there. You never know who else, but that really puts you in the room, and you feel the room, you feel the terror, you feel the chaos, you feel all of that. So I think we're going to see some hear some feeling and feel some feeling.
Yeah. With gun ownership and the responsibility of that being kind of the bedrock of the prosecution's case, do you think that that is a strong approach here? Because again, we are talking about negligence and that alleged negligence that led to everything that happened at that school.
Well, I think the position of the prosecution in this case is that they're not concerned with a particular point of view of a juror regarding gun ownership, even those who may be enthusiastic one way or another about gun ownership, because this case shows the total irresponsibility which gun owners would be, which would cause them to be, very disconcerted with, and people who are certainly not gun owners or opposed to weapons in general would look at the same evidence and think it was extraordinarily wanton and criminally negligent. So this is such an extreme case, I think, that either position you have on guns fits into the confines of the criminal charges.
It's a really interesting point. And you said earlier you believe that Jennifer Crumbley will testify in this trial. What do you expect when that might happen?
Well, my position on that is actually twofold. First, that it was intimated strongly that she'll testify in the opening statement by the defense attorney. Secondly, I think that in a case like this, or a case where you have, for instance, a police officer who's accused of excessive force, you have to have that witness testify to explain themselves. She never has. She's never explained herself or explained her position, and I think that's important.
All right, we are seeing some activity in the courtroom. We're going to listen in now.
Yes.
That's a half hour long. That's why I'm asking. It's number
71.
Yeah, I just
Yeah, you're going to.
Okay, so that's a half hour, so it's going to be longer than half hour.
Yes.
That's all
Yep.
I'm asking.
Yep.
Okay, thanks.
Yep, that's right.
Thank you. Thank you.
We think we're finishing today, I hope.
I don't think so, Your Honor, because one of the exhibits that still has to be played is a half an hour long.
Oh, really? Okay.
There's a video.
It's okay.
Yeah.
Hi.
Hi.
I don't want to make you nervous. I want to tell you that we really appreciate your note. That's exactly what you're supposed to do. All right. That's why we have alternates in case something comes up.
Right.
So really, my only question for you is whether or not the fact that you might have met this person, this ATF agent, mentioned by Brett Brandon, you knew him in 2005 or 2006.
Yeah, actually, when I knew him, it's the same individual. He was working with Detroit Police Department.
Okay.
At either the 6th or 8th precinct
Okay. So did you ever have a beer together?
No.
Okay. And is there anything about the fact that his name was mentioned that would make you have difficulty being fair and impartial in this case?
No.
Okay. We appreciate your note. I know that this is, yeah. So.
I wanted to make sure.
Okay, I appreciate that. Do you have any questions for him?
No, I don't, and we have no objection to him remaining.
Okay.
No questions, thank you.
Okay, I appreciate your note. You can be seated if you want. We're going to bring your friends in. So. Yeah, go ahead.
Thank you.
Are you agent? Is it your title? Agent?
Special
Agent.
agent.
Special agent.
Agent.
Special
agent.
All right, for the jury.
Okay, you may be seated. Agent Raymond or Sandra?
Yes, Your Honor.
All right, go ahead.
Thank you. All right. We had an opportunity, my co-counsel and I, to reorganize so that we can do this as efficiently as possible. Special Agent, I'd like to direct your attention to Exhibit 66. I'm sorry. This is the Instagram post of the shooter, and you already testified earlier that Instagram account was followed by Jennifer Crumbley. Is there anything about this image that you want to remark on in terms of what you see and what you don't see?
Yeah, so in the image is the 6-hour 9mm pistol. There's one magazine inserted into the firearm. There's also an empty magazine next to the firearm on the right-hand side. In the image, there is not the ATF pamphlet or the cable lock that was sold with the firearm.
And then and I believe 66 is already admitted. And 67? What is this, Special Agent?
This is a picture from Jennifer Crumbley's cell phone taken, I believe, 30 to 40 minutes after, I was in around 6:38, 6:40 p.m. on the 26th.
The day the gun was purchased?
Correct. And this is a picture of the Sig Sauer is the bottom pistol with a magazine inserted. The top pistol is the Keltec 22 caliber pistol, and then there are the two Sig Sauer magazines, the ATF pamphlet, and a cable lock with a key inserted and a second key attached.
And this was previously admitted, this cable lock. It's People's 39. Can you testify about whether or not this is similar or the same? Can you tell that?
I would say that it is similar. The exact same words and instructions are on the pamphlet and on the, call that I don't know if it's a sticker that's attached to the bottom by the lock there.
This right here?
Correct. But I've had an opportunity to review the words on both, and they do match up.
Okay. And you see the pamphlet in that picture?
Yes.
And Jennifer Crumbley took that photo of the day the gun was purchased, and you said around 6:30?
It was between 6:30 and 6:40 p.m., I believe.
Okay, thank you. I want to go to now the next day. That would be this Saturday. The 26th was Friday after Thanksgiving. The 27th was Saturday. Did you have the opportunity to review surveillance video from a gun range in Clarkston?
Yes.
And do you know about what time that surveillance began? In other words, who's the surveillance of?
It shows Jennifer Crumbley and the shooter entering the gun range, paying for range time, targets and 9mm ammunition, 100 rounds of it, and then they proceed to take turns firing the Sig Sauer pistol.
Okay, so do you recall about the time they arrived there?
It was approximately 1 o'clock p.m.
Okay. So the receipt is for, you said 100 rounds?
Yes, they bought two 50-round boxes of Patriot Defense 9mm ammunition.
Okay, and so the only firearm that ammunition is for is the shooter's Christmas gift, the SIG?
Yes, out of the firearms in their home, it would only be utilized in that one specific firearm, yes.
Okay, and the previous receipts that we've admitted into evidence that you obtained, is there any record of any purchase of a 9mm ammunition before this day?
Not that I found, no.
Okay. So in terms of the evidence you obtained, this is the first time and only time you saw a purchase of 9mm ammunition?
Correct.
Okay. And who was at the range with the shooter?
Jennifer Crumbley.
Were you looking at the phone evidence and the forensic evidence from the phones able to determine where James Crumbley was that day?
Yes, I believe he was door dashing during the daytime hours that day.
He was a DoorDash driver, correct?
Yes.
Okay. And I want to draw your attention to the actual surveillance video, which is Exhibit 71. We are not going to play the entire video, Your Honor, although the entire video will be admitted into evidence and the jury can view it. We're going to try to focus on the most relevant parts, and then the entire video is in evidence.
And you can play the video
Yeah,
if you want.
got it. Thank you.
Okay. All right.
Okay. What are we looking at, Special Agent?
So that's Jennifer Crumbley had just arrived and placed the 6-hour pistol box on the display case there, and the shooter is standing over her shoulder.
Special Agent, we're going to fast forward. That you've already identified that gun case as the SIG case, and not this that it's this one, correct?
Correct.
Okay. So at this point, if you know, where is the gun?
So the handgun is in the 6-hour pistol case with the 2 boxes of ammunition sitting on top.
Okay. And Jennifer Crumbley is handling those?
Yes.
Okay. And what are they doing now?
They're putting on ear protection before entering the range.
The previous footage shown of Jennifer Crumbley at the shooting range, do you remember, did she have ear protection on?
Yes.
Special Agent, can you explain to the jury what's happening right now, if you know?
Yeah, right now, the shooter is loading ammunition into the magazines.
Now, at this point, he had the gun for one day?
Yes, approximately around exactly 24 hours.
Okay. And do you see a lock anywhere in that case or next to the gun or the case?
No.
Special Agent, I do have a question while we're viewing this. Are all of the visits and purchases stored on surveillance and ranges and licensed firearm dealers?
So in this particular gun range, there is surveillance camera equipment. I don't believe it went back past September 25th, which is why there wasn't surveillance video for the previous visits.
Okay. So what's happening right now?
So that is the 6 Hour pistol. I'm going to call that the stand, as well as a loaded magazine. And now the shooter is placing a target on the cardboard before sending it back down range.
So just for the record, the shooters already were able to tell how many rounds he shot?
It depends on how full the magazine was, but if he had a full magazine, it would have been 15 rounds once he loaded it in the firearm that he discharged.
Okay. And can you tell the jury what's happening now?
Yeah, so now he brings a new target over for Jennifer Crumbley, and then he affixes it to the cardboard and then sends it downrange.
So it seems both of them are struggling at this point, as he did before. What are they trying to do? He had the same trouble.
So initially he had trouble inserting the magazine. This is different. He's trying to explain to her how to send the slide forward by pressing sending the slide release and sending it forward to chamber around from the magazine. And that's that action right there.
So Jennifer Crumbley took her turn at firing the SIG. Were you able to tell whether it was just? It seemed like just a few rounds.
Yeah, it was just a few rounds. It was a partially loaded magazine that was inserted into the firearm.
Okay. And then I know you have viewed this several times. At this point, the shooter does another. I don't know how many rounds.
Ask that the witness answer the questions and just be asked non-leading.
I'm just really just trying to make things easy and more understandable. And we were going to fast forward.
Okay, so you're going to fast forward. What happens next? What happens next?
So I think they exchanged turns one more time, shooting at the target, and then I believe it's only one more time each, and then they depart from the range.
Okay. All right, you're fast forwarding to when they're both completed. You think that what did they both shoot more rounds, or just the shooter, if you know?
I'm not certain if Jennifer shot more rounds or not. I know the shooter takes another turn this time around. I don't know exactly how many more times Jennifer shoots.
Do you know how many rounds total were left when they were finished shooting?
So they discard an empty box of 50 rounds of the 9mm ammunition into the trash can, and then exit with only one box of 50 rounds. So when they departed, they only had the 50-round full box of Patriot Defense 9mm ammunition.
Okay. And we can fast forward to that part. We're going to try. Special Agent, is that where she just, the ammunition's discarded?
Yes, that's correct.
Okay. And this is the picture of the target that was posted. Do you know, was that ever recovered?
Yes, there was targets in the shooter's bedroom. I don't recall exactly if it was Mrs. Crumbley's target or not. I know the shooter's target was one of them, I believe. Right now he's trying to put...
Good afternoon and welcome to CBS News Detroit at 4. I'm Terrence Friday.
And I'm Meredith Bruckner. The involuntary manslaughter trial of Jennifer Crumbley is underway today. We have been listening in all day, gavel to gavel. Let's listen back in. Some of the things you hear may be disturbing.
And what does it look like to you is happening?
So the shooter's just trying to rearrange the pistol box so that it closes properly and can fully clamp with those that we demonstrated earlier, the opening of the clamps.
The latch?
The latches, yes.
So Jennifer Crumbley's carrying the case with the SIG inside of it.
Yes.
And do you see is the shooter carrying anything?
Yes, he has the targets as well as the box of 9mm pistol ammunition.
Okay. And based on your investigation and all the physical evidence and digital evidence, was this the last known image of this weapon before it was used to kill the students in Oxford High School?
Yes.
Okay. Okay. I'd like to draw your attention to Exhibit 72. Can you tell the jury what this is?
This is an Instagram post by Jennifer Crumbley on the date that they went to the range later that evening. It says, "Took my new SIG out to the range today."
I just want to stop you. This is actually...
I'm sorry.
Okay. Whose Instagram post is this?
I'm sorry, this is the shooter's Instagram.
Okay.
It was posted later that evening. Said, "Took my new SIG out to the range today. Definitely need to get used to the new sights, LOL."
And could you tell when that was posted?
Yes, 1902 on the date they went to the range, being the 27th, the day after Thanksgiving.
Okay, and what time is that for?
7:02 p.m.
Okay. It's UTC -5, so is it 7 or is it?
I'm sorry, that is in UTC. So at the time of this, it would be around 2 o'clock, 2:02 p.m.
2:02. Can you tell the jury what UTC minus?
Yeah, so
what am I talking about when I say that?
It's just the universal time. So that is like the time in the Eastern time zone is either -4 or -5, depending on the time of year, daylight savings time.
Okay. So that is 72, and then I'm gonna. Do you know, by the way, where Jennifer Crumbley was when this was posted? If you know.
I believe she was still home at this point.
And I want to draw your attention to 73. What is this?
This is the Instagram post by Jennifer Crumbley of the target with "Mom and Sunday testing out his new Christmas present. My first time shooting a 9mm I hit the bullseye. And this was posted about a minute later than the shooter's Instagram post.
So his post was 2:02 and hers was 2:03?
Yes.
Okay, and there's more than just this post, correct?
There's 3 images within the one post, yes.
Okay. So it's the same text, but 3 different images?
Yes.
Okay. And this, what is this picture of?
So this is the 3rd image. The first was the main target, then there was a zoom in of the bullseye, and then there was this image, which was of the firearm in the case with 2 pistol magazines and the ATF Youth Handgun Safety Act notice beneath it.
Do you know where James Crumbley was during this time? Was he still doing DoorDash deliveries?
Yes.
Okay. Do you know at some point whether or not Jennifer Crumbley left the house that day when they returned from the range?
Yes, she did.
Okay. And do you know about what time?
It was around, I believe it was around 2:30, or it could have, I know there was a Facebook message around 2:30 sent that she was shopping, so I don't know exactly what time she left, but I know she left after that after that Instagram post.
Okay, and do you know when she returned?
It was around 5:30 p.m.
Okay.
You know, I might be confusing Jennifer and James on that timing that Jennifer returned home.
Okay,
for that.
It's okay.
Yeah.
We have another witness that will testify about it. Just one moment, Your Honor. All right, I want to draw your attention to a previously, I believe it's previously admitted, 74, Exhibit 74. All right, and if we could zoom in on the drawing of the firearm in that diagram. We've already, well, tell the jury when you first saw this worksheet.
I first saw this worksheet when I was at Oxford High School on November 30th, 2021, responding to the shooting.
Okay, and what's your understanding about who drew those things and when?
It was my understanding that the shooter drew them earlier in the day, and I have to say that I saw an image of this worksheet, which is probably the same image. And it was, like I said, during my time responding to the school.
Okay. Special Agent, what, if anything, caught your attention about this drawing?
There were several things, specifically with the firearm. After recovering it and looking at it, inspecting it, it appeared to be the same firearm recovered from that the shooter used to commit the shooting, the Sig Sauer 9mm pistol.
Okay, can you explain to the jury why you believe that?
Yes. So when you look at the image, the back of the. Do you mind if I pick up the actual weapon?
Go ahead.
Okay.
But you're gonna have to stand so the jury can see it.
So when you look at the back of the slide, there's serrations at the back of the slide here. Actually, I'll turn it this way. So there's serrations at the back of the slide in the same location that they are in the picture. The shape of the trigger guard of the picture appeared to be the same shape, as well as the magazine. The SIG magazine is unique in that it has this lip at the front. And when inserted in the firearm, it creates this secondary kind of, it's not flush with the firearm, right? There's this lip.
Sorry,
Can you
turn door so we can
move my chair back? Yep, there we go.
Sorry, I can't see what you're.
Yep, no problem. So there's a lip in the front of the firearm here when the magazine's inserted. And when I looked at the picture, it appeared to be that was what was drawn at the bottom, where you see that lip.
Did you see anything else about the drawing that was notable?
Yes, the ammunition appeared to be, after working this case and reviewing the image and knowing the caliber of firearms in the Crumbley home, it appeared that ammunition was not .22 ammunition for the simple fact that the cylinder at the bottom on a .22 long rifle round of ammunition is not flush. It creates almost like a cylinder at the bottom, if you could picture it, and it wouldn't be flush with the with the round. So instead of it just being a circle like this, where you'd have a circle like that, it would be that there are parts and edge sticking out around it, so to speak. There would be an edge drawn further around the bottom of that rounded ammunition, and it's much thinner.
Okay, and I'm going to approach and show you the previously admitted picture of the other firearm that the Crumbleys owned. That's most similar to what's not here that's on the SIG that makes you think that the drawing was of the SIG. How are these two different?
So additionally, on the SIG...
And tell me how I should hold this so it doesn't look like I'm pointing at you.
Take that from you. Yeah.
Okay, thank you.
So when you look at the SIG here, there's an ejection port on this side, on the right side of the firearm, similar to the one drawn in the picture. The only other magazine-fed pistol in their residence at the time did not have an ejection port on either side of the firearm because it's concealed by the slide.
Okay, that's cool. Thank you. Nothing further at the moment, Your Honor.
Thank you. Good afternoon.
Afternoon.
We are watching live as Jennifer Crumbley's involuntary manslaughter trial continues. The mother of the Oxford school shooter. We have to take a quick break over the air, but we are streaming online. We'll be right back after this.
Thank you. Special Agent Brandon, would that be the correct way?
Yes.
Okay, to address you, thank you. You were testifying that you are familiar with the state and federal laws regarding guns, correct?
No, that's not correct. I had stated that I was familiar with the federal laws to purchase a firearm, and in some of those investigations in purchasing firearms, some of the state laws come into play.
Okay. In terms of, and if you don't know the answer, please let me know. If you do know the answer, let us know, and please answer the question. Back on November 30th of 2021, it was not illegal, and it still is not illegal, for a minor to touch a gun, correct?
It is not against federal law for a minor to touch a firearm in certain instances, no.
Okay. It is not against the law for a minor to shoot a gun at a gun range. It wasn't then, and it's not illegal now, correct?
It is not against federal law for a minor to go to a gun range to shoot a firearm, no.
Okay, and as far as you know, it's not against state law either, correct?
Yeah, as far as I know, especially from this investigation, I know that it's not against state law, yes.
Okay. On November 30th of 2021, there also is no law, federal law, that requires certain storage requirements for guns, correct?
Inside of your residence?
Yes.
There is not a federal law that forces anyone to store their firearms in a certain way, no.
And as far as you know, on November 30th of 2021, there also is not a state law that states how a firearm must be stored, correct?
It's my understanding, based on this investigation, that at the time there was not a law governing how to store a firearm in a home, no.
Okay. Now, you testified and talked to this jury about how there are various ways guns can be stored safely, correct?
Yes.
And one of the possible ways is in a gun safe, correct?
Yes.
And the Kel-Tec and Derringer gun, they were in a gun safe in the Crumbley home.
That's correct.
Another way that a gun another way of making a gun safe is with a cable lock, correct?
Yes.
Welcome back to our gavel-to-gavel coverage on the involuntary manslaughter trial of Jennifer Crumbley, the mother of the Oxford High School shooter.
We're going to go back into that courtroom right now and listen in.
And in order to disable or take the cable lock off, you have to have a key, correct?
I would say that's one of the ways to take it off, yes.
Okay, so that would be the way that most people would take it off, is by using a key that works with that lock, correct?
Yes.
Okay. And I want to go to exhibit 38, which I'm going to put up on my screen, but I need to switch it over. And I apologize. Mr. Godwin, can you help me, please?
Oh, yes.
I just am not sure I've shifted over. Okay, so I'm going to exhibit 38. It's this thing. Okay, I've got it plugged in. Oh, I did better than I thought I would. Okay, so this is exhibit 38. This has been admitted. This was admitted through the people when you testified before. This is the trigger lock statement. You recall testifying about this, correct?
Yes.
And when a sale of a gun is made, this form is filled out and given to the person filled out by the person buying the gun, correct?
Correct.
And it's signed, and this form specifically is signed by James Crumbley and Cammie Back being the person who sold the gun, correct?
Yes.
And this form is to help ensure that there is safety in this process of guns being sold, correct?
I'm not sure what the congressional intent is on this, and that's not something I can testify about.
Okay, thank you. You would agree with me that the sale must include a trigger lock or a gun case or storage container that can be secured, correct?
No, it says a trigger lock or other device design, which in this instance would be the cable lock or a gun case or storage container.
Okay, so I'm sorry. So it could be a trigger lock, it could be a cable lock, it could be a gun case, it could be a storage container. There's options.
Yes.
And when you testified about the 3 guns that we've seen in this courtroom, you testified about the Derringer, the Kel-Tec, and the Sig Sauer, correct?
Yes.
And you were testifying that the caliber on those guns, that the Sig Sauer has the biggest caliber, correct?
Yes, it's a larger caliber.
Out of the 3 of those.
Yes.
Okay. And by nature, with those 3 guns in mind, that means the Sig Sauer can do more damage than the other 2 guns, the Kel-Tec or the Derringer, correct?
I believe what I said is that it just makes a bigger hole, but yes, what you're saying is, yeah, that it would cause more damage, yes.
Okay. And a 9mm is not the, this is going to sound like a terrible question, but it's not the largest millimeter there are guns that are bigger and stronger, correct?
Yes.
What other guns could create even more damage or even larger holes?
I mean, there's a lot of calibers that are larger than a 9. I don't know that you want me to list them all right now, but there are more calibers that do cause more damage, that do fire a bigger round than a 9mm.
A 357?
Yes.
A 45?
Yes.
A 50?
50 caliber?
Yeah.
Yes.
Okay, approximately how many other kinds of, would you guess, how many other?
I'm not going to guess. I mean, there's a lot of calibers of firearm. There are several that are larger caliber than a 9mm. There's not many that are larger than a 9 as a semi-automatic handgun. There's a few, I would say, not a ton.
Okay, so a 9mm is not the most destructive gun you can buy, but it's a gun that a person can buy.
A 9mm is a gun a person can buy, yes.
Okay. You testified about I'm going to go to Exhibit 37. You testified about this ATF pamphlet, Youth Handgun Safety Act notice, correct?
Yes.
You would agree with me that everyone knows guns are dangerous, correct?
I would hope so, yes.
It does not take getting a pamphlet to know that a gun is a weapon. That's common knowledge, correct?
Yes.
Whether that pamphlet is in the box, on the counter, on the floor, in the car, it's common knowledge that a gun is a serious, dangerous weapon, correct?
Yes, but that's not the purpose of this pamphlet.
Well, the purpose of this pamphlet is to make sure youths with handgun is especially dangerous, correct?
Yes.
And that also is fairly common sense, correct?
I don't know how to answer that question, being that it's like the #1 cause of death for children, that firearms are the #1 cause of death for kids. So I don't know how to answer that question.
Well, my point is, we know guns are dangerous. We know they're dangerous when youths handle guns. It doesn't change whether it's a youth or an adult, correct?
I think that if they wanted to have a pamphlet that said the Person Safety Act notice, they would have. It says youth for a reason. I think that there's a special category for that.
But any person would know that a youth handling a gun, it would be dangerous.
I would hope so.
Okay. We saw a lot of exhibits showing that there were...
All right, we were just watching the beginning of the involuntary manslaughter trial for Jennifer Crumbley. We are going on a short break. We'll be back soon.
James Crumbley like guns or are interested in guns, correct?
It appears so from the evidence, yes.
You showed this jury evidence of them purchasing, of James Crumbley purchasing the 3 weapons, correct?
Yes.
We've shown this jury text messages between Mr. Crumbley and Mrs. Crumbley showing that they're going to, that Mr. Crumbley and Ethan Crumbley, the shooter, are going to gun ranges, correct?
I'm sorry, could you repeat I got a little distracted.
I am so sorry.
That's okay.
You're like in a choke. Excuse me, I'm so sorry.
That's fine.
You want a cough drop?
I need like just something. I feel like I just had a bug fly in my throat.
I haven't seen any bugs in here. You want a cough drop?
Yeah, can I have one? Thanks. Sorry, excuse me. I'm so sorry. Okay, we can agree James Crumbley and his son are interested in guns.
Yes.
We can agree they would go to the gun range, they would go shooting together.
Yes.
Okay, you have some evidence of some various trips they took to the gun range, but it's possible there's many, many more trips that Mr. Crumbley and his son took to the gun range, correct?
That's possible, yes.
What you're testifying to this jury is not limited to the only experiences we can say the shooter has ever had at a gun range.
That's fair, yes.
And there's one occasion back in the summer of 2021 when Jennifer Crumbley is with her husband and son at the gun range, and we see her shooting in the video, correct?
Yes.
And aside from that, the only other time we see Jennifer Crumbley at the gun range is on the day after the Sig Sauer was purchased, when she's with this half-an-hour-long video we watched with the shooter, correct?
Yes.
And as we watched that video, on that occasion, we can agree James Crumbley is not there with them, correct?
Yes.
And when Jennifer Crumbley walks in, she's carrying the case that has the gun in it, correct?
Yes.
She goes up to the counter, purchases ammunition, and she carries it over to the area where they shoot. Is that fair to say?
Yes, she purchased the ammunition. I'm not clear on who picked out how much ammunition. There was a time that that the shooter made a 2 with his finger, and I can't be certain if he was talking about the ammunition boxes.
Okay.
Welcome back to our gavel-to-gavel coverage of the involuntary manslaughter trial of Jennifer Crumbley, the mother of the Oxford High School shooter. Let's tune back in.
You put the gun in the spot where the person stands to actually shoot it, correct?
Yes.
And then it appears to me, but please tell me if I'm wrong, that you load the magazines with the ammunition on the counter behind when the gun is sitting away from you, correct?
Yes, that's generally been my experience at private ranges, yes.
And in these videos that we saw, it's apparent that the shooter has knowledge of how to load those magazines with the ammunition, correct?
Yes.
He is the one loading those magazines with the ammunition, not Mrs. Crumbley.
No, there was a point at one time when Mrs. Crumbley was putting rounds in, her arm was moving. Obviously the angle's sideways so you can't see, but there was a time when she was loading. I don't think she loaded all the magazines, but I think she did load a few rounds.
Okay. And when we see the video of the shooter shooting the weapon, he obviously knows how to shoot the weapon and is shooting the weapon at the target, correct?
Yes.
And when Mrs. Crumbley comes up and takes her turn, Mom's having her turn with the weapon, there's some very obvious conversation going on between herself and the shooter, back and forth between the two of them, correct?
Yes.
And it appears from the video, I believe that you said the shooter is explaining something to her.
Yes, I think he was explaining how to send the slide forward to chamber a round. She was having trouble. She got the magazine in, but then couldn't get the slide to go forward.
Okay, and that was in the first, she took 2 turns essentially at the range, correct?
Yes.
And in the first turn she took, that's when she's having trouble with the slide?
Yes.
Okay. And when we see Mrs. Crumbley take her second turn, we see her turn back and have to call the shooter over to explain something else to her in trying to figure out how to hold the gun, correct?
Yeah, it seemed like he was trying to explain how to properly grip the firearm, yes.
Okay. And we can agree that in the videos from this shooting range at Accurate with Mrs. Crumbley and other ranges, it's clear the shooter has been given experience shooting at ranges and knows how to operate these weapons, correct?
Yes.
You also showed this jury evidence that on one other occasion, Mr. Crumbley and the shooter rented a 9mm gun.
Yes.
And on that day, obviously, the shooter shot the 9mm gun, correct?
I don't recall from the video that we have of that if he shot it or not. I believe, I would assume he did, but I can't say for certain.
It would be weird if you rented a gun and didn't shoot it.
I agree.
Okay. And you don't know if there's other trips that Mr. Crumbley took with the shooter where they may have rented 9mm guns on other occasions, correct?
If it was to this specific range, I would know about it based on the receipts, but if not, then no. If it was a different range, then it's possible, yes.
The range that you checked with was the one in Clarkston, correct?
Yes.
There are a number of gun ranges, though, in the area, and it's fair to say you did not check with all of those ranges.
Not all of them. The ones in close proximity to the house, yes. But at the time it was winter, so a lot of the outdoor ranges, it had snowed the weekend before. A lot of the outdoor ranges either were snowed, there was too much snow, but yes, as far as the indoor ranges in the area, that's the closest.
Okay. In addition to these guns and going to this indoor range, you were at the Crumbley home during the time the search warrant was executed, correct?
Yes.
And if you do not know the answer to this, you can let us know. During the search warrant that was executed, you observed that the shooter had a number of BB guns, correct?
Yes.
And BB guns are not on the same level of danger as these 3 weapons, these 3 guns you've testified about, correct?
I mean, they can be dangerous, but are they a firearm? No.
Okay. So, and you also, I'm sure, observed that in the backyard at the Crumbley's home, they had targets set up where BB guns could be shot in the backyard, correct?
Yes.
So, it's a very fair assumption to say that the shooter was interested in BB guns, target practice, these guns, going to the shooting range.
Yes.
When you testified that the Caltech was in a gun safe at the time law enforcement did the search warrant, correct?
Yes.
And the Derringer.
Yes.
And there was a cable lock that was not on the Caltech gun, correct?
There was a cable lock in the Caltech gun box in the kitchen that was not on the Caltech gun. There were no cable locks on either the Derringer or the Caltech inside the safe.
And we talked about the different options of ways to keep a gun safe. And while the cable lock was not on the Caltech or the Derringer, there wasn't a cable lock on that one, those two were secured in a gun safe.
Yes, with the combination of 000, but yes.
Okay, and when you testified about the combination being 000, that was the combination that you said the manufacturer, that would be the default.
Yes.
And that combination can
We
be
have to
changed.
take a quick break, but this trial continues uninterrupted on our stream. We'll be right back after this.
The combination was at the time that James and Jennifer Crumbley had that safe in the home. All you know is the time you saw the safe, the combination was 000, correct?
I know that the safe was unlocked at the house by law enforcement using the code 000.
Did you unlock the safe at the house, or is that, you were not the person that unlocked that safe though, correct?
No. You asked me the question. I said I know it was unlocked with that, but I was not present when it was unlocked, but I know that that's the combination to the safe. And it has not been changed since.
Okay. You did not watch law enforcement open the safe.
No.
You did not watch law enforcement turn the numbers on the safe.
No.
You believe that the numbers law enforcement used were 000, but you do not have personal knowledge that 000 opened that safe, correct?
I did not physically observe it, no.
And it's fair to say that those guns, that Caltech and that Derringer, were purchased in June of 2021, correct?
Yes.
And there is no claim in this case that the shooter ever took those two guns or took them out of the house or took those to school, anything along those lines, correct?
Not out of the house, no.
In terms of, Your Honor, are we going to go till 5 or what's the court?
I have special permission.
Okay,
But
so
I would like to, can we finish this witness? Can we finish this witness today?
Your Honor, there were so many exhibits. I don't think we can. And
Okay, we can go till 5, right? You guys okay going till 5?
okay.
Yeah.
You testified. Okay, so let's go to some of the exhibits if we can.
Okay.
I'm going to go to Exhibit 52. Was this, it appears to be conversation by messages back and forth. And it shows the shooter holding the Caltech, correct?
This one shows him loading the Caltech, that video that you have it on now, yes.
I'm sorry, it shows him loading the Caltech. Was from back in
Welcome back as we listen in to the involuntary manslaughter trial of Jennifer Crumbley, the mother of the Oxford High School shooter. Let's get back into Judge Cheryl Matthews' courtroom in Pontiac.
The shooter holding the Caltech, and let's see here, the video was admitted also. Let me just get to the video. Okay, so this is the video. I'm just going to play it. It's 12 seconds. This is exhibit 51. Okay, so this video shows the shooter loading the Caltech.
This one was an empty slide. He just sent the slide forward on this video, yes.
Okay, I'm so bad with
yeah.
these guns. Yeah, please correct me. So this one is him doing what, sending the slide forward?
Yes, there was no ammunition in the firearm, I don't believe there was even a magazine inserted. He just sent the slide forward in this video. It was like a black leather, looks like a couch or something like that below it.
Okay, and in this video, you have no idea if there are other people around him.
No.
The video is focused on the gun in the shooter's hand, correct?
Yes.
And this video was sent by text message over to a friend of the shooter's. Is that correct?
Yes.
And while we don't see any people in this video, we don't know if Mr. or Mrs. Crumbley were present at the time the shooter is taking this video.
We know that they were in the home at the time, but we don't know exactly where they were in the home, no.
Okay, so we know they're at home at the time the shooter's in the home making this video and sending it to a friend, correct?
Yes.
And as much as, this video, him doing this, the shooter doing this, is not illegal, correct?
No.
It's not.
It's not illegal. I mean, I can't say.
I'm not going to say it's a good idea.
Right. I don't mean under federal law, it wouldn't be illegal. You're in your own home, and I don't know where his parents are at the time either, though. So I can't really comment whether it was legal or not on what he's doing with the firearm.
Okay, right. We don't know. All we have is this little 12-second video with no context, correct?
I think the context was the text message that says, "My dad left his gun out," so it seems odd to send the text message if your dad was around while you filmed it.
Okay.
Or your parents, I should say.
We know dad is in the home at the time this video is made, correct?
Yes, both Jennifer and James, yes.
We know mom is in the home at the time this video is made, correct?
Yes.
This home we're talking about, there will be other... Sure.
I'm sorry.
All right, we are on a brief pause right now as the defense continues its line of questioning. We are watching the trial for Jennifer Crumbley, the mother of the Oxford school shooter.
What could the judge be saying now, Richard?
I'm not sure what she could be saying other than, get to the point of this cross-examination. It's all she's doing Cross-examination should be surgical, precise, get what you need to get and get out. And it's clearly not what's going on here. This cross-examination is actually reinforcing the prosecution's case.
All right, we're going to go back in and listen now. Again, warning for you, some of this language may be disturbing to some of our viewers.
It does not.
It specifically says my dad,
Yes.
and at the end of the day, you don't know the shooter.
I don't know the shooter personally.
Right.
No.
You don't know the shooter's friend.
No.
You don't know other things the shooter and his friend had been talking about that day, correct?
I've reviewed messages between the shooter and his friend for several days, but I don't understand what you're asking there.
I'm asking, you don't know whether when that statement was sent to his friend, you don't know that that's true, that his dad left the gun out, correct? All you can do is read the text.
I know he sent the text, yes.
He sent the text, but you don't know that that's true, correct?
I can say I know he sent the text. I don't know. I don't know exactly where. Yeah, I don't know how to answer that question. I don't know if it's true or not. I don't know if anyone knows it's true or not. But he sent the text.
You are aware that teenagers can embellish things?
I don't have any teenagers.
You were a teenager at some point.
Sure. I don't know that I'm specialized in teenager behavior.
Okay.
To testify to that.
You would agree with me it's possible for teenagers to embellish to impress their friends?
I would agree, yeah, that it's possible for teenagers to embellish, I think is a fair statement.
It's possible for them to send messages to friends to try to look cool?
It's possible, yes.
It's possible to try to fit in with other people and get people's attention, correct?
I think we're getting into an area that I'm not authorized to testify about as a federal agent right now, honestly. And
Yeah, Your Honor, Special Agent Brandon has very defined parameters about what he can testify to. He has Assistant United States Attorney in the courtroom because he can only testify to certain things. So I would just ask that.
I guess I'm not sure what that means, but.
It means he can't testify about teenage behavior. He can't testify about.
Well, some of that is also argumentative. Right? I guess I take judicial notice that teenagers embellish things, just for my own, right? Yeah, so they talked about that during jury selection. So he doesn't know. I don't think he was a teenager not long ago himself, I think. So police officers are looking younger and younger.
Okay, so the bottom line is...
All right, that testimony continues. Once again, we have to take a quick break. Uninterrupted coverage is available on our stream and our website, cbsdetroit.com. We'll be right back.
We just don't know. We're not mind readers, correct?
Yes.
We do know, though, it's not just based on text messages, that James and Jennifer Crumbley were in the home at the time this video was made, correct?
Yes, that's correct.
That is something that you established through actual evidence, and we know they were present in the home.
Yes.
And when we're talking about the Crumbleys' home, it's a 900 square foot home, correct?
Yes.
It's a small ranch with 3 bedrooms.
Yes.
We're not talking a 4,000 square foot, 3-story house, correct?
That's correct.
So we know that all 3 people at the time this video was made were in this 900 square foot home.
Yes.
Same thing with the video that was you testified about a video where you can see the dining room table and you recognize the wood grain as being from their dining room, correct?
Yes.
Can you remind me what was happening in that video? I don't want to waste the jury's time, but I think you...
Yeah, so in the video, the shooter loads a loaded pistol magazine into the Kel-Tec and then sends the slide forward, chambering around, which means the firearm is ready to be discharged at that time.
And when that video was taken, that's also a short little video clip, correct?
Yes.
And that video clip also, we do not know who else was present when that video clip was taken.
Not in the immediate vicinity around him, no. We know that both Jennifer and James were in the residence there. Yes.
Okay, so James and Jennifer are in the residence when Ethan Crumbley is making this video.
Yes.
Okay, and we know he made that video and obviously had it on his phone.
Correct.
And we know he sent that video to a friend.
Yes.
And again, we don't really have much more context beyond that, correct?
Other than the text message, no.
Well, the text message was from the other...
I think the text message, the videos were sent, and then the text message followed the videos.
There was, I'm sorry, were both of those videos sent at the time when it said my dad left it out?
I think the first video was sent at 9:30, and the second video was sent at like 12:30 a.m., so 4 hours later. But in that chain of text, it's video 9:30, video 12:30, and then the text that said my dad left his gun out, LOL,
Okay.
something to that effect.
And you checked to make sure that at 9:30 and at 12:30
Yes.
Welcome back to our continuing coverage of the Jennifer Crumbley trial. Let's go back into Judge Cheryl Mathrub's courtroom in Pontiac.
Correct?
I don't recall if there was a response or not. I know that they were sent. There may have been an exchange, but I just know that they were sent to his friend.
Okay. And then he sends another text saying my dad left this out, correct?
Yes.
Now, we can agree in the text message, or I'm sorry, in the Instagram post, there's reference that this gun was a gift to the shooter, correct?
Yes.
You are not a member of the Crumbley family, correct?
No.
You don't know what the terms of that gift are in terms of whether the shooter was allowed to just possess it and have it at all times, or if there were conditions around and rules around that gift, correct?
No, I just know that it was a gift.
Okay. And you don't know if you do not know where that gun was kept, the Sig Sauer was kept, prior to the day you're in the house with law enforcement and the open gun case was on the bed, correct? I'm sorry, it's late in the day, so
Sure.
my questions are getting terrible. Let me back up. When you saw the weapon, the actual weapon, the Sig Sauer, you saw it at the school, correct?
Yes.
And when you went to the parents' home, the gun case was out on the bed, correct?
I believe when I got there, it had been moved to the kitchen at that point.
I'm sorry, it was in the kitchen
Sure,
at
but
that
yeah.
point?
Yes.
Okay. And prior to you getting there, you don't know where the gun case had been, where it was moved to, who had moved it, and things like that, correct?
I know based on reviewing the search warrant photographs from the scene that are done prior to searching a residence, that it was on the bed and with the empty box of pistol ammunition next to it when those photographs were taken. That's what I know.
You don't know prior to that day or the night before where that gun was stored in the Crumbley's home, correct?
I don't know myself. I don't have knowledge of that. I know that there's been. I don't know how to answer that question, honestly.
Okay, well, you don't know the answer to that.
As someone that's been involved in this investigation, as one of the officers in charge, I have reviewed multiple different statements and texts about where it was stored. So I don't know how to quite answer that question because there were various texts and statements about where it was stored from the defendant's messages and statements and things like that. So I don't know how to answer that question. But do I know for certain where it was stored? The answer to that is no.
Okay. You also don't know whether when the gun the Sig Sauer was in the Crumbley home if they had the cable lock on the Sig Sauer gun?
I'm sorry, can you repeat the question?
When the gun was in the Crumbley's home, in the days following James buying the gun, you don't know if the cable lock was on that gun.
I don't know, other than the 26th, the date that they purchased the firearm. I believe they took photos of it around 1 o'clock p.m. I know that the shooter took a video around shortly after 6 o'clock p.m. with the firearm, with the cable lock still in the bag, not inserted in the gun. So I know that at least when they got home from the firearm store after the purchase, there were photographs taken. There was no cable lock inserted. I know later that night at 6 p.m., so shortly thereafter, between 6 and 6:40, both the shooter and Mrs. Crumbley took photographs on their phone or photos and videos, and the cable lock wasn't inserted. It was still in the bag. That's all I know. I know that and at those specific times when those pictures are taken, that the cable lock was not used at those times.
Okay, we can agree on that. Beyond that photograph, the day the gun was purchased, past 6 o'clock that night, you don't know if the cable lock was put on that gun, correct?
I have no evidence whether it was or was not, no.
You also don't know, after 6 o'clock that night, where the gun was placed, correct?
For that specific day, I don't personally know where that gun was that night, no.
You also don't know who was responsible for putting that gun away that night, correct?
I don't know how to answer that question. I guess it's if Mrs. Crumbley is taking a picture of the firearm and she's the only one home, it would be her responsibility to put the firearm away. And if it's Mr. Crumbley, so I don't know how to answer your question. If you want me to answer that, I don't know their conversations about who's responsible for locking it up at night.
Right, so your answer
yes.
is I don't know. You don't know.
Right.
Okay. And so on the 26th, that night, after 6 p.m., after the photo's taken, we can agree, you don't know if the cable lock.
And we are going on a short break. We'll be back shortly.
And you don't know who's storing it, correct?
I don't know how to answer your question because I feel like that
Because you don't know.
I think
it's asked and answered.
I don't know whose responsibility. It could be both parents' responsibility. I don't know how to answer that question.
You weren't there.
Correct. I wasn't there. I don't know who's.
Okay.
But Your Honor, I just want to make record. He does have knowledge of all the other evidence, so I think the struggle here is he
knows what was happening at 6 p.m., but
no, he's reviewed different statements about.
Always.
So that's where the struggle is here. He doesn't personally know if those statements are true, but I think that's why I don't want to put words in his mouth. But
he has other information.
I'm asking him about his personal knowledge, though. I'm not asking him about things other people said, things. Okay. All right. So then we go to the 27th. This is the day after the gun was purchased by Mr. Crumbley, correct?
Yes.
Okay. We've obviously talked about Mrs. Crumbley being at the range with the shooter that day, correct?
Yes.
Okay. That night, after Mrs. Crumbley was home, you do know that Mrs. Crumbley and her son went back home, correct?
Yes.
Okay. You don't have personal knowledge of who took the gun from the car they drove into the home, correct?
That's correct.
You don't know if the gun was even brought into the home when Mrs. Crumbley and the shooter arrived back home after the gun range.
That's correct.
You don't know if after coming home from the gun range, the cable lock was put on the gun.
By who? I don't know that the cable lock was placed on the firearm, but if you're saying it appeared the way that Mrs. Crumbley operated the firearm, it would be very difficult for her to lock the slide to the rear to put the cable lock on.
She appears like she doesn't know what she's doing with the gun, right?
Yes.
Okay. There's no doubt the shooter has a lot more knowledge about this gun than Mrs. Crumbley does.
Yes, that's fair.
Okay. And when Mrs. Crumbley is posting, she's posting that it's her first time shooting a 9mm, correct?
Yes, that's what she wrote.
And she's calling it a Mother-Son Day, correct?
Yes.
And you don't know much about this family, but Mother-Son Day implies this is a mother and son spending time together, correct?
That's what the text said, yes.
It's obvious Mrs. Crumbley's doing something with her son he enjoys, correct?
Yes, he was definitely smiling when he was shooting the firearm, yes.
Okay? And then both Mrs. Crumbley and her son are, comparing targets and
All right, the trial continues for Jennifer Crumbley on trial now, the mother of the Oxford school shooter. We're going to listen in live.
that night, you have no idea if the cable lock was put on the gun.
I do not know, no.
You don't even know if the gun was brought in the house.
No,
You don't know where the gun was kept that night.
no,
And you don't know where the gun was kept in the following day or day after. You don't have personal knowledge of that, correct?
yes.
And at the end of the day, I'm sorry, scratch that. In terms of the shooter, you have no awareness of whether the shooter has ever had any kind of safety course.
I found no evidence that he had a safety course, no.
You don't, so there is no evidence that you can say, there's no evidence, but that doesn't mean that didn't happen, correct?
Correct.
And you have no evidence about James, whether or not he's ever had a safety course, correct?
I found no evidence of that, no. But I don't, yeah, correct.
So you wouldn't know either way?
It's possible he had a safety course. I personally found no evidence of that.
And when you're talking about this drawing, and I'd like to just put the math paper back up. And I apologize, I believe it was exhibit...
It's 75? No, it's 74.
Thank you. Okay, so your testimony was, by looking at this math paper, you believe the gun in Exhibit 75 looks like the Sig Sauer weapon, correct?
Yes.
And this math paper was drawn after the shooter had already picked out and had his dad purchase the Sig Sauer, and the family already owned that gun, correct?
Yes.
And that bullet, you believe, looks like a bullet that would be unique to the Sig Sauer gun.
No, that's not what I said. I just said out of the firearms they own in their home, out of the two calibers, it resembles more of a 9mm than a .22.
Okay, but it's just a bullet, right? We can agree that the
You
drawing...
listed off a lot of calibers earlier. If you ever look at all those rounds, they look vastly different.
All right, so that's a 9mm caliber?
I'm saying it resembles, or could resemble, a 9mm caliber. It is definitely a round of pistol ammunition that does not look like a .22.
Okay, these are just drawings that we know the shooter drew at school, correct?
They are drawings that the shooter drew at school, yes. I don't know if I would say just.
They're drawings we know he drew at the school.
Yes.
And you have never discussed these drawings with the shooter, correct?
No.
You were not present when the shooter met with the school counselor about this drawing, correct?
No, I was not.
You were not present when the school shooter met with the principal from the school and talked about this drawing, correct?
I was not present.
You were not present when Mrs. Crumbley and her husband met with the shooter at the school about this drawing?
Correct. I did not get to the school that day until after the shooting occurred.
You did not hear the shooter explain why he put these things on this drawing, correct?
Yes, I did not respond until after the shooting occurred.
Okay. So you've never had a conversation with him where he explained or talked about what he was doing in this drawing, and you've never seen a video of those conversations, correct?
Yes, I believe I said before, I haven't met the shooter before.
Yeah, just a moment, Your Honor.
Sure.
I have nothing further, Your Honor.
Can we do redirect before we leave?
I can. Special Agent Brandon, you were asked some questions about the 9mm and that it isn't the most powerful gun, that there are other guns that could do more damage. Do you remember that?
Yes.
Okay. Would you acknowledge, though, that it's much more difficult to control and fire it quickly and accurately than a .22?
Yes, if we're going by the calibers, yeah, 50 caliber will be a lot more difficult to carry around than a 9mm. Yes.
Okay. And you were asked a lot about whether or not James or Jennifer, how many times they went to the shooting range, or if Jennifer ever went took them at a different time. You don't really know, though, correct?
No, all I know is the evidence that I found and that was presented today and that I testified to.
Okay, well, let's talk about that for a minute. What have you reviewed? Just summarize what you've reviewed.
So I've reviewed surveillance camera video from both the school, the firearms range, Facebook returns for James and Jennifer Crumbley, Instagram returns, the forensic download of 7 cell phones, I believe, belonging to James, Jennifer, and the shooter, the entire case file, other interviews, and things like that. Basically everything related to this case.
Okay, and when you say you reviewed the phones, that means all the content that was on the phone, correct?
Yes.
Going back to quite a long time.
Yes.
In fact, some of the cell phone data went back several years.
Yes.
Okay, and on those phones you also reviewed every video taken by Jennifer Crumbley.
Yes.
Correct? Every picture, correct?
Yes.
All of the Facebook messages from the return that she hadn't deleted, you reviewed those, correct?
Yes.
All of the communications between the two, Jennifer and James, correct?
Yes.
Videos that were recorded by her of herself, correct?
Yes.
Videos of the two of them fighting, correct?
Your Honor,
No,
I would
Your Honor,
ask-
let me finish.
This
The-
is all leading questions.
Okay. The question was, you don't know too much about this family, do you? Is that true?
In the context of this investigation, I've learned a lot about the Crumbley family. Based on the way the question was asked, I thought it was more in the lines of, in the same way of asking if I knew the shooter, do I know the Crumbleys? I don't personally know them, but in this investigation, yes, I've had a very detailed look at their life over the last several years, especially the year leading up to the shooting, yes.
Okay. And you were asked about the second video the shooter took of the Caltech.
Yes.
Okay. And you were asked if you knew whether or not someone was a parent, Jennifer Crumbley or James Crumbley, was next to him, correct?
Yes.
Okay. let's just say for a moment, they were. Do you still have any problem with that video?
Objection. His opinion about having a problem with it is irrelevant.
Yeah.
Do you have concerns about safety when you look at that video, regardless of who was next to him?
Yes, based on the height of the table, the direction the firearm was pointed would either have been based on the way the wood grain goes, it would have either been at the neighbor's house or out the front window of the house. And because of the height of the table, potentially, and with the porch, I'm not quite sure if it would be head height or stomach or above, but it would definitely be pointed in a direction where if the firearm was shot, it could travel outside the home.
Okay. You were asked about whose responsibility it was, or did you know, to lock up the weapon, correct?
Yes.
Okay. Whose responsibility is it when a firearm, a 9mm, is in your home? Whose responsibility is when you know there's a minor there?
Based on my understanding of the pamphlet that was handed out, I can say that it would not be on the juvenile.
You were asked about that meeting in the counselor's office, correct?
Yes.
Okay. And the worksheet that you viewed,
yes.
Correct? Okay. And you were asked if you don't know what the counselor said about it, correct? And your answer was no, you don't.
Correct. I said I wasn't personally there for what he said about it.
Okay. But you know that the worksheet was shown to Jennifer Crumbley, correct?
Yes.
And you know that the worksheet had the words "help me," correct?
Yes.
Okay. And the worksheet had the words "blood everywhere," correct?
Yes, it did.
Okay. And you know that that worksheet
Your
was
Honor,
both texted.
Objection to leading. This is all leading.
Do you know whether or not Jennifer Crumbley saw that worksheet?
Yes.
All right. And how do you know that?
It was on her cell phone, and she sent it to several people after she received it.
Okay. And do you know that if the worksheet that she was shown had the words "help me," "blood everywhere"?
It did.
Okay. Thank you.
You can sit down and rest. Okay. So I know it's been a long day, but I'm intent on using time as well as possible. I think we've made some good headway today. I'm going to ask you to return at 8:30 in the morning. Do you guys have any questions about the schedule? Did you fill out your lunch? Was lunch good? I made it myself. I'm going to have you return at 8:30 in the morning. Any questions about the schedule? I'm supposed to tell you, during the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and lawyers must be able to cross-examine them. News reports do not have to meet these standards. They could give you incorrect or misleading information. So to be fair to both sides, you must follow this instruction. Do not go on social media. Don't post. Don't do research. Don't watch the news. And please do not discuss the case with anyone. If anyone attempts to discuss the case with you, please let me know. All right? All right, we appreciate you. Any questions about the schedule? I think we're moving along, okay?
All rise for the jury.
Good evening and welcome to CBS News Detroit at 5. I'm Terrence Friday.
I'm Shayna Humphreys. The involuntary manslaughter trial of Jennifer Crumbley is underway today. We've been listening in all day long, gavel to gavel, and the day just adjourned for now, but a lot more is to come. Here with us throughout the day has been former federal prosecutor Rick Convertino, as well as defense attorney Lillian Diallo. Thank you so much for being here all day long.
Thank you.
A very intense day, as we're used to now with this case. It's been kind of contentious, really, from the beginning. What are your takeaways right now, Rick?
Well, from the last witness, I think it was a totally feckless cross-examination by a frankly inexperienced cross-examiner. The cross-examination reinforced the the prosecution case. I think the redirect was excellent. and got out a lot of information that was probably impermissible otherwise, because the door was opened by the defense attorney. So it was a very poor example of a surgical, on-point cross-examination that would get information out from a witness who was extremely professional and very effective for the defense side. It was terrible. Now, Lillian's kinder than I, but that's my assessment.
He's not mincing words, Lillian.
Diallo for the defense, right? So, I'm a defense attorney, and it's very stressful in these situations, and hopefully she'll get her sea legs, but, you have to stop forcing these errors, right? I don't want to criticize so that she feels like she can't do anything right, but you're forcing errors, you're opening doors, you're letting things happen in the courtroom, you're letting the witnesses handle you. It's supposed to be the other way around, and you're supposed to listen and shut some of this stuff down. I would have been down 2 hours ago if it was me.
And it seems like that's been the general consensus since the beginning. Even at the opening statements, you both seem to be a little critical of the defense and their approach.
It was an abomination when you talk about the Band-Aid and the sliver, and there are 4 people dead plus numerous people injured from a gun, all the people that were terrorized, all these children that have to live with this, and you're talking about it's like putting a Band-Aid on. Wait, no, it's about holding those responsible. You bought that gun for that boy. You have an obligation to just do more than try to make him feel good. It's not about feeling good, is it? It's about doing what you are required to do, just the minimum per the law.
For those who might just be joining us, the lead defense attorney invoked Taylor Swift lyrics in opening statements. Yeah, I mean, it's hard to see it as anything other than ridiculous. You're a former prosecutor. Right. What were you thinking when you heard that?
Well, I was thinking anybody but Travis Kelce would be, pleased to hear that, but certainly not a jury. And I mean, it was. As a defense attorney, you think of yourself as liberty's last champion. You're defending a client's liberty interest, and whether or not that person at the defense table goes to prison or not is you're a big part of that. And so, finding, as Lillian says, finding your sea legs is absolutely unacceptable in a case of this magnitude. Maybe for a first-year law student or someone who's practicing and defending slug-em-mug-em cases or misdemeanor cases, but at this point in one's career, I think didn't do any help for this defendant, none at all.
Yeah, and also, would you say that the emotional stability of the defense is something else that you have questioned today?
Yes. When you start talking about sobbing and pointing and saying, this is horrific, I've never seen this before, we don't do things like that as defense attorneys. If you haven't seen it before, that should be what? Mistrial? I mean, this is that person's life. You said you would represent whoever that is next to you, and I've represented some abominable people, right? You have an obligation, though. The prosecutor has an obligation to do justice, not to just facilitate convictions, and that defense attorney has an obligation to try to defend that client, right? You need to do a little bit more than talk about your eye makeup, right? Taylor Swift. I've done hundreds of opening statements. I've never, ever done that. I think I would be admonished or something. I don't know. Ms. Diallo, move on.
The prosecution seems to have been a lot more consistent and fact-based throughout this day one of this trial. Rick, what would you say the defense is going to have to do moving forward to try to salvage this? Or is there just too much damage?
Well, I mean, there's an incredible amount of damage the first day of trial. I mean, you have one chance to make a first impression on a jury, one opportunity. And starting off with a Taylor Swift quote is not that chance. And that was probably the best part of her opening statement. So, I'm sorry to say, but who represents you is a critical decision you make when your life is at, your liberty interest is at stake.
I'm probably being generous here, but for devil's advocate's sake, is there a chance in the jury's mind when you're seeing this, you're thinking, all right, this is just a poor job being done by the attorney? Do you think they almost give a little bit of a benefit of the doubt to the defendant on account of this, or?
She better hope so. Yeah. She better hope so. But she's forcing errors from his eyes were black. And what are you doing, lady? You have to look at your jury, your prospective jury, and understand you just can't make those kind of things that may turn somebody off immediately, and they're like, I don't care what they say. Yeah.
All right. We have to take a quick break. We will be right back after this.
In now, take a look at the weather. It's a lot has been going on today, but of course we got to keep up with the forecast as well. A little sloppy out there still.
Most definitely. We're kind of stuck with all that fog really just kind of swinging its way through, right? So here's what we've got going on into the rest of the night as well. I mean, starting off with really just this dense stuff all the way into the next few hours. You got 39 degrees out there right now, but you can't see a thing. We've got dense fog, by the way, continuing all the way into the night ahead. We've got really right around 0 for the visibility mark, actually all the way down south of there. Once we get into the late portion of it as well, you can see right here 5, 6, 7, 8, 9 o'clock finally starting to improve, and that's an important note because we are going to get a chance to finally get rid of some of the heaviest of the dense fog. We do, by the way, have a dense fog advisory. This continues all the way up until 10 o'clock tonight, so we're still not quite done before we get a chance to finally improve. It's going to be some time before everything gets a chance to finally go away. Now, highs going into tomorrow, you can see we are making it back to that 40-degree mark right there, upper 30s, still after a little bit of cloud cover and fog to start the day. We also get rain tonight, enough rain tonight, by the way, that you're going to see a few more showers into the day tomorrow. Now, whether or not it lasts in areas south of 94, that's the part we're going to have to watch very closely because it really does have a chance to really rip through tonight and then improve in areas south of 94 going into tomorrow. Troy, for example, the high near 40 degrees. Again, a lot of upper 30s there. Not much wiggle room for you. Brighton right around 39, but especially at the warmer mark as you get into the very start of the day. Going up further to the north, St. Clair, Lapeer, Sanilac counties, all in the upper 30s near 40 degrees. St. Clair itself right around that upper 30s mark and a high right around 1 o'clock in the afternoon, close to about 40 degrees. And that's going to be a key factor as we move our way forward. Now, on the next weather futurecast, that's what you see right here. Showers pushing their way all the way up to the north. The heaviest right smack dab in the middle of the night. Watch for that to really be something we have to keep an eye on going into the rest of those overnight hours. Now, there's the rain right there in the middle. See how it just kind of settles its way over areas north of 94, but notice most of that green is, again, it's north of that corridor, not much down in Lenawee and Monroe counties. So while you've got fog still for tomorrow, don't expect a whole lot in the way of rain south of there during the day tomorrow. It's going to be a lot further to the north. By Saturday, everything's drying out. We're left with a little more fog, and it's because we're warm. Now, on Sunday morning, yeah, we get a little bit of a break. Watch for a flurry or even a light snow shower at the very start of the day. And then it's all about the next 7 here, making our way into those upper 30s for the start of next week with that main other stumble going into the start of it on Monday.